Lordship, with your permission, Your Lordship.
Just a moment. Just a moment. The specific question whether the misconduct proved against the petitioner is grave misconduct which would justify the infliction of a penalty after retirement in terms of Rule 214 of the KCSR has not been considered by the government in the order. In the result, petitioner is allowed, the order of the tribunal is set aside, order impugned the application, that is the order dated 23/4/2018, shall also stand set aside. However, the first respondent shall take an informed decision on the question whether the charges number 1 and 4, which are found to be proved as against the petitioner, would amount to a grave misconduct so as to justify imposition of the penalty or recovery from pensionary benefits as against the petitioner in terms of Rule 214 of the KCSR. All admitted retirement benefits shall be released to the petitioner forthwith. Orders as directed shall be passed by the first respondent within a period of 2 months from date of receipt of a copy of this judgment. If the orders are not passed within the time frame as provided above, the entire withheld benefits shall be released to the petitioner within a period of 1 month thereafter. Yes.
Your Lordship.
Memo for posting for RFA, Your Lordship. Suit for partition has been partly decreed. The item number 2, which is considered against this appellant herein, has been the respondents have already created third-party rights and Kata transfer is for tomorrow. If Your Lordship please post it tomorrow, hearing on IA, Your Lordship.
Yes.
Permission, Lordship. Matter for hearing on IA. Your Lordship has passed to post a respondent in a particular place. After posting, she gave a complaint that she has been cheated. So 7 to 8 lakhs, in which she has given bribe to the government for the posting itself. And the criminal case is also registered. That consideration, she cannot be continued in that post. Only for IA hearing on IA tomorrow.
My Lords, one respectful submission, my Lords. Suit for partition has been dismissed and our counterclaim has been allowed. And both the suits have been clubbed here. Both the appeals have been clubbed here. The respondent that we are representing is suffering from cancer and due to the stay order of this Honorable Court, we are not able to cultivate. We have filed an application for vacation of stay. It may kindly be considered, Your Ladyship.
Next week.
2 more memos, Your Ladyship. Both of them are connected. This is with respect to a writ petition challenging an order of case 80. The next round of counseling is on 27th. So I kindly request for tomorrow. Doctors, with respect to the doctors' counseling session. I'm so grateful.
21. Fresh matter. Transfer matter. Request. Yeah, tomorrow. Fresh matter. What's the matter?
If I may please, Your Lords. It's an RFA, Your Lords. It came up before Your Lords upon hearing on 15/7. The respondent have filed an application to vacate the stay. The stay was still persisting, staying the further public auction of the suit scheduled property. And it has been posted for hearing on 12/8. So since there was no explicit extending of the stay order, they have moved application in the trial court to confirm the sale application. So I'm requesting Your Lords to post it at 2:30 today. The stay is there. The stay order was granted, but it was not extended explicitly.
Can you not wait till tomorrow?
Your Lords?
Can you not wait till tomorrow?
Yes, Your Lords.
Yes.
Tomorrow.
My Lords, it's a fresh review petition. Judgment passed by this Honorable Court in WP 10/6/30/54. Requesting listing of this matter tomorrow.
What is the urgency?
It's with respect to 371J. It's a transfer arising out of 371J. The contentions recorded is not with regard to the case, facts of the case. That's the only.
District, not tomorrow. Not tomorrow.
My Lords, on fresh matter, my Lords, regarding childcare leave, we are challenging that. Fresh matter, we have filed on regarding the challenging the childcare leave of the order of the Central Administrative Tribunal. And we have filed in April, and the matter is not listed. So kindly filing memo, my Lords.
Yes.
Kindly.
You are for the officer concerned?
My lords.
Are you for the officer concerned?
Yes, my lords.
Employee,
Because of Nimans, yes, my lords.
it has been rejected,
Child, yes, my lords. So we are
has
challenging.
been rejected.
Yes, my lords. So,
RFA, first 2021 admission notice was ordered. For the respondent may be posted for admission any date in this week.
My lordship memo for posting, this is regarding the writ petition challenging the case at decision. The thing is like, I'm for
Challenging what?
case at decision, madam.
Hmm.
The thing is like, I'm for the petitioner.
Hmm.
There is a departmental inquiry that was concluded, and there's a second department inquiry for the same cause that has been initiated by the Lokayukta. And tomorrow we have an hearing, my lordship. The Lokayukta.
Not tomorrow, list it.
My lords,
Much obliged.
my lords, this is a transfer matter, my lords, where the we have challenged the order dated 15/3/2024. We have filed a IA for dispensation. The file is not getting moved in the scrutiny ban, so kindly. I have moved the memo in the last week, but the date was given. The matter has not been listed. I'm moving it for the second time. Much obliged.
Page 1, number 25. Page 2, number 59. Page 3, number 10 to 14. Page 4, 15 to 17. Page 5, 18 and 19. Page 6, number 20 to 25.
Number 22, madam. Praying for short accommodation, madam, for appellant.
Item
app-
number?
22.
Yes.
Obliged.
Page 7, number 34.
26, madam. CL number 26. Short accommodation.
For appellant.
Yes, madam. Obliged.
2 weeks.
Page 8, 35. Page 9, 43 to 48.
My lord, serial number 43, my lords, for the appellant, my lords. I pray for a short accommodation, my lords. 2 weeks may be granted, my lords.
Yes.
43. Deeply obliged, my lords.
Page 10, 49 to 61.
My lord, CL number 49, I am for appellant.
Before the
Short accommodation, my lords.
Your lordship, I request that a date be fixed in this
Date may
week.
be fixed.
Yes.
Any date after second, my lord.
This week, your lordship, I.
No,
there
this
is
week
some
I'll not.
urgency.
After second.
Serial number 52, my lords. Posted before, my lords.
Yes, yes.
CL number 49, I'll not be there till first, my lords. It may be taken out second. Ah,
It's appeal for the appellant, my lord. It's a plaintiff's appeal against a
On the
portion
rate
of
of
the decree.
interest.
Yes, my lord.
On the rate of interest.
Yes, on the rate of interest. A
You've
suit
been
for
granted
recovery-
how much?
12% we've been granted, my lord, but in the peculiar facts of this case, yes, it was advanced as a loan, my lord, in the year 2010 itself. And the defendant sets up a dishonest plea that it was given towards a business transaction. To substantiate that, voluminous evidence is produced. And then it's a second round of litigation. My suit is initially decreed, then they file an RFA, it is set aside. In the second round of decree also, it is, the second round of litigation also, it is decreed, my lord. And the defendants have also filed an appeal. So we had moved both of them together. So while appreciating that appeal, if this can also be clubbed and heard together, my lord. So while dismissing their appeal, the court can enhance the interest.
Still on.
Yes.
Still on. Give the another appeal number.
Yes, the other appeal is 724 of 2021. 724. If both can be had next week, anytime this week or next week, if both can.
On behalf of the respondent, one in this case.
this appeal is by the, my lord, the appellants were, they were not party to the proceedings before the trial court.
You are not a party to the compromise.
Yes, at the first instance, my lord, the first respondent 1 and 2 hearing, they are the plaintiffs. They filed suit for the relief of,
How the appeal is maintainable?
my lord, the
Then
the-
file a suit.
No, no, my lord, the regarding maintainability, my lord,
Is Lok Adalat decree, then you have to
yes,
file a
my
writ
lord,
petition.
appeal, kindly have this matter, my lord. Tomorrow, my lord, I will get the judgments, my lord.
The compromise decree by Lok Adalat.
Yes, my lord. It
Remedy
is
to file a writ
maintainable
petition.
in view of the, my lord, the law laid down by the apex court as well as this honorable court, my lord. At the very first day of, my lord, the hearing, maintainability, my lord, it was argued and have placed the two judgment of the apex court. I think it is in the,
Which is the judgment you rely on?
my lord, presently I don't have, my lord, I will furnish, my lord. I have this matter at 2:30 or tomorrow I will get those
Lordship,
judgments.
for the respondent one, I'm not receiving copy of the appeal memo any lordship. Respondent.
The Keveter,
Respondent one, the lordship. Sir, I'm filing wakalatami of the respondent one, not receiving copy any of the appeal memo on the IAS.
For itself, my lord, I will
furnish the copy.
please.
Yes, furnish copy this next week.
Kindly fix some date, my lord, since
Next week.
please. Appellant in this matter.
Is this compromised?
There was a compromise. my lord.
There is no
was a-
compromise. There was no compromise.
May I request your lordship to kindly take ink page 75. To say that there was no compromise is to go beyond the records of this case. The matter was settled before Lok Adalat and payments have been made in pursuance of that order, which have been encashed by them. They have even withdrawn the 30 lakhs which was deposited in pursuance of the order passed in Lok Adalat. The relevant page would be, first page would be 67, my lord. May I request your lordship to take page number 67. Paragraph number 3. It is agreed by the complainant that he will withdraw the suits in OS number 1131 of 2014. That is the subject matter, the judgment of which before your lordships, pending before court hall number 8, and there are other cases also. Paragraph number 4, my lord. Complainant to return all the original title deeds in respect of house property bearing number 51, situated so-and-so Baswangudi, Bangalore 4, to the accused Sri Anshumanan D. Shah. He is the appellant before your lordships and the defendant in the court below. But the contentions of the other side is that there was no compromise, which is totally incorrect, because if your lordships goes through the other pages which I have produced, the certified copies before this honorable court, from ink page 75, what was agreed to be paid was not paid within the agreed time. Therefore, applications were filed, criminal petitions were filed before this honorable court, permission was taken, subsequently deposited and withdrawn by the respondent hearing. And there is a finding by the trial court that the agreement of sale upon which the respondent filed the suit was not a sale, was not for any real transaction. It was only a loan transaction and the money was supposed to be returned. Your lordship will get it at issue number 3, page number 21. The finding on issue number 3, page number 34, madam. Paragraph number 21. May I read it, ma'am?
Yes.
It is not in dispute that the sale agreement marked as at Exhibit P1 came to be executed in the year 2008 and the suit was filed in 2014, and thereby the defendant took the contention that the suit of the plaintiff is barred by limitation. While answering issue number 1, this court has come to the conclusion that it was not the intention of the plaintiff to get the sale deed in his favor on the strength of sale agreement. The manner in which he prosecuted the matter gives strong inference that the transaction which taken place between them was a loan transaction. Further, the plaintiff also initiated proceedings against the defendant herein under Section 138 of NI Act, and those cases were settled before the Lok Adalat, and thereby the plaintiff consented to withdraw this suit. The terms of the compromise is clearly forthcoming in the order sheet, marked at Exhibit T1 to D4. Added to that, the plaintiff in his cross-examination dated 14/11/2017 had clearly admitted that those proceedings were ending in compromise in Lok Adalat, dated 4/12/2014. Further admitted that at the time of settlement before the Lok Adalat, he agreed to withdraw the present suit. But for the reasons stated above, those compromise was not materialized, and therefore plaintiff herein further prosecuted those matters. But this is an incorrect thing, because it is available on record that the matter after being settled in Lok Adalat, payments have been made. I have stated in my appeal memo the payments which have been made to the present respondents. May I request your lordships to take in page 14.
What was the settlement?
The settlement, my lord, it was a loan transaction. I and the plaintiff.
What was the settlement?
Sub-settlement.
Terms
Please,
of
ma'am.
the
The
settlement.
terms of settlement is at ink page. It starts from ink page 66, my lord. It is called out. The compromise is like this, my lord.
Where is the compromise petition?
Compromise ಇಲ್ಲ ಲೋಕ ಅದಾಲತ್ತಲ್ಲಿ record ಮಾಡಿ, it has been called out in the order sheet itself. In the concerned check bounce case 12742/2014, sorry. ಲೋಕ ಅದಾಲತ್ತಲ್ಲಿ there were three parties. One more person named Govindacharlu was there in between them. The plaintiff and the defendant, that is the appellant and respondent and the appellant before your lordships are good friends. They used to indulge in lot of transactions. They used to take money and give it on interest and everything. So
Some agreed was for compromise. Total sum agreed for the compromise was how much?
the total sum agreed
50
was,
lakhs and few immovable properties.
it is at ink page 66, my lord. They have got settled the matters for a total sum consideration of 50 lakhs.
Hmm.
Payable by the accused Sri P.V. Govindacharlu to the complainant towards the claim under checks in dispute. In all the cases referred above in 3 installments of 15 lakhs, 25 lakhs and 10 lakhs.
The accused PV
Govindacharlu.
has agreed and undertaken to execute a
Please,
registered
ma'am.
absolute sale deed in favor of the complainant or his nominees.
That
for
is the
any
interest
person
of other lands.
him, and convey the title with the possession of agricultural lands bearing survey number so and so so and so.
Yes, my lord.
Has that been done?
No,
That is other lands, not our land. It is not concerned with us. It is not concerned with us at all. Insofar as the present appellant is concerned, I have made payments of 50 lakhs to the respondent. And there is a incorrect finding by the trial court that the compromise did not fructify, is my humble submission. Because insofar as I am concerned, it is fructified, which is as per the compromise at ink page 67, paragraph 3 and 4, he has to return my title deeds also. My lord, kindly see the suit for
Just a-
specific
just a
performance is
second.
dismissed.
Just a second. You are not Govindrajulu.
You're
No.
not going right.
Obligation to pay rupees 50 lakhs is on Govindrajulu. Why did you pay amount? Where is
Lord,
your obligation?
as per the settlement,
Now, where is your obligation?
my obligation arises out of paragraph 4, paragraph 3 and 4. He has agreed that, my lord, that's what my submission is. It has come in the evidence as well. There is a,
He means who?
pardon?
He, in paragraph number 2, he means who?
He, that is the respondent hearing, the plaintiff in the case. That is the plaintiff in this case, that is Bharat Chandra. Dr. Bharat Chandra is he in this case.
No, it's, if you look at paragraph number 1,
Yes,
the
my lord.
reference is made to Govindrajulu.
Yes, my lord.
Then second paragraph, it starts with the word he.
Yes, even in the third paragraph, no, it is agreed by the complainant. Complainant is Bharat Chandra. That is the plaintiff in the trial court now. It is agreed by the complainant that he will withdraw the suits. But it is just a question of being money transactions. Whenever there is some problem, they will file a suit. They are all business friends. The trial court has clearly come to a conclusion that there was no transaction to sell the property. The suit for specific performance is dismissed. Suit for damages is dismissed. The court has gone to the conclusion that what 38 lakhs I have received. Kindly see in this case, my lord.
Just a second. Are you a party to this criminal proceeding?
I am not a party in that proceedings. I am not a party in those proceedings.
You undertook to withdraw this suit?
there is a passing reference to this suit. This suit bears OS number 1131 of 2014.
No, 1131.
1131 to 14.
1131, 1131 of 2014. There is a passing reference to this suit in the award passed by Lok Adalat. But Lok Adalat could not have taken cognizance of this case. Please see section 20 of
Seconds. In the compromise petition or memo which was filed before the criminal court, did you give an undertaking that you are going to withdraw the suit?
there is a passing reference to OS.
Where is the joint memo?
Yes, there is a joint there is a mention of this suit.
In the joint memo, you agreed to withdraw this suit?
Yes.
Then
Memos
please-
accepted, cases are
please.
disposed of accordingly. Bail bonds of the accused person shall stand. Both parties have filed
But
joint.
on that account, this award is not an award in the OS 1131 of 2014. Please see section 20 of Lok Adalat.
So having undertaken to withdraw this suit, how can you prosecute this suit? That is the question.
It is not an award.
No, sir, you have undertaken to withdraw this suit. Why?
On fulfillment of this compromise memo, I undertook to withdraw the suit. There is no fulfillment of this compromise
What are the
petition.
terms and conditions? One is you are supposed to receive is 50 lakhs.
Yes.
That is received.
And
Just second, that is received.
yes, and immobile properties
Immobile property has to be transferred by
transferred by
Govindrajulu.
Govindarajulu.
He has not done it.
He has not done it.
Property belongs to whom? Govindrajulu.
Property belongs to third parties. Govindarajulu has to arrange sale of properties. And Govindarajulu has to pay a sale consideration, not me. Section 20, the requirement of Section 20 of Legal Service Authorities Act comes in the way of this honorable court accepting this as an award. Please see Section 20. There are two requirements under Section 20. One is the civil court has to form a satisfaction that it is a fit case for settlement. And then Lok Adalat has to take cognizance of the case. Lok Adalat did not take cognizance of this case. Please see last page.
What was the role of the appellant in the present compromise?
He was just present there. Now, this decree is based on the admission made by the defendant. He cannot go against his own admission.
Where is Govindrajulu now?
He is absconding. He is not available.
So property doesn't stand in the name of Govindrajulu.
Property doesn't stand, they don't stand in the name of
It stand in the
Govindarajulu.
name of the appellant?
He has a house property.
No.
That is the subject matter of this suit.
There are 6 survey numbers, 6 properties.
No, they don't belong to this appellant. They belong to some third parties whose names have not been disclosed.
House property bearing number 51, First Main Tata Farm. Is that belonging to you?
Yes,
Belongs to him.
The
That belongs
Yes.
to him. That is the subject matter of this suit.
that is also subject matter of the
You
compromise.
returned the original title deeds of that property.
On that property, I filed suit for specific performance. Specific performance has been rejected and a money decree has been passed.
But the money decree is passed.
Who is not claiming special, is only claiming.
Please, note, money decree has been passed on the premise that no payments have been made. But as I have called out at page 14,
No, you are not made payment.
He has not made payment.
Govindrajulu has made payment.
no, but I have made the payments.
How do you say that?
I have produced but the extract.
Obligation, just a second, obligation under the order passed by the criminal court is that Govindrajulu should make payment.
Please, note, but I have made the payments. I have called,
Hey,
I have
why do you
paid
take-
50 lakhs to him.
What is responsibility?
My lord, the understanding, as I submitted before your lordships, they are all friends since a long time. They are giving loans, taking loans to third parties, taking documents.
All that
It's a fit case
all
for
that has
admission,
been
my lord.
denied.
It's a fit case for admission and I cannot be made to pay him again and again.
Let me call for records.
I oppose admission on this count. After 1976 and 2000 amendment, admission is not a matter of right of the appellant. He has to earn it. Now, please see section.
Based on the submission made now, he has earned it.
Who has
Admit.
made,
Now, this is,
who has
this,
paid who has, the DDs have been paid?
Yes,
You have drawn the DDs?
yes. All the DDs are drawn by me.
please see para 14, 15, 16.
Admit, sir, admit.
But the interim order, I have filed an application for
oppose- I
stay of the
oppose-
judgment and
I
decree.
oppose-
They have
I
filed an
oppose interim
execution.
order.
They have taken undertaking.
Please see.
And most, I didn't want to submit this. They have filed objections. The cause list shows that they have filed objections to my applications. I have not been served with the objections at all. I don't know how it is
Do
possible.
you admit the fact that the demand drafts have been bought by him?
No, it was paid on behalf of Govindarajulu.
Not on behalf.
Who drew demand draft? I do
Who
not.
purchased demand draft? Who
I
pur-
do not know.
you
I
don't-
do not.
He makes a statement that he has purchased.
I do not know.
Yes,
I do not know.
It is submitted by the learned counsel for the appellant that the rupees 50 lakhs, which was agreed to be paid as per the settlement arrived at in CC number
12742 of 14.
14 is paid by the appellant and the appellant has purchased the demand draft. Learned counsel for the respondent submits that he has no information as to who has purchased the demand draft. Under these circumstances, operation of the impugned judgment and decree is stayed.
Please impose condition.
No, he says that he has purchased the demand draft. We have no information. Prima facie, it appears that he has paid the entire amount.
I'll get information, please, but please,
Another thing,
please.
one more thing. You are given an undertaking that you are not going to prosecute the suit. You have prosecuted the suit. This is not a case to post
I'll
any
get the
conditions.
information. Please reserve my liberty to file an application.
Move the application.
Please make an order. I would request this honorable court.
At this juncture, learned counsel for the respondent submits that he will secure necessary information as to who obtained the demand draft for rupees 15 lakhs, which is said to have been purchased by the appellant. Yeah. Respondent is permitted to move the application for modification of the order, if so advised.
Very well.
I was to revert on a compromise petition on this date, your lordships. However, my instructions are that there's been a death in the family and therefore we request about 2 weeks of time.
May I make a submission, your lordship? The matter involved in this is this, your lordship.
Rectification of the partition.
Yeah, rectification. All are benefited by extent of land discovered. We are partition the less, we are partition more. Because the joint development agreement is entered and the developer, he is changing the nature of the suit. Therefore, I made an application. At least until your lordship hears and matter, that may be stayed, your lordship. Otherwise, if he changes the nature of the property.
My lord,
Because unless there is a partition by meets and bounds, your lordship will kindly see.
No, you are the respondent.
I am the first respondent plaintiff, your lordship.
I am 23rd respondent,
your
the developer, my lord.
Second, decrease in your favor.
Yes, your lordship.
So you want it to be stayed.
No, I don't want to be stayed. This is
My lord, my construction has nothing to do with this portion, my lord.
There is already a stay in favor of the appellant. What I have made an applicant or 39, 1 and 2, restrain the respondent number 23 from changing the nature of the property, your lordship. Otherwise, if he changes the nature of the property.
He has entered into the.
My lord, my construction is.
When you have entered into joint development agreement.
Pardon, my lord.
When you have entered into joint development agreement.
2011, my lord, 2016 he has filed a suit. Residential portion has been completed and commercial construction is in progress. And he has specifically in cross-examination said he has no claim over this land. How we can prevent my construction, my lord? The property that has been given to me has nothing to do with his right. In fact, if this rectification is accepted, the owner of the property was made available for joint development by me gets increased. It does not get decreased. And the portion which he got under partition, which he wanted to rectify, is far up from my property.
So your vendor will get a larger number of shares or higher number of shares. Whatever.
Yes, why my construction should be stayed?
He will also get a.
No, I will not get any excess.
Just a second.
Because Lord, earlier partition was by meets and bounds.
Just a second, sir. He may also get some additional share, right? So in case if you develop the property, you can't claim equity.
No, he is not a party to my development.
Sir,
He is not a party to my development.
rectification takes place.
Rectification, my lord.
Allow me to complete. Allow us to complete. If the rectification takes place, he may also get some additional share.
If he gets, my lord,
If he gets, that's what I said.
If he gets.
In such an event, you should not claim any equity.
Yes, if he gets. My lord, for a minute, my lord, I just would like to point out where my portion comes from.
Understood your case, sir. We have understood your case.
My lord, what has happened?
For the respondent.
My lord, it is like this, my lord. 3 acre 15 guntas was the land that was available in this survey number. 1 acre 17 guntas came to be acquired by BDA. So what was left was 137 guntas. Instead of that, they made partition for 138 guntas. Out of which my vendor, that is in my partner in for the sake of this thing, the owner who made available got 28 guntas, which was by meets and bounds. Along with that, other lands which I owned, which other owners, they had given their land, my lord, entire property was, my lord, clubbed together and assigned a single number. With that, my lord, my development is in progress. Now, his case for rectification is that later in the year 2016, he came to know out of 1 acre 17 guntas that was acquired by BDA,
Entire land is not utilized.
BDA had not acquired entire, there was available another 19 guntas.
Correct.
So all that he could have done was seek partition in that 19 guntas, not rectify this. And therefore, my lord, during cross-examination, my specific question to him was, have you got any objection as for this property which is under my development? He has said he has no objection. Then how he can prevent my construction, my lord?
My
My
submission to
properties, my lord, with other property is amalgamated.
particular extent we are partitioned. We are all the family members. Rectification is the
Any
only-
portion in these 19 guntas is with you?
No.
No,
No.
no.
Then,
Then why?
just a second.
Yes.
Your lordship will kindly see, if 19 guntas is allotted by meets and bounds to all, if you by the, suppose some extent comes to my land, some extent goes to others who are not entered into a joint development, their property rights will be affected because if you change the nature of the property.
No, sir. What he says is,
Yes,
now 19 guntas is excess, which is not partitioned because
Yes.
the BDA did not acquire the land.
yes, your lord.
So you can claim partition in respect of those 19 guntas.
Yes, in fact, that
And
is
just
why.
just a second. He has not taken any share in those 19 guntas.
Yes.
My lord,
He has,
it is not
just a
so.
second, he has purchased the property from the vendor who has been allotted in some other serial number and has developed the property.
Your lordship will kindly say,
Is in appeal before.
say only one of the owner is in appeal, your lordship, before lordship. Therefore, your lordship will kindly say, there are several legal representatives of a particular person. All of them are not before your lordship as appellant, only one.
So the question is,
Yes, your lordship.
he has not claimed any portion of the land in Suriname, in 19 guntas of land, which
My lord,
is not acquired by BDA. One aspect.
That will be made clear when we partition that 19 guntas by meets and bounds. Until that time, it will not be.
So in those
there
19
are-
guntas,
there are
just a second, in those 19 guntas, he has not put up any structure. He's
Your
not,
lordship, we do not know which is that 19 guntas.
he makes a
No.
statement.
It
By
is-
meets
your
and
lordship-
bounds, that
Your
was
lordship
done.
will kindly see if he happens to know which is that
19 years,
guntas,
my lord.
we would have partitioned that also. We did not
No,
partition.
we will record a statement that
Yes, sir.
he will not put up any structure in 19 guntas, which is the subject matter of the present appeal.
Yes.
Is that fine?
Now he has applied for.
19 guntas, which is given up by BDA,
Okay, all
in
right.
that I will not claim anything.
What is that sorry number?
Now he has applied.
38/3 only,
38 bar?
3.
Now he has applied for.
My lord,
In
it is
respect
not
of
quoted.
19 guntas, I will not claim any
The
share.
learned counsel appearing for the plaintiff respondent as well as defendant.
23, my lord. The
Defendant-
developer, it may
defendant-
kindly be clarified.
Who is the developer? Full stop. It is brought to the notice of this court that initially the Bengaluru Development Authority had acquired survey number 38/3.
1 acre 17 guntas.
1 acre 17 guntas, full stop. Later,
It was found that only
later BDA has given up its claim in respect of
19
guntas of
guntas.
land. By that time, the parties had already partitioned the properties. Hence, a suit is filed for rectification of the partition deed, full stop. Learned counsel for the plaintiff respondent would contend that the joint developer, that is defendant number 23, is developing and changing the nature of the property, full stop. Thus, he seeks restraint order. Learned counsel appearing for defendant number 23 submits that the developer is not putting up any structure
Lord,
or
only my
developing
before your lordship,
19
sir,
guntas of
your
land in
lordship
survey number
dictate,
38/3, which is given up by the Bengaluru
BDA.
Development Authority.
that 19 guntas is
Submission
not
is-
in one particular place.
Submission is placed on record. Full stop. Since the joint developer has made a statement that he is not putting up any structure in survey number 38/3 measuring 19 guntas given up by BDA.
Yes.
This court is of the view that there is no need to pass any restraint order against the
Hello.
joint developer.
May I make a summary, that we do not know in that 38/3 that 19 guntas where it comes. That is the position.
I can also add one more statement. In the cross-examination, you have admitted that you have no claim over 19 guntas.
Yes.
My lord,
This 28 gunta, what I have
but
got
the
on
facts
that.
remains
yes,
your
I have no
lordship,
objection.
38/3, 19 guntas is not partition. Others have not accepted.
Those 19 guntas will be partitioned, as simple as this.
Yes, your lord, but
And
the
he won't
question-
put up any structure in those 19 guntas.
now it is only he has applied for PODI, unless PODI is done. Where is that 19 guntas comes, we do not know, and he also do not know.
The 19 guntas given up by BDA.
BDA.
Yes,
Remaining portion is acquired by BDA.
Yes.
As simple as this.
The entire property is one contiguous whole.
yes, your lordship will kindly, PODI is not done. as a result, your lordship will kindly say, two survey numbers are partitioned.
We'll also say that in case if you put up any structure,
In 19 guntas, madam.
you are
What
not
is the
enti-
subject matter of my
Right.
JD?
you are not entitled to claim any special equity.
Yes,
In case, in case if it is found
yes,
that the structure is put up in the 19 guntas of
Yes,
disputed
ma'am.
land.
Yes.
The developer shall not claim any.
yes,
special
madam.
equity.
Yes, yes. Highly obliged.
May it please, your lordship.
For the appellant, the first case, my name is not shown, but I am appealing. I will let her start, we are sailing together. She as a claimant, defendant, who has also asked for the partition, which as plaintiff,
There was one suit for partition.
One suit for partition, plaintiff suit is dismissed. And the
On the
application,
ground that there was an earlier partition.
no,
7 rule 11
Rejection.
application has been filed. At that stage itself,
Yes.
I represent the counsel who was representing for D1 and D2 before the trial court.
Hmm.
Plaintiff and D1 and D2 are in a way colluding with each other. D1 and D2 had also made a counterclaim. So incidentally, when the suit is rejected, the plaintiff is rejected, our counterclaim also got rejected. That's why we are before your lordships. Two appeals independently filed by plaintiff as well by defendants.
we are catching the same.
90 days.
I just pass on a short synopsis, my lords. In one appeal, there is delay, my lords, let me be honest with the court. But anyhow, because both are rises out of same appeal, I mean, same this one, I don't think they would have any objection to it. May I just proceed, ma'am?
There's an unregistered partition between the father and sons. Plaintiff is a daughter, 1 and 2 are also.
10, 11, 9.
This page. Page 33. Page 33. 33. Paper book, page for 33, page 33 of the paper book, 2. Paper book 1 is here, paper book 2. Paper book 2. Plain policy. Page 33 there. ಏನು medical free ಇರೋದಿಲ್ಲ.
Objections are last time. Last time.
You are one of the daughters.
Please, my lords. 1 and 2, both are daughters.
3 daughters, as a matter of fact.
Please,
Plaintiff
Lords.
is also. a
That's where,
daughter.
my lords, if your lordships
1
are
and
to
2 are
see,
also daughters.
please, my lords, if your lordships are to see 33, page 33 of the paper book 2 that we have given, book 2 is there.
Just a minute.
Your lordship will get the genealogical tree. Plaint, it's in the plaint itself, it's there.
Even page 33.
You can choose the court fees.
Second appeal, court fee is not paid.
Second, you have filed, no?
297.
297, you have not filed the court fee? We have paid, I think, we have paid. If it is, just check, otherwise we will have it paid, absolutely no issue.
Yes, there is delay also.
In the trial court, we had not paid, but here we have paid together. Yes. Trial
Please.
court, we had not paid.
Yes,
Here we have
please-
paid
Please
double.
check and
Yes, please.
verify
Lords.
those office objections.
We have filed, that's what the objection is. In the trial court, we had not filed. But here, in the appeal, it's, if it is FDP, my lords, your lordships are aware that we can pay at any time. So here we paid. In fact, we had paid double. We had paid double.
Yes.
If your lordship, please, my lords, may I just submit, my lords, make my submissions, my lords.
Delay application. In which appeal there is delay?
Second, 297 of 20.
6.1. Application is also not filed for condonation.
Application is
Lord,
We
the
have filed
affidavit
the-
is not served on me. There's only an application. Affidavit is not served on me.
It's there. It's filed, my lords. It's, the seal is also there. Affidavit is there. 184, 187 to 193.
Minute is
78 days delay, we have filed, my lords. Brother. Manmohan, sir. Copy. 187 to 193.
Copy of the affidavit also has to be served.
Yes, no, affidavit is not served on me. Application is served.
Please serve a copy of the affidavit. We see whether the court fee has been paid. We'll list it. Day after tomorrow.
Please.
Show the name of the
24.
counsel appearing for the appeal.
Lord, I undertake to file wakalat in the second matter for not 3 respondents. I'll file it. Please.
Day after tomorrow.
Sorry for the inconvenience, we couldn't.
Please.
Else we have to look into even these things also. Extremely sorry. We could have avoided this 5 minutes of.
Lord, here for the appellant, Lord, the other side, my lord, has given a proposal for settlement. And my lord, I have already communicated to my client and he is also willing to sit and negotiate.
We'll try to settle. We'll try.
some date maybe.
When do you want?
After 4 weeks, my lord.
After 4 weeks.
Interim order may be extended. Interim order. Interim order.
But I pay for appellant in this case.
One humble submission, Lord.
The suit for
I pay for time 2 days, Lord. 2 days.
amendment has not been carried out.
3, 25th, Lord. 25th,
This has been posted today for, with the understanding to dispose the matter.
25th. Please. Interim order, interim order.
Rejection of plaint, my lord.
This was listed last week,
Yes, my lord. It was listed last week,
10:15.
section 15, my lord.
Yes, yes.
Swaswa.
Much.
I'm appealing for the appellant. But it's a plaintiff appeal. My suit is for partition. And
Any chance of settlement?
Lord.
Any chance of settlement, dispute in the family?
earlier, my lord, it was
We are
referred
open,
for-
Lord. There was an attempt made before the.
My lord, they
trial court.
wanted to extend charity to me, though I am legally entitled. They want to give something to, it is not in accordance with law. That was the offer they made.
Can it be referred to mediation?
Lord, as I said, Lord, we are ready. One chance, one effort was made. It did not go through. Once more, we are ready.
Mediation.
Please, madam. We are- But my request be properly considered, my, they don't waste the time of the honorable court. Earlier, similar thing was happened.
ಅಲ್ಲ ವೇಸ್ಟ್ ಅಂತ ಅವ್ರಿಗೆ ಅನ್ಸುತ್ತೆ ನನ್ಗನ್ಸಲ್ಲ.
ಅಲ್ಲ ನಿಮ್ಗೆ ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಕೊಟ್ಬಿಡ್ತೀವಿ.
He may think it is a waste. It does not appear to me as many times mediation efforts are made.
Decent manner if they want.
If he is not convinced, we can go ahead with the case.
Where are the parties from?
Parties, my lord.
Bangalore, Lord. Both are here.
My problem is, he has no means to survive for a 2-day meal, my lord. He is living in such a poverty.
Lord, that's not
The
true,
worth of
Lord.
property is more
He
than
has
10
made
crores.
that submission on every occasion. Lord, that
Property is
submission has
more
been
than 10
rejected.
crores. All the
His
properties
IAS
are in
have
the
been
custody of the
rejected.
elder.
MFA he filed, that has been disposed of.
I have order of the honorable court, kindly, again, I make this very same contention, but to kindly see the order possible. There is no finding.
Yes.
After going through the records, this could be the view that the party should explore the possibility of settlement through mediation. Both the learned counsel for the appellant and respondent have agreed to
Date may kindly
the
fix.
possibility. This matter before mediation center on
Any Saturday.
Saturday, my lord. Please, sir.
27?
Please,
at 11 o'clock.
please. Much
11 o'clock. Karnataka mediation center.
Great.
Parties present.
Not agree. Arbitration clause in the partnership deed, there was an interim arrangement between the partners. I filed section 8. The trial court says that no, the dispute arises out of the subsequent agreement. I am on the earlier agreement.
Yes.
Please present, my lord. Lordship asked me to keep my party present.
He understands English? Yes. See, there are some advantages if you go through the arbitration process. There is a mandate under the law that the arbitration proceeding is to be concluded within 1 year. And again, challenge under section 34 and section 37 will be only on limited ground. And is it possible for you to say that we are agreeing for arbitration? And as you suggested, it can be in Mysore also. We are told that both of you are from Mysore.
We stay here in Bangalore.
Sorry?
We stay here in Bangalore.
Bangalore. If both of you agree, it can be on an in a place which is convenient to both of you.
agreeable to Mysore. Mysore,
Bangalore, Mysore,
Nice.
file a memo, my lord, joint memo,
joint memo,
day after tomorrow.
Joint memo, no?
2:30.
Our party, their party is not present.
You
No,
didn't
he's,
want consent.
his entire case is there is an arbitration clause. His signature may not be required.
That kind of day after tomorrow, my lord, I file a memo. Day after tomorrow.
Very well. Great. The appellant, your lordship. Lord, it's a defendant's appeal where my lord, the very approach of the plaintiff, but admitting the fact that the property, subject A property, schedule A property is a self-acquired property of the grandfather. Lord, in the presence of the father, my lord, they have filed a suit as if it is a property of lord where they are entitled for the share. But the whole theory with regard to my lord, the plaintiff.
Where is genealogy?
My lord, it is available at page number, my lord. 44.
43, 43.
Please.
Father is alive.
Father is alive. my lord. Instead of invoking the provisions of section 8, my lord, they claim that they are being the co-partners, they are entitled for the share.
To whom the property belonged, according to you?
Sugnanachari.
Sugnanachari.
Sugnanachari is the original, the owner of the property.
His self-acquired property.
It was his self-acquired
And he
property.
died?
He died, my lord, in the year, my lord, subsequent to the suit, my lord.
Subsequent to this suit.
Lord, he died, my lord, sorry. He died in the year 2017, my lord.
2017.
Please,
On his death, the property devolves on his wife, son,
please, my lord.
then
That's all, my lord. Now this plaintiffs, my lord,
is survived by how many people?
my lord, only son and wife.
Son and wife. Son is alive.
Son is alive,
The suit by grandson.
grandson. my lord. And even, my lord, I have taken, my lord, the second marriage, even my wife and daughter has not been made as parties.
What is Sagilwan, no?
I think they have entered appearance through KVET.
Admit call for records.
Lord, there is now execution filed, my lord. What had happened is, my lord, with regard to Schedule B property, which are jewels.
Operation of the impugned judgment and decrees state till next date.
Please.
Till further order.
And for respondent number 4 to 6 in this one.
Can I make a submission, my lord? Just now it was brought to my knowledge that the defendant number 1A is died on 16/7/2024. But it's also been brought to my knowledge that LRs 1A and 1B are the only legal heirs to that particular. So that I need to make certain meant to that particular aspect, Your Honor. Before commencing, it would be right on my part to bring it to the legal aspects before your lordship's knowledge.
Defend number 1 is respond number 1 here.
Yes, my lord.
1A, respond number 1, sorry.
Yes, my lord.
So 2 and 3 are the LRs.
Yes, my lord.
Is submitted by the learned counsel for the appellant that respond number 1 has expired on
16/7/2024.
16/7/2024, and it is further submitted that respondents number 2 and 3 are his legal representatives. Submission is placed on record, appellant to carry out necessary amendment in the cost title.
The other aspect, my lord, why the plaintiffs are before this honorable court is the court goes on a presumption that there is an earlier partition and a second round of partition suit is not maintainable. For this aspect, if your lordship is pleased to appreciate, the honorable court has culled out the earlier schedule of the partition, which was at ink page number 25 of the internal running page of the judgment, Your Honor. Ink page number 25, internal ink page number 25 of the running page of the judgment. G schedule property. May I read out this, but this is where the court has gone to a wrong presumption and dismissing the suit of the plaintiffs here. Because if the court had read this particular schedule as it exists, it would have been a different aspect. I'll just read out. Property allotted to the share of the parties of the second, third, seventh part the property measuring 1 acre, 7 guntas, new number 25, survey number 1, new number 25, corporation number 11, Vittal Nagar measuring 3 acres, 20 guntas, situated at so and so. The G schedule property at present measures 1 acre, 20 guntas, out of which 20 guntas consists of an alla and the rest measuring 200 by 200. The remaining 2 acre has been occupied by the slum dwellers. Our case was that at the time of this particular partition, this 2 acres was occupied by the slum dwellers. It was not available. Now that slum dwellers, we have all the family members jointly have evicted the slum dwellers. Based on that, we filed this particular suit schedule property for partitioning only that portion of 2 acres. If your lordship now appreciates my contention and takes the decree, which is the suit schedule property before the Honorable Court, Your Honor. Decree, if your lordship gets ink page number 69 of the paper book. Decree is available at ink page number 69. The schedule in the decree, Your Honor. All that piece and parcel of the property measuring old survey number 1, new survey number 25, corporation number 11, Vittal Nagara, 2 acres, out of 3 acres, 20 guntas. And here, western portion, if your lordship please to appreciate, we have just remaining portion of the property allotted to the share of so and so. That 1 acre, 20 guntas, including the Halla, was because the schedule of that 1 acre, 20 guntas and the Halla is in the internal next page running of the judgment copy, Your Honor. 26 schedules have been demarcated clearly.
Road for partition.
Yes,
in respect of the property which is in possession of some slum dwellers.
Yes, now it has been vacated. We all the family members jointly we have seen to that. The slum dwellers are vacated that particular portion. Now that we have just come before the Honorable Court, that 2 acres should be allotted to all the family members, not
And
one person.
Finding is it is allotted to whom?
The G schedule owner, that is the respondent number 2 and 3 here before your lordship here.
There is a registered partition way back in.
Yes,
the
I admit
2000
that.
No,
2000
partition is admitted.
Partition, it's my humble and respectful submission, my lords. Lordship, may kindly see the findings at paragraph number 25. My lords, there is a registered partition, my lords, in the year 2000. In terms of the registered partition, entire 3 acre 20 guntas has been allotted to the share of defendant number 1, 2 and 4. My lord, the plaintiffs before the trial court have got 2 properties to their share. They've already alienated, sold their properties. After selling the properties allotted to their share, my lord, now they are making false claim over the property exclusively allotted to the share of D1, D2 and D4. Therefore, my lord, Honorable Trial Court, considering the material on record and also considering the specific terms of the registered partition deed and taking note of the fact that they've already alienated their share of my lord's property, has categorically held that.
Come back to the description at page number 25.
Yes, ma'am.
See what is allotted to second, third and seventh party
Yes, madam.
is 3 acres 20 guntas. The further particulars of those 3 acres 20 guntas have been mentioned later.
No, my lord. It is, I've been clearly instructed that this was the family elders have made it. Maybe some discretionary, because the property identification of the property goes by its boundary mark and not by its extent or the measurement.
So there is
Now,
no-
if your
There is
lordship
no
is pleased to.
ambiguity, there is no ambiguity in the description. It says 3 acres 20 guntas is allotted to 3 persons. And out of 3 acre 20 guntas, what are the features there? That is mentioned there.
If your lordship, if your lordship.
In the partition deed, it is mentioned that
If your lordship-
2 acres should be divided amongst all the parties.
May I submit this way, my lord? If your lordship continuously running that particular description goes to the schedule, your lordship finds that east by unauthorized slum dwellers, west by remaining portion of the property, north by unauthorized. We'll have to identify the property by its boundary marks.
No, the reason is since the slum dwellers were occupying that property when the partition took place, the possession is not given to the parties to whom this property is allotted.
My
So that is how
instruction, my
it has been
instructions were
described.
that within the family members, that is why, except the person who is claiming all the others properties, even file a written statement, let the suit be decreed.
What is the extent of property allotted to your share in the partition?
That copy is not right now available with me, my lord.
Is the partition deed available?
I have the copy of the partition deed, exhibit P7, my lord, so I may be permitted to pass on the partition deed. The value allotted to their share is much more than the property allotted to the share of its value is specifically mentioned in the partition deed. It is much more than the value of the property allotted to them, allotted to us.
If you are given larger share, then how can you say that this property is not allotted?
If the continuity of the schedule is read out, Your Honor, not just passing ourselves to the above portion, definitely it gives a meaning. To my understanding, it gives a meaning that the property which the suit schedule property was not included in that particular schedule, my lord.
They could have shown the lesser extent then. Instead of making 3 acres, 20 guntas, they could have shown the lesser extent.
Party mentioned in Schedule G, the property mentioned in Schedule G here under shall go to the chair of the parties of the second, third and seventh party. That is so, 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 so.
Totally measures 3 acres, 20 guntas. Out of that,
Of the properties allotted to the shares transferred.
Notes in the registered partition deed, but the value of the properties is also mentioned. The value of the property allotted to their share is 4 lakh. The value of Schedule G property is 3 lakh
that was the
75,000.
reason why the other
Jointly
defendants are the
allotted to
family
two
members.
daughters.
Just tell us, what is the extent of land allotted to his share?
There are two minutes, one residential and commercial property.
All right, what is the extent?
Sorry. Note, it is measuring 108 feet into minutes 45 feet. Situated at Chamrajpet 1. Second, minutes the property is measurement is
Records.
108
But the
feet.
case will call for records.
Yes, ma'am.
Call for records.
Then I will be also in a better position to assist your lordship on that particular issue. I might be permitted to carry out that small amendment, which should not be another way.
Great.
Appealing for the appellant, Your Lordship, senior is experiencing a slight inconvenience. Can a short adjournment be given, Your Lordship?
Next week.
I am ready. Any date may be fixed.
Interim order may be extended.
Short question, this is the arbitration as well as commercial court has confirmed the arbitration award. Short question, because poor persons have given the land earlier, about 10 years back. So they have that was considered by the arbitral tribunal as well as the commercial court.
Listed on 29.
Yes.
The interim order shall remain in force till then.
Please, Your Much obliged.
For the appellant in this case, we had a discussion with my learned friend and the respondent. They have agreed for settlement. Please call this matter after 3 weeks. We'll report the settlement.
Which date?
Sorry.
3 weeks.
Submitted by the learned counsel appearing for the appellant. That
Kindly extend the interim order plan.
settlement is being negotiated between the parties and that the settlement will be finalized within 3 weeks. Just after 3 weeks.
Great.
Should be in effect.
I think more paper books will have to be filed. I have one request. There are a large number of records. Of course, I don't expect my learned friend to file all the records. But can the records be got from the trial court?
I have prepared, my lord, one set of all the documents which the arbitrators have referred to. Because otherwise, my lord, it will run into, my lord, halfway.
The records come because this is a case where our cases, there's no evidence. And therefore, we have to show your lordships to see what is there and what is not there, more important. So if the records can be called for, my lord, from the lower court.
So whether the matter can be remitted to the arbitrator without the consent?
No.
That part of the order can go.
Parties can consent, then it's permissible.
Yes, yes.
The parties consent. Consent on
No,
the.
no, I agree. the party is concerned. But then, my lord, for that, there must be something wrong with the award.
No,
That
once it is set aside. once
set
it is
aside, yes, if party is concerned. Otherwise, it can't be. One. Secondly, even to, send it.
Understood, that is
Yeah,
understood.
yes. In fact, the learned, my lord, the commercial court, sorry, district court has virtually, my lord, sought to reappreciate in half a page, one paragraph.
We'll show the award.
Anyway, my lord.
Can the records be called for, my lord? Because at least one set of the papers will be before your lordships.
Because a huge amount is due and payable to us from, my lord, for the last 10 years. It's only 14 years. That's the only thing, my lord, at the earliest. Subject, of course, I know, my lord, subject to your lordship's convenience and
14 years.
board, my lord. And we'll file this, my lord, in the office.
Right.
Then, my lord, if your lordships can
August.
speak. Of course, according to me, it's not needed, but of course, my lord, my learned friend says, my lord, I can't say anything.
When do you want?
At the earliest, my lord.
I would second week of August. Whenever, second week of, not, can it be after 14th? No? After 14th. 12th, 13th, 14th, not, but okay, 8th, 9th, 10th also. 5th onwards.
Fourteenth will mean 19. Yes. After 14th would mean 19th,
19th.
19th of August.
Any, my lord, 12th, 13th, 14th, not possible.
12th, 13th, I'm not.
Oh, 13th.
3 days and not.
3 days. All right. I'm in your lordship's hands.
Yes,
19th, my lord.
19th.
Please.
This one.
Responding.
Yes.
Notes may just pass on a very short synopsis, notes. Just 2 sentences before I take your lordships to the synopsis. It's a very short synopsis. Notes the appellant before your lordships is a developer. He enters into a joint development agreement for development of a larger plot as a villa complex. It is to be developed in 2 phases. That's the understanding. Though the plan sanction is given for the entire project, it is to be developed in 2 phases. When he is in the process of completing the first phase, there is some financial distress which he undertakes. It is at that time he approaches the master, that is master services agreement is entered into, which is based on a term sheet as to what was the circumstance which was then prevailing. May lordships now kindly take the synopsis.
Yes.
Notes on 19.1 is the joint development agreement where that 62%, 38% is there. 62% is to the developer. That is my share. On 25/1/2017, there are 2 documents which comes into existence, which is the master services agreement and the term sheet. The appellant company entered into a DMSA with the respondent company for construction of the underdeveloped residential villas. That is the first phase 54 villas, and in second phase 41 villas. In all, 95 villas of the developer share and 23 villas of the landlord share in the first phase, and 35 villas in the second phase, in all amounting to 59 villas. Appellant company is entitled to 35% of the profits for selling the villas, and respondent company is entitled to 65% of the profit share for selling the residential flats in the project. Lordships, kindly permit me to pause here for a minute. This is pertaining to the entire project, is how the master services agreement has been brought about. But the fine lines of what existed or what was the circumstances under which the transaction was brought about is what is contained in this term sheet. The term sheet says the appellant is having 18,000 square feet of out of the 1,92,418 square feet in the first phase. That is my share. The appellant company, his receivable amounts from the project stock, which is already sold, is about 41 crores 54 lakhs. Notice this is what is required to be received by me for the plot for the first phase of the villa buildings, which has already been constructed, and this is what is required to be received by me. Next, approximate amount required to complete the first phase is 30 crores. So whatever is the balance work which is required to be undertaken by them is approximately at about 30 crore rupees. The loan is 25 crores on the project from LIC Housing Finance, of which 13 crores has been drawn out. Second phase project total area is about 3,05,000 square feet. 1,70,000 square feet, that is 60% of the area, goes to appellant share in the company. Approximate cost of the construction of the second phase is about 75 crores. And the respondent company is not claiming 65% share from the first phase project. He is entitled to nominal cost of construction and all the costs and sale proceeds accrued from the first accrued to the ND developers. I'll just again pause here for a minute. I just wanted to explain as to what this transaction is all about. There is a first phase and there is a second phase. First phase is concerned, it is under construction and we have completed most of the works. About 30 crores worth of work is still pending. And what is recoverable from these plots, the plots which has already been negotiated with the purchaser is about 41 crores, which is the receivables, number one. Secondly, what will be received by the person who enters into the services agreement, the respondent, is a nominal cost for the purpose of undertaking the completion, for which he will undertake the second phase development, in which he will get a revenue sharing of 65%, 35% over and above the benchmark. This is essentially, my lords, how this document is structured. On 28/9/2017, there is an addendum executed. There is no great significance to this. On 27/11/2017, appellant and the respondents have mortgaged 60 unsold villas in favor of India Bulls and raised a loan of 42 crore rupees. So this is 42 crores is from the first phase of the project itself. Then on 5/3/2014, this is very crucial. This is the original sanction plan. Was sanctioned by the BBMP. Certificate was issued by the BBMP on 29/1/2016. The project was registered with RERA on 3/11/2017. On 22/1/21, the BBMP issued a partial occupancy certificate for 177 villas out of 172 villas in the first phase of the project. The respondent company has now filed an FIR in number 92/22 for misappropriation funds of 1 crore 92 lakhs received from the customers under section 120B. This is what has been filed. Then a legal notice is issued to the appellant. On 13/9/23, there is another criminal complaint which is registered against the company. On 8/12/23, another complaint is filed against the appellant's company. Then we filed this commercial AA. The appellant filed commercial arbitration application seeking interim relief not to alienate the property, not to draw the amount from the project. The trial court has dismissed the application against which we are now before the court. Now, Lords may kindly come to clause 13. What is that which has happened? Lords, the total amounts which has been received on record is what I have noted. This is in the first phase, 23 crores 93 lakhs in respect of the unsold apartments. They've sold 4 villas in the second phase. When second phase is concerned, I'm producing documents to show that the plan sanction, which was sanctioned in 2014, they have applied for modification. They don't want to go ahead with the project on the basis of the same sanction plan. And there is no sanction plan in existence so far as the second phase project is concerned. Then next, total amount is 34 crores received from sale of 11 villas. Then 8 villas in first phase is sold by respondent for 24 crores. In all, they have received 47 crores 93 lakhs 41,679 from first phase of villas. And what they have received is another 11 crores from the second phase, which is 58 crores 96 lakhs 75,727. In other words, for what was essentially an amount of 30 crores which they were required to invest, they have completed. It's not completed in the strict sense. They have said that this is completed for the purpose of obtaining the occupancy certificate, and they have recovered about 60 crore rupees. Now, this entire exercise is undertaken when the applications were pending before the court. This is what has happened. Now, the only relief which we are seeking is that they should not alienate the properties, because by virtue of a power of attorney, we have given them the power to sell the properties. The reason why we are telling this is twofold. Firstly, legally, it is impermissible for them to sell any apartment, any villa in the second phase for the fact that, and the documents kodi, for the fact that there is no plan sanction so far as the second phase is concerned. They have gone for a modification of the plan. The modification is not yet given. Question of selling it doesn't arise because the gullible people, the gullible public will be put at risk if they are permitted to sell the villas based on 2014 when they have already gone to the BBMP and said that we wanted a modification of the same. This is number one. They cannot now go on with the project also because the plan sanction is yet to be.
Buildings have been constructed as per the old plan or new plan?
The buildings, second phase is not yet constructed. The first phase is constructed and its occupancy certificate is given for about 77 villas out of 177 villas. Second phase is concerned, they have started with it, but there is no plan sanction. And whatever they have started is not in accordance with the plan sanction which is given in 2014. And the period for which the sanction is given, that's already expired.
No, there is an injunction order operating in their favor where you are restrained from interfering their construction activity.
Yes. That's them, absolutely no difficulty. Now the question is only this, Milords, whether they can sell the property is the question. If they're entitled for a revenue share.
The court has observed that there is no arbitration clause, so section 9 application is not maintainable.
Not sir, that is not, if your lots is, no, that's not the observation. That is what is being argued, Milords, on the other side. That's not the observation. There is an arbitration clause.
No,
they want to say that the kind of arbitration clause which is now referred to will not cover the nature of dispute which we are raising.
Subject to correction, there is a finding.
No.
Arbitration clause. Is there a finding to that effect?
It is. There is no such finding. The notes go ahead. There is a finding to the contrary, Milords. Page 42. So that is page para 38 is the contention, then page 42, para 39.
See, come to page number 45.
Lots of
second sentence. I am of the opinion that the contention of the respondent number 1 is that the instant arbitration application filed by the petitioner
is not acceptable one.
Contention of the respondent, all right.
Yes, is not acceptable one.
Understood.
So that's essentially where it stands, Milords. Whether they can, now the question is, Lords, may kindly have a look at the additional documents because this is something which they have not disclosed when they were before the court. This is, transcript copy lo idike.
The power of attorney is irrevocable.
Notice the power of attorney, whether it is revocable or irrevocable is an aspect.
No.
During the course of arbitration only, our contention is it is revocable, determinable by nature.
Is it not coupled with interest?
Notice there is no question of interest because the nature of interest which is recognized or reckoned in terms of the section 202 of the Contract Act is interest in the subject matter.
They have invested.
Notice the interest in the subject matter, the creation of an interest in the subject matter. Notice if an agency is required to do certain acts, including an investment, will it amount to an investment? Will it amount to creating an interest in the subject matter is an aspect which will be gone into Notice in the given circumstances. That is something which will be decided by the arbitrator. But the question is whether in the scenario of this kind, because if there is anything to be said, whatever 30 crores they have invested, that amount, Milords, they have already taken it back. 57 crores is what they have already taken it back. They cannot sell the sites for two reasons. Firstly, kindly have a look at these documents, Milords.
Under the second agreement, you are entitled to share in the profit.
In the second phase, there is a sharing of profit. Sharing of profit. Now, that's the reason why I said it will be whether it is to be reckoned as a commission for doing the work of agency which I have given to them, or whether it should be reckoned as an interest created in the subject matter of the agency is a question to be decided.
You are entitled to profit.
I am entitled for 35% of the profit. Once we say it is profit sharing, whether it can be termed as a commission or an interest in the subject matter of the agency.
If you are entitled to share in the profit from the properties which he sells under the general power of attorney, how can you seek a restraint order against the respondent?
Milords, the only question is this, Milords. The question should be asked the other way around. If he is selling the property based on the agency which I have created, can he be permitted to sell the property and say that you take your profit and be quiet with it? Because I am the one who is entitled to this ownership of this property. Whether my ownership gets divested to the extent that they will have a laissez-faire to sell the properties.
You authorized him.
They have authorized him under certain circumstances, which now does not exist. There is a variation in the terms and conditions by virtue of which it cannot go on.
What are the variations?
No, the variation is, what he has done is he has appropriated to himself the entire amount which was sold from out of the first phase of the projects. Second phase, a modification is applied for, which is not with our consent, and modification does not wait. Without there being any modification, he started selling the villas in the second phase.
If there is no modification, the earlier plan subsists.
No, that is expired. 2014 plan. Kindly have a look at minutes. They cannot approbate and reprobate. They are having approached the BBMP. They had to wait for the outcome. Kindly have a look at page 17. And this was not an account which they could maintain by themselves. This is more in the nature of an escrow. Every single rupee had to come to the account, but that is not what they have done. The criminal cases are filed because they have misappropriated it. The entire amount they have withdrawn. Milords, in that page 17, Milords, in the list of, Milords, my apologies, the English translation is not given. I'll just read it and translate for Lordship's consideration. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಾವು ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ಕರ್ನಾಟಕ ಮಾಹಿತಿ. Page 17, Milords, in the list of documents now given. ಈ ಪ್ಲಾನ್ ಎಲ್ಲಿ ತನಕ ವ್ಯಾಲಿಡ್ ಇದೆ? ಎಲ್ಲಿ ತನಕ ವ್ಯಾಲಿಡ್ ಇದೆ?
So these are all part of pleading in section 9 court?
No, this was not placed. This is something which they are a privy to. Page number 17. And Lordships will see when is that the information is obtained. This is on 2/7/24. And their application is on, Milords, filed sometime during 22-23. After the disputes have arisen, they have gone before the BBMP on the basis of this power of attorney.
Is applied for modification?
Yes.
Yes.
Lords, may just copy it, yeah?
According to you, when the first sanction plan expired?
2014, it will be valid for a period of 10 years, 2024, 21.
Valid for?
Once OC is given, provisional occupancy certificate is given, they will have to again seek for modification, which they have done in 22-23. There is no subsisting plan as of today. Lords, may I just?
According to you, when it expired?
Lords, 21 it expires. Lords, what is now the subject matter is this portion where there is a vacant portion here. This is where they are required to construct. Half constructed villas are there, which is in accordance with the old plan only. They have constructed to some extent. But now they are seeking for the modification of the entire part, which is now unconstructed. Whatever is in the first phase, they have already sold it. There is nothing in the first phase. Lords, if they make a statement, there is a subsisting plan, then it's a different aspect. I'm making a statement, there is no subsisting plan. Lords, now your Lordships may kindly see the term sheet. Lords, there is some significance to this document. The document, this was filed on 10/7/24, my lords. Page number 2. Lords, now there's another, it was filed on the last occasion, my lords. I'm sorry.
This is plan.
This is the sanction plan of 2014, for which the provisional certificate is already issued in 2021. This plan is lapsed and they have already gone for modification.
Lapse in the sense it is not completed, project is not completed. within the
completed.
Stipulated period.
Yes.
Then what is the procedure? They have to apply for renewal.
My lords, either they have to apply for renewal, or now they have not applied for renewal. It's an admitted fact that they have applied for modification.
Ideally, they should apply for renewal.
Yes, ideally that will be.
Okay.
Now, lords, may kindly have a look at the term sheet, my lords. That will bring light as to what was the existing scenario. There is nothing more than what they will be entitled to claim. 10.7.24.
Madam. Madam.
Where is the 10.7?
10.7.24.
Yes.
Page number 2, my lords. This is on 12.1. Your lords will see this is between the appellant and the respondent. 25.1, this DMSA comes into existence. This is on 12/1/2017. Lords will see it in the bottom of the page. Work and scope of project development for around the mangoes. Project description: Mrs. ND developers are developing a villa project around the mangoes consisting of 164 villas over 20 acres of land with a total of 5,84,000 square feet built up area, that is. All plan sanctions have been received for the said project and construction is ongoing. Project is a joint development of by ND developers. Its share is 60% of the total development area. Landowners' share is 40%. ND developer share in phase 1 of the project is 1,92,000 square feet, out of which 18,000 square feet is unsold. ND developers has receivables of 41 crores 54 lakhs from the project stock already sold. So this is something which they are yet to receive.
From whom? From the
From the
purchasers.
persons who are the purchasers.
Purchasers. Not from the respondent.
No, 41 crores is to be received by them. So this is made over to them. That's essentially what we are telling. The approximate amount, this is very, very important. The approximate amount required to complete phase 1 is 30 crores. There is a loan of 25 crores on the project from LIC Housing, out of which 13 crores has been drawn. Not 13 crores is the loan which is actually withdrawn. 25 crores is the sanctioned loan. Then the approximate cost of construction in phase 2 is about 75 crores. This is how it is calculated. Then all areas and figures approximate subject to verification. Terms of agreement. Concept abeyance is offered to develop phase 2 of the project of ND developers have consented to the same. The project will be co-branded. Concept abeyance will invest 25 crores into the project, out of which 5 crores will be paid within 15 days from the date of this term sheet, subject to legal due diligence. Costs and sale proceeds, lords may kindly mark this. Costs and sale proceeds from phase 1 will accrue to Mrs. ND developers. Concept ambience will also carry out the balance construction for phase 1. Concept ambience will charge a nominal fee for the same. This is for phase 1. Then phase 1 and phase 2.
So phase 1 was by and large over by that time.
Yes. So therefore, they will complete. What is happening is, in lieu of their undertaking to construct and complete phase 1 for a nominal cost, they will be entitled for developing the phase 2 with a profit sharing ratio. This is essentially how it is designed. Now, phase 1, they have already taken the entire money.
Which money?
That 53 crore rupees, which I have now indicated, in that
41 crores.
41 crores, whatever amount was coming into this project, they have taken it.
From your purchaser.
Yes. Now next,
how the payment is made to them?
Payment will be made now. After this, there is an account which was opened. All the money came into the account and they operated the accounts and took the money.
So who showed that account to your buyers?
We have only communicated.
Who showed?
Yes.
They credited. As simple as this.
There is scope to extend the project by 5.4 acres for the adjacent land. ND developers will stake JDA on the same with the landowners, and parties will mutually discuss. Then work and scope of development and project will be branded, so on and so forth. Then page 5 is the unsold villas. This is the inventory drawn, at that stage. And the details of which is at page number 6, 7, and 8 and 9.
Yes.
Notice the reason why I'm submitting this is, it is not as though that there is something which is unconditionally given to them. It is conditional upon certain things happening.
No, there is nothing in this term sheet to indicate that they can start phase 2 only after completion of phase 1.
Absolutely not, my lords. They are entitled to start it. But now the difficulty is phase 1 they completed. What it says is phase 1 is required to be completed by them, and phase 1 they will be entitled to receive nominal amounts.
They have received
Now-
excess amount, here is your claim.
Now they have received, the whole of the consideration is what they have received. 25 crores is what they was required to be brought in. But instead what happened was, there were certain other unsold villas which was mortgaged, and about 40-50 crore rupees was again mortgaged, brought into the project by a mortgaged loan. So that is how the money has been brought into this project. Question is about enabling them to sell this.
According to you, after this term sheet being entered into between the parties, second phase has not commenced.
Lord, second phase, what happened? They have started the second phase. That photograph, if your lordships were to see, there are about 14 villas which they have started with the construction. The total number of villas in second phase is to? What the total second phase is villas? Second phase is total 77 villas.
Correct. How many villas they have completed?
Lords, they have not completed anything.
To what extent they have completed?
Lords, they have completed some 20-30% of the work which they have completed as of now. But what they have done is they are selling it. But the whole situation is that this is in the teeth of a modified plan having been applied by them.
Whether the terms and conditions would say that they can sell the property only after completion?
Lords, my rights, because they will not,
Even before completion.
they
it is
cannot do
permissible
it.
To sell.
They can't do it.
Under
No,
law,
no.
there is no prohibition.
Lords, under the joint development agreement, I myself don't get the right to sell the property unless I complete the project. I am a developer. Unless I complete it, where is any question of?
They are deriving right under.
Yes, yes. Delegators, delegators, potus delegate.
Under law, there is no prohibition. If
There
there
is no, Lords, the law says that if there is an express authorization, it is permissible to delegate.
No, under law, there is no prohibition to sell the property which is not yet complete. But your agreement with the owner, it says
Is
it
to
can be
complete
sold.
the project and then I get the right to sell the property. And what they are referring to is clause 12, my lords. If your lords were to see, whether this could have been done at all is one of the questions.
Which clause in the original agreement says that you can sell the property only after completion?
Lords, lordships will kindly take the joint development agreement at page 53. At page 67, clause 23. This is the clause.
Clause 23.
3.
Page 67, huh?
67, my lords.
Who is the first party?
First party, my lords, is ND developers.
As and when the project is completed or at any time as required by the first party after obtaining approval of layout plans.
Lords, this is
From
the
the
first,
PDA.
second part. If your lordship is reading the second part contemplates a situation where they want to sell the plots and enter into an independent agreement for construction of the villas. Lords, your lordship,
All right, even before.
the normal commercial
even-
practice,
Even before completion of the construction, it is permissible
plots,
under the.
plots could have been sold.
All right.
My lords, plots could have been sold. Lords, there are two ways of conveying this, Lords. What was conceptualized, what is the content of section of clause 23 is, if it is villas, then it is after completion. If it is plots, then it can be sold together with the construction agreements. This is how it is being done. That is what it refers to as a commercial practice.
But the agreement doesn't say it can be sold only after completion.
Lords,
Doesn't
it
say-
says two contingencies, Lords. As and when the project is completed, or at any time required by the first party after obtaining approval plan from the BDS, second party shall execute necessary registered sale deeds conveying the land and construction villas or falling to the share of the first party. Lords, what happens in a commercial practice, it is permissible that in order to save the stamp duty, they will convey the plots and then they will undertake an individual agreement for construction of the villas. This is what it essentially provides for. That is what is contemplated, but this is not what is provided for them. If your lordships were to see the master services agreement, lords, that is not what is provided. At page number 95. At page 105.
Yes.
Lords, clause number 4.4.5 says what is the total area which is required to be sold. 5.1.1 speaks about the consideration, that is 65%. And then at page 107, clause 6.3 speaks about the execution of the power of attorney, at what stage they could undertake this exercise. The development manager shall be entitled to identify the purchases for villas forming part of the developer's area, enter into agreements for sale and agreements to build, and or agreement to lease and sale deeds of villa in respect thereof. The developer shall authorize the development manager with power of attorney to do such acts, signing of checks, keeping accounts for the same, marketing, selling, branding, negotiating, signing of contracts, constructing, signing and certifying vendor bills, payments, including but not limited to entering into agreements for sale of developer's area, including undivided interest, sale deeds or agreements for lease, license, or other deeds, acts, agreements in respect of the developer's area at any time during the said development and in relation to the same that shall be required for satisfactory performance of the agreement. Then payment of bills for works executed 7.1. All bills for work, costs of the works executed shall be raised in the name of the developer and addressed to the development manager. Development manager shall evaluate and certify the value of the works properly executed, release the payment from account manager, so on and so forth. This is what is contained. He's already taken 42 crores for construction in the first phase itself.
Yeah, I only submit this way, please. Essentially, my lord, the
You appear
writ has I for
So
2 to 8. Essentially, my lord, the writ, my lord, seeks for consideration of the representation at annexures A1 to A6. There is an interstate dispute between both the parties. When
Just
the
appear for
agreement
respondent's number.
2 to 8, please.
In the writ petition.
In the writ petition, there is a connected writ petition, my lords, which is posted before lordships.
Petition.
There is a writ
There are
petition that is.
altogether
Is
there are-
arising from which proceeding?
No, altogether, there are 5 writ petition, 5 cases before your lordship. The first is WP number 24,380 of 23. That is regarding unilateral cancellation of the deed. Then the second is WP 12,118 of 2024. Well, I had given the list also, minutes. That table I had given. That is, yes. The second is that WP 12,118 of 24. That is regarding the denial of the temporary injunction minutes. The third is company appeal minute, that's 164. That's the one that was first filed before your lordship. Then
WP number 14157, please, my lords, is where I appear. Essentially, my lords, to consider their reference for crores mortgage. That could be disposed of, my lords, we will consider the representation in accordance with law.
WP 12118 is regarding denial of temporary injunction.
denial of temporary injunction.
The present appeal is also same.
By them, my lords. This is WP is by us.
By you. my
Yes.
lords. So my apologies to interrupt, my lords. One correction in the submissions which I made in that written synopsis which I have filed. 58 crores 96 lakhs 75,727 is what they have actually received by the sale. Other than that, what they have taken is 42 crores by means of mortgage and another 41 crore rupees, which was my receivables. So in all, they have received almost about 130 crores. They have received 130 crores as on today.
Crores have now value.
Yes, then third. Third case.
Then means that 12,101 is, then the 14,157, which my learned friend appearing for BBMP is mentioning, is a writ petition filed.
We have filed the writ petition as 17.4 for illegal construction without plan. That is the direction to the BBMP to demolition unauthorized structure. That is the
Direction is, my lord, to consider their representation in accordance with law. At annexure A.
They have done it now.
I will request my lords or officers to consider it and pass order.
You appear,
Communicate to them.
you appear for
Lords, A2 to R2 to R8.
PDA,
please.
PDA.
BBMP.
BBMP.
Please.
You are not a party in that proceeding.
No, I am not a party.
Lords, in 17.4 he is party.
Instead he comes in, he is the
Developer is not a party.
developer is a partner.
Developer is the petitioner. my lord.
There are two developers.
Lords, developer is
Correct. There are two developers. Rather than one form. Correct. So that can be disposed of.
That can be.
17.4 can be disposed of.
14,157. We will consider it in accordance with law.
All contentious be left.
I think what is the question?
Lords, in fact, please, my lords, a date may be fixed. We will hear both the parties, please, my lords, in their presence only, and we will put it.
That's nice.
Take a call.
You represent Mondo Builders.
Mondo means.
So you have no objection to allow this writ petition.
No, minister, we have no.
They will, let my submission.
Just a second. Just a second.
All contentious be left open.
All right.
In their presence only, please, my lords, we will hear them and pass orders. Yes. That intention. Lords, a date may kindly be fixed, my lords, about 4 weeks from today.
Lord, the learned senior counsel appearing for the petitioner. Who represent first respondent? State Urban Development Department, learned government advocate for the first respondent. BBMP,
Lords, I represent.
learned counsel appearing for the joint director town planning.
Yes, my lords. All R2 to R8.
2 to
8.
8, learned counsel appearing for the respond number 2 to 8, and also the learned senior counsel appearing for respond number 9. Full stop. The present writ petition is filed seeking writ of mandamus against the respond number 2 to 8 to consider the representation dated 15/5/2024, marked at annexures A, A1 to A6. Full stop. In terms of the said representation, the petitioner claims that he has requested the respond number 2 to 8 to stop illegal construction activity taken up by respond number 9 in violation of building bylaws. Stop. Learned counsel, senior counsel appearing for the respond number 9 would contend that the construction is being taken up in accordance with the building bylaws.
Please.
Learned senior counsel appearing for the petitioner would contend that the construction activity is in violation of the building bylaws, and for this reason, the petitioner has submitted the representation to respond number 2 to 8 to take appropriate action in accordance with law. Having considered the contentions raised at the bar and also on perusal of the records, this court is the view that keeping open all the contentions of the contesting parties, the respond number 2 to 8 should be directed to take up, should be directed to consider the representation dated 15/5/2024, marked at annexure A, A1 to A6 in accordance with law. It is further made clear that
Respondent number 6, my lords.
6,
Yes.
6 and 228, 6. It is further made clear that the respondent number 6 shall issue prior notice to the petitioner
But
as
the
well as
date may be fixed, they will.
Lords may fix a
We'll
date for.
appear on that day, minutes.
as well
Date
as-
may be fixed.
Date fix ಮಾಡಬೇಕಾ?
Next Monday, fix ಮಾಡ್ಬಿಡಿ ಪರ. Next
as-
Monday.
as-
Little they are.
Right, as jointly requested by the learned senior counsel for the petitioner and the respondent number 8.
Nine.
Respondent number 9, the respondent number 6 shall inspect the spot, inspect the site of construction on
After the
22nd, my lords.
26th.
22nd is too early.
No, I'm sorry, 29th. My apologies. Today is 26th.
29th.
29th.
On 29th of this month, alwa, 29th of July 2024. At 11 PM,
11 AM.
11 AM.
Lords may fix a time for conclusion of the proceedings
It is
within
further
30
made clear
days.
that this court has not expressed any opinion on the rival claims of both the parties. The exercise shall be completed within 30 days. Within
Please.
30 days, within
Please.
30 days. From today.
But we will issue necessary endorsement to them.
And thereafter, the respondent number 6 shall
The
issue
Lords may
necessary
not observe it, my lords. It indicates that they are only required to issue an endorsement. They have to take a decision. If it is
whatever.
question of
But
issuance
there
of
is a
endorsement doesn't
representation,
arise.
we'll have to
They
refer
are
to the
asking them, they are
representation.
asking them to take action. If they don't take action,
In
then.
accordance with law, in accordance with.
Yes,
Come
please.
again. Please. So, Milord, now we are left with 4 cases.
So very grateful.
We started the proceedings before your lordship through 164. My lord could kindly turn to, I have given this, like, funny it is, Bible for me, or Gita for me, this, there all the papers are, all are there. My lord could kindly turn to page 194. Why they came here, man? That is explained. In middle of that minute, the respondent number 1, my lord, could get it minutes.
Hmm.
The respondent number 1 is trying to create third party. It's got it.
Page number.
Page 194, there's internal page 36. The respondent number 1 is trying to create third party rights over the petition scheduled properties. The petitioner herein has not produced any prima facie documents before this court. Considering the above facts and circumstances of the case, and for the above reasons, I am of the opinion that at this stage, the petitioner has failed to place the prima facie materials before this court to grant an interim measures against the respondent above as prayed for in this application. Further, as stated above, that when the petitioner has approached this court for seeking the equitable relief of interim measures injunction against the respondents in respect of the petition scheduled properties, then it is the bounden duty of him to approach the court with clean hands. But as stated above, the petitioner has suppressed so many material facts in this application. Considering the above facts and for above reasons, I am of the opinion that when the petitioner has not approached this court with clean hands, then he is not entitled for equitable relief of injunction. Then, Milord, straight away I'll take your lordship to the submission made other day that influenced me to seek for time. First time, Milord, your lordship kindly recollect, I sought for time. Till then, I was not seeking time on any day. They made a submission that we are selling the properties. All allegations are made. Now, with all respect, Milord, whatever said in the memo and whatever said today, with all respect to the learned senior counsel, Milord, my learned friend, is false on the face of it, and we can demonstrate that it is false. It is for that reason, Milord, they had not filed, please note, any document before the learned trial judge. And here, Milord, all the documents are virtually thrown before your lordship without an affidavit.
Now, like this document which reveals that you have applied for.
No,
modification. Just a second, just a
that's
second.
what I said.
No, just a
Each
second.
1 minute I had to controversy.
Second, whether this document has come into existence during the pendency of this appeal or it was pending during the pendency of the proceeding before the trial court.
Earlier means. And all these documents, for a moment, whether it is here, Milord, or before the learned trial judge, if only they file an affidavit, they will be caught. Therefore, they have not filed an affidavit. Please note this, I'm making this submission with all respect, Milord, to the other side, that they have making false submission to the maximum.
We'll file an affidavit. Lords may have this matter
What you
tomorrow,
are
we'll file
saying
the
is,
affidavit.
no, what you are saying
We'll
is
file
you are
it.
not, just a second, you are not applied for modification of the plan.
No, we have not applied. We have not applied. No, this can be demonstrated straight away, Millard.
Yes, you have to file an application then.
No, not only that, Millard, let me complete the rest of the things. Millard, the memo, Millard, other day they filed. Yes. Five seven, dated 5/7. But by the way, it's my duty, Millard, to introduce. The instructing counsel is an advocate and also chartered accountant, Millard. And whereas he is Mr. Pawan Millard from Hyderabad, he will be appearing in that other connected appeal minutes. I'll be appearing in the first appeal. He'll be appearing in the Millard, this memo, Millard, file giving several dates. Their allegation, my lord, could kindly recollect, Millard, what the allegation made on that day and today also is that we are swallowing the money. Hope I am right to the extent, Millard. They have made that submission. It is factually incorrect. Straight away, my lord could kindly turn to. What is his debit credit? Millard, serial number 8 and 11 are one and the same. Double entry. 2 lakh. So the total also varies because of that. And now, Millard, in respect of each Millard, my lord friend, the instructing counsel will explain to the court, Millard, how that money has been generated and where it has gone. It has paid by me to them. That is what they are going to demonstrate with bank documents. We have the documents. With the court permission, he will explain because he's a.
Sorry?
He will explain, Millard, because.
Your lordships.
If they have to explain it, if they put it on record, it will be easier for me.
Let them put it on record, then we will be in a position.
I've already put it on record. If they are disputing any of these documents, they would have already filed something.
Not one. Everything is disputed.
Lord, sir, it is supported with an encumbrance certificate which reflects the sale transaction, the sale
You
transaction
are
value.
referring to some additional documents now?
Please, sir.
Yes, ma'am.
You are referring
Yes,
to
ma'am.
some additional documents to rebut. This memo dated 5/7/2024.
Yes, but in respect of that, we are pointing out how it
Are you
is
pro-
false.
Are you producing it today?
Yes, ma'am.
Yes,
Share the copy.
yes, we'll give a. How it is false is being demonstrated. They collect the money, put the blame on us. In Kannada, we said, no, I'm sorry for that. That koti tinbut innobru mukhake benne hechtu. The monkey story. That's what is being. They say that we are doing, it's not correct. They swallow it and put the blame on us. And we are now supported with bank documents. And further, Millard, one more interesting point at this stage. My lord could kindly take this Bible, Millard, I pointed out. Please see, Millard. Page 1. The first party is ND developers. And second party is GV Nagaraja Reddy. My lord could get it, means. My lord could get it, means.
This one?
In the, no, I'm referring to this. JD. The list of the Gita had, Bible Millard I had given.
Yes.
Yes. Page 1 may kindly be seen. ND developers and GV Nagaraj Reddy. That is dated 19/2/2011. My lord. Then Millard, GPA is at page 22. And GV Nagaraj Reddy and ND developers. No confusion. Nagaraj Reddy is the landlord. Then, now please come to cancellation deed, Millard. Page 128. Page 128. ND Developers and GV Nagaraj Reddy, represented by Durrani, that is ND Developers. My lord, notice. Now please turn to page 34.
Page
34.
So you are a party to the addendum to the general power of attorney.
Yes. Yes.
You are a party.
Yes.
And that is cancelled without your,
Yes, yes. That is the subject matter in one of the readers. And the GV Nagaraj Reddy expired and his LRs have now filed this GPA. That is at page 34. He expired on 26/1/2016. Cancellation deed is executed in his name by the GPA without bringing these people on record. So that again is a false submission. So keeping the death in without disclosing, they have executed the cancellation.
keeping the dead alive.
Dead man alive. They represent the dead man alive.
In 2023.
23.
So they are powerful enough even to represent dead man. Probably the LRs are not siding with them. They did not do any development. Therefore, the developer came to me, and when we started working, we started getting money and putting in their account. We gave our properties and all as security. They suddenly realized that we are the persons. So now landlords are not with them. It looks like. Therefore, Miller, they had done all this. Let them file everything on affidavit, Miller. And
There is a rectification deed. I've already placed it on record. This document, what they are referring to, is already rectified, showing the LRs instead of Nagaraj Reddy, and the document stands rectified. It's already a rectification deed.
For rectification, who could you represent a dead person? That is a contention.
Lords, that's what I'm submitting, my lords. Now, they can't grow bigger than me. The servant is not never more royal than the king. Whatever rights they are now claiming is only under me. If they say that I don't have a rights under Nagaraj Reddy, they will not have anything
Now
instead.
let me quote his own word. Whatever rights I
will not
claim
have-
is under him. In the same way, whatever rights he is claiming is under the landlord.
They
If
will
the
not have
landlord
any.
got to file, then will he keep quiet? Miller? It's not.
All right, coming to the facts and figures.
Yes,
how
the
much
facts
amount-
and figures.
How much amount you have credited to his account?
Yes, he will explain this.
Your Lordships, at the outset, we wish to state that every transaction that they have mentioned has been debited and credited through the account of ND Developers Private Limited, my lords. Nowhere has Mondo privately received into their accounts, my lords. Regarding that, we have submitted the statement as well, the bank statements
Just
as
a
well.
second, amount might have been credited.
Yes,
Who has withdrawn it?
My lords, the withdrawals, as mentioned by them in their memo, my lords, I have an explanation to each and every withdrawal, my lord. Just if you could,
Before that,
peruse-
who has-
yes.
before that, who has withdrawn it?
Lords, we had authorized them to operate the bank accounts. They
Yes,
are
my
the only ones who are operating the bank accounts. We don't have powers to operate the bank accounts.
Your Lordships, the debit and credit entries are taking place through ND Developers accounts, my lord. Where it is going to, that is subjected to audit, and audited financial statements are also shared with them. However, the issue here is what they're claiming, that we are funneling money out, is not true, my lord, because all the money is coming to ND Developers Private Limited's account, my lord, their bank accounts, and we have submitted their own bank statements, my lord, along with our bank statements in the reply to their memo, my lord. For instance, my lord, the very first transaction that they mentioned.
Second, once
Yes,
the amount is credited to the account of ND developers.
Yes, ma'am.
The profit or certain percentage agreed upon.
Yes.
That has to be shared.
Yes, ma'am.
Right? Whether it is shared or not.
No.
My lord,
Only expenses has been done.
expenses
That's
has
what we
been
wanted to
accrued, my
explain
lord.
it.
All the expenses,
For
as a matter of
example,
fact.
Security will be there. We have to pay for the power. We have to pay for the water.
Understood. Is he not?
All those
no.
expenses, Miller.
All right. Is he not entitled to a certain percentage of share?
Your lordship,
the
it is their own bank account, my lord. the fact of the matter remains,
Bank account is theirs.
yes, my lord.
Now, under certain arrangement, they are precluded from operating the account. You are allowed to operate the account. The agreement says he is entitled to certain percentage of share in the
Yes,
said
my lord.
transaction.
My lord, frequently and throughout the years, throughout the period of 7 years, they have withdrawn their share, my lord. And we can demonstrate that if all the 7 years of bank statements, we can produce it, my lord. They have, MKK Durrani has consistently withdrawn money, my lord.
The term sheet would say that they are entitled to some 41 crores.
Yes, my lord.
Whether 41 crore is given to them now?
Yes, my lord. 41 crores has been paid to them through different means, including clearance of their LIC HFL loans, my lord. At
Just a second. You know, the most of the submission is based on all the new materials which have not been placed before the section 9 court. You file proper application along with the necessary affidavit.
Yes.
Let it be on record.
Very well, my lord.
So that,
We
section
know
9,
41
respond to that.
Absolutely no rupee has reached us, 41 crore rupees, 40 crore rupees, which they obtained as mortgage. Everything is put into the project and they are showing only expenses. They have 130 crores is what is generated from the project. 130 crores into their hands. My lord's bank account is in my name, but the bank account is being operated. I'll file everything by means of an
third
affidavit.
senior counsel appearing for the appellant and learned senior counsel appearing for the respondent. Next paragraph. This appeal is arising from an order passed under section 9 of Arbitration and Conciliation Act 1996. Full stop. In terms of the impugned order, the section 9 court has declined to grant interim measure sought by the applicant before it. Full stop. Hence, the applicant is before this court in appeal. Full stop. Next paragraph. It is urged by the learned senior counsel appearing for the appellant that the amount payable to the appellant under the joint development agreement, as well as, what is that agreement? DMSA.
DMSA.
Development Management Services Agreement.
Development Management Services Agreement is not paid to the appellant. Full stop. It is his further submission that the respondent has withdrawn the said amount by misusing the authorization granted to the respondent. In support of his submission, he would also submit that the appellant is, respondent is not carrying out the construction activity as per the sanctioned plan, and he has applied for modification of the sanctioned plan without the consent of the appellant. Full stop. Next paragraph. Learned senior counsel appearing for the respondent would submit that the respondent has not applied for modification of the sanctioned plan. And it is also his submission that the appellant has not filed any application for production of additional document before this court. And the submission made by the appellant that the amount is misused, misappropriated by the respondent is also incorrect. And said contention cannot be accepted without there being any proper application and materials placed before this court. Stop. He would also submit that the respondent has got necessary documents to show that the amount has been used as per the authorization. Amount has been applied in terms of the authorization given to the respondent. Under these circumstances, this court is the view that the appellant and respondent shall file a proper application for production of any additional documents. Appellant as well as respondent.
No, we are not, whatever they file, we'll file it.
All right. Under these circumstances, this court is the view that the appellant shall file an application for production of additional documents, and the respondent is also permitted to file rejoinder
It's supporting.
in support of the contention of the respondent. Full stop. When do you want?
1 week, my lords.
In a day after 30th minutes, because I'm not there in.
This matter.
For furthering means.
We don't know about the combination.
That's why Kalashmi put it on some Friday minute for further hearing.
In a day, my lords, I am before your lordships. Please. They are undertaken. Anyway, they are saying that the statement is false. Let him keep it false for some more time.
No, Miller, we had to make expenses, Miller, that otherwise the project will come
Let
to
them
an end.
not, they had said that they'll not undertake not to alienate the properties till the next date. Let it be continued till the matter comes up once again, my lords, before your lordships.
We had
Okay,
to
that
incur
is at large.
expenses, Miller, we had to incur expenses. Project to keep, Miller, whatever that is done, we will place it before the court, that will be subject to the result in the, before your lordships, subject to approval by your lordships. Because we had to pay for the security.
No,
We
are
have
you-
to
no,
pay for the power,
No,
Milord.
no. just a
130
second,
crores they are
just-
having in their pocket.
Are you selling the
Spend it
property
leisurely.
or just borrowing the loan? You are selling the property or what?
It's like this, Milord. Some of the properties are sold by them, which we get the money now. That we credited
That,
to the
that
account.
money will be credited to your account. There is no.
Account, yes, Milord. What, through bank
Let
account.
them
Their
not sell any
submission is-
fresh properties.
Just
What
a second,
is-
their submission is, the undertaking was only not to sell the property.
Sell the properties, that's it.
No, if it's already sold, Milord, if it's already sold under.
If it is already
agreement,
sold, no difficulty. The
no,
amount is.
under an agreement, Milord, if it is sold by them under the agreement, we are bound to continue it. Otherwise, they will not make the balance payment.
So you will not create any fresh agreement.
No fresh, yes, Milord, that we
That
are
can
not
be-
doing.
No fresh transactions.
We will not create any fresh
All right.
third party rights.
It is made clear that the respondent shall not create any fresh third party
Fresh
rights.
trans-
Fresh
yes.
third party rights. Full stop.
Madly.
The respondent is permitted to continue with the transaction, continue with the agreements which have already been entered into.
Yes, sir.
Please.
And also make payment for the commitments, Milord, already there, because we had to
But
pay
they
for
are
the.
still authorized to operate my bank accounts.
No,
But
that authorization is already there.
Yes.
that authorization is there. What is that they want
And if
from
he
the court
undertakes,
now again and
let him
again?
pay.
Manoj,
No
may I?
question.
No fresh,
There is no question of, that's the only undertaking and that is the subject matter of the instant appeals.
fresh transaction shall not be carried out in respect of immovable properties.
Lots. Please, Vinod.
Manoj, there's another writ petition, my lords, in regards to the wrongful cancellation of the general power of attorney. That's WP 24380, my lords.
That can be taken up
All
along
those
with this.
cases can be taken up on the same.
My lords, the issue is, my lords, that cancellation of the sale deed has been done without authorization before the wrong sub-registrar's office, my lords, and that,
No,
the general power of attorney.
general power of attorney.
The general power of attorney, my lords, has been unilaterally cancelled before a wrong territorial jurisdiction office. And my lords, that's an important petition.
Sir had no jurisdiction.
Yes, my lords. My submission, my lords, is this. As much as there are allegations and counter allegations, the crux of the issue, my lords, pertains to whether or not the GPA has been wrongfully cancelled without the notice and what is the status. The genesis is that writ petition, my lords. Everything else thereafter is with regard to whether or not it's an arbitrable or not arbitrable. In my humble submission, my lords, if that writ petition gets decided in terms of the manner in which the registration has happened, then, my lords, the court will be completely apprised of the fact in terms of whose conduct it is.
All cases will be taken up together.
My lords, my submission is this, my lords. If in that, I don't think the counters have also been filed, my lords. If
Just
at least
second, notice to R8 is not, respond number 8 is not yet complete in the.
In
petition.
that.
In the 24380, I appear for respond number 7, my lord. I have instructions to file the wakalas.
WP?
Number 7 to one of the landowners in 17.2.
So will you accept on behalf of notice, on behalf of R8?
R8 no instruction, my lord. Respond number 7.
Notice to R8 is not yet complete.
Yes, sir.
Notice to R8 is not yet service.
I'll have it done, my lords.
Grateful.
Next one.
Any date is given, means?
Petitioner to pay the process fee for service of notice to respond number 8.
I'm obliged, my lords.
Any?
Fifth
At
August.
2:30 means. 5th August at 2:30. I'm sorry.
It will be listed at 10:30, make a mention and get it listed at 2:30.
Obliged, my lords.
Plaintiff's appeal, my lords. A suit for recovery has been partially decreed. The 2,33,94,711, my lord, was the claim. 35 lakhs has been decreed, my lord. The rest 2 heads of claim, my lord, is covered by specific clause.
Has filed an appeal? Defendant has filed an appeal?
Defendant, my lord, I am told has filed an appeal and it's still in the compliance stage.
List along with,
Ah,
list along with.
Well, I'm for the appellant in this matter. This is the matter, my lords, that
Understood,
heard
understood.
regarding section 8.
I think Supreme Court, gave for yesterday.
SBI's judgment, but that was in context of a section 11, my lords. That is in SBI's judgments on accord and satisfaction. It has said that even accord and satisfaction is
That
arbitrable.
supports your view.
It supports the view, but here the question is not of accord and
Understood.
satisfaction. That is the only factual distinction. My only submission is, my lords, 5 dates now the respondent has not appeared after filing wakalat. This matter may be disposed.
Pass over.
Pass over.
Appear for the appellant. My lord, I may be permitted to place on record, my lord, the documents which I had filed before the commercial court. My lord, among the documents, my lord, your lordship may kindly see page 2, my lord, the first document. My lord, this is a notice which I received on 6th August 2004. Calling upon me, my lord, to pay 39,178 initially. Then, my lord, 3 installments were given. My lord, I exercised the third option and paid the money. My lord, the proof is my bank account, my lord, at document number 2 and 3. Then, my lord, all of a sudden in 2006, I received a notice from advocates, my lord, from New Delhi, as per document number 4, page 5. My lord, then, my lord, a conciliator was appointed, my lord, in Bangalore. I offered my reply, page 6, my lord, document number 5. I said, as per the demand, I have made the payment and nothing is due to me. My lord, this is in 2006. Then all of a sudden, my lord, subsequently in 2020, my lord, after lapse of, my lord, 14 years, my lord, a demand is made, my lord, calling upon me to pay 2,73,000. My lord, I have no, except, my lord, disclosure of the arbitrator's position. No claim statement is served on me, nor I had any other notices issued by the arbitrator. In the meantime, my lord, the matter was listed before the District Legal Services Authority on 2 occasions. I said, there is no liability from my side. My lord, thereafter nothing was heard. All of a sudden, my lord, I receive a copy of the award, not even a certified copy of the award. It is a photocopy. My lord, on receipt of that, my lord, I approached the commercial court. My lord, date of agreement is not forthcoming. My lord, date on which the card is issued is not forthcoming in the award.
Close the seat of arbitration.
My lord, nothing is there. He records that seat and venue is at New Delhi. My lord, it is not supported by any document. They were held ex parte. Both are.
What the award says?
Award says, my lord, I am liable.
No, no.
And seat of the arbitration is at New Delhi and venue is at New Delhi.
So then,
my lord, it is not extracted. Records were summoned. He doesn't produce the records. Both were held ex parte, SBI cards as well as, my lord, the arbitrator.
but prima facie award says it is passed in New Delhi.
Pardon, my lord?
Prima facie award says the award is passed in New Delhi.
Yes, it says, it is a copy of the award, my lord, which
How
I
the section court, the court in Bangalore will get the jurisdiction?
My lord, there must be one, my lord, valid award. Second, my lord, the award should be, my lord, at least a document I should have notice. My lord, if this kind of awards are allowed to be passed.
No, those things understood, but you can question it, no difficulty. You have got X number of grounds to question the award.
Please, my
No
lord.
difficulty, but it has to be questioned before the jurisdictional court.
My lord, it flows from the agreement.
Merely because you are residing in Bangalore, you can't raise the
My lord,
question.
I agree with that. But, my lord, it flows from the agreement if there is one. That, my lord, they don't produce despite the court summoning it. My lord, he is a small man, my lord, an industrial worker. In 2003, my lord, he took this card. And everything, my lord, liability was closed, card was mutilated. My lord, liability was closed, squared off. And I had stated this, my lord, when the conciliation was held way back in 2006.
Section 34 court issued notice to summon the records.
Yes, my lord. Your lordship gets that at my lord page. Your Lordship may kindly turn to page 55, my lord. 54. My lord, 54 top. Hence, service held sufficient. The defendant number 1 placed ex parte. Await records and arguments. Call on so and so. Then, my lord, once again, page 55 top. Await records. Then, my lord, once again, page 57. The plaintiff has already submitted paper book in spite of repeated requisitions. The learned arbitrator has not furnished the records.
Issue notice.
My lord, now they have filed execution, my lord. My lord, I pray for stay of that. My lord, I am, after 16 years, after everything is closed.
Deposit the amount.
My lord, I am a retired industrial worker. Everything, my lord, according to their own document, my lord, the liability is 41,000 in the way back in 2006. I file my objection saying that.
After hearing the learned counsel appearing for the petitioner who submits that despite summons being issued to the arbitrator, the learned arbitrator has not produced the records. And in the context of the submission that no claim notice was issued to the present appellant. This go to the view that operation of the impugned award is to be stayed till further order. Issue emergent notice.
Much of
Operation and execution.
My lords, kindly pass over the matter.
So where we had to file an affidavit as to how many agreements of sale have been entered into and also the bookings, my lord. Now, there's a clarification. I have the affidavit ready, but I'll have to make some submissions insofar as what the affidavit also contains and the clarification pertaining to that. My lord. Because here, as per their own say, the termination has already been given effect to. May I place this on record or should I do it once the learned senior counsel is there?
You're placing it today?
I have it, my lord. It's with me.
Have you served the copy?
I'll serve a copy. Right?
Yes. Next week.
Next week. My lord, the only thing is 90 crores is still stuck, my lord. I'm still not able to do anything. Now, insofar as alienating the property to a certain extent, my lord, here, but then collecting monies. Now, this is their grievance.
Tomorrow. Share the copy today, tomorrow.
Absolutely. May I seek a passport itself, my lord, if possible, because at 2:30, the only thing is that
Today's
money
load is quite heavy.
I understand.
Tomorrow.
Please.
Obliged.
Please. Obliged.
For the appellants in this case, my lords. I'm before this honorable court seeking to set aside the ad interim ex parte injunction passed by the honorable commercial court, order dated 6/7/2024. My lords, I had filed an IA for dispensation of production of certified copy, IA number 1. I've received the certified copy, my lords. With your permission, I will produce it to this honorable.
Is it under section 9?
My lords?
Is it under section 9?
No, 13.
Order 39.
Order 39, yes.
But order is not granted.
It is granted. I'm the defendant in the case. I'm questioning the ex parte interim order passed. The reason I'm approaching this honorable court is twofold.
I think that this court has taken a view that appeal is not maintainable against an order.
My lords,
passed under order 39 rule 3.
please, my lords. I have various judgments from the Honorable Supreme Court and this Honorable Court as well, wherein it says the order passed under Order 39, 1 and 2 ex parte orders are also under orders and appealable under Order 43. I will produce the judgments as well. The reason I've approached my lords are twofolds. One, Based on the,
Wait.
please.
Could I also make one submission, my
This
lord?
is Supreme Court judgment.
First three are the Supreme Court judgments. First four, my lords, my apologies. And number 5 is division bench of this honorable court.
The learned paragraph.
Please, my lords, what the Supreme Court says is whenever an ex parte order has been,
Learned paragraph.
please. Internal page number 26. Paragraph number 36 in the first judgment, Morgan Stanley Mutual Fund versus Karthik Das. With your permission, if I may read, my lords. Please. As a principle, ex parte injunction could be granted only under exceptional circumstances. The factors which should weigh with the court in the grant of ex parte injunction are whether irreparable or serious mischief will ensue to the plaintiff, whether the refusal of ex parte injunction would
Take to the paragraph, it says appeal is maintainable.
my lords, in all these judgments, the Honorable Supreme Court has set aside the ex parte orders passed by the Honorable Court. And the latest judgment, my lords, which is...
If that contention is not raised, that an appeal is not maintainable against an order.
It is, my lords, it is. Even...
Where is the finding?
My lords, page number 63, the latest judgment, 2024 online SC 426. This arises under special leave appeal. Even in this case, my lords, the lower court had granted an ex parte order. The High Court had rejected to entertain, refused to entertain the appeal on the ex parte order, and the Supreme Court has
The
gone.
ground that appeal is not maintainable.
Yeah, the High Court said the appeal is not maintainable, and the Supreme Court set aside the ex parte order. My lords, page number 64, paragraph number 4. The order of the trial judge has been upheld by the single judge of the High Court of Delhi by order dated 14 March 2024. The single judge of the High Court seems to have had doubts about the maintainability of the appeal, but the point need not be labored any further having regard to the provisions of Order 43 of the Code of Civil Procedure. And thereafter, the Honorable Supreme Court has gone and discussed various provisions and eventually set aside the ex parte order passed. This is the latest precedent of the Honorable Supreme Court, my lords. If I may point your kind attention, my lords, page number 67, paragraph number 13. In view of the above, the High Court ought to have, in our view, also at least prima facie assessed whether the test for the grant of an injunction was duly established after an evaluation of the facts. The same error which has been committed by the trial judge has been perpetuated by the single judge of the High Court. Merely recording that a prima facie case exists, the balance of convenience is in the favor of the grant of injunction, and that an irreparable injury would be caused would not amount to an application of mind to the facts of the case. The threefold test cannot merely be recorded as a mantra without looking into the facts on the basis of which an injunction has been sought. In the absence of such a consideration, either by the trial judge or by the High Court, we have no option but to set aside both the orders of the trial.
Dismiss the appeal on merits. In the sense, High Court felt that there is a prima facie case. High Court didn't reject the appeal on the ground that it's not maintainable.
Yes, my lords. Consequently, the Supreme Court held that the High Court has the power to set aside an ex parte order. The reason I'm approaching this honorable court is twofold, my lords. One, the honorable lower court has set the next date as 19th of August, which is more than 1.5 months from the date of the order.
Advance the date.
6/7, the order was passed, my lords. In the meantime, the plaintiffs has gone to the level of publishing false articles in the newspapers, threatening various customers. But
What is the effect of interim order now?
my lords, it is in page number 21, which is the interim order. I had filed an IA first dispensation. I have received the certified copy. The main point, my lords, is the interim order was obtained based on false submissions. They said they have a valid patent wherein the patent had ceased as on 24/3/2022. By making or misguiding the honorable court, they have obtained the interim order.
Application for a grant of injunction now has to be considered on merits by the trial court.
Yes,
They have
yes,
the trial
my
court
lords.
to dispose of the applications as expeditiously as possible. We'll fix a date for appearance.
Absolutely, my lords. The problem is, based on this interim order, please refer, my lords, to the page number 6, 7, 8, and 9. He has gone on to publish defaming articles against me. He is threatening my customers and causing irreparable loss to the business. The main point, my lords, is they don't have a patent itself. He has been the judge, the jury, and the executioner, and submitting that dhoti itself is nakli. The product I'm selling itself is false. My company is fraud. All these various allegations he is causing, my lords. That's why I'm knocking on the doors of this honorable court. The date fixed is 1 month from today. In the meantime, I'm suffering lakhs of loss every day in the business, my lords.
Product?
It's a dhoti, which is a telescopic device which is used to pluck fruits
Harvesting
or
device.
prunes. Harvesting device, basically. In Kannada, it is called dhoti. It is a telescopic device. The plaintiff had filed for a patent in 2018. My lords, in the claims, the crux of a patent is in the claims. He had claimed a patent for a product which has a counterweight at the bottom. My lords, if I may take your kind attention, page number 46, which is the IA that they have filed. With your permission, if it may please this court, I'll just read the wordings of the IA.
So can you appear before the trial court on Tuesday or Wednesday?
I can, my lords, but various other defendants may not have been served, and advancing the matter
No,
without
injunction-
it becomes.
it's operating against you.
Yes, my lords, the High Court,
What
sorry,
other
the,
dependents? Who are other dependents?
respondent number 4, 5, and 6 in this case, they are also the defendants in the case.
They seem to be not aggrieved by the order.
They are aggrieved. They have not approached me. The few clients who've approached, which is appellant number 1, 2, 3, and 4, have filed on their behalf. But I'm sure they are also suffering from the impugned order. The main.
So defend number 1 to 4, they can appear on Monday or Tuesday or Wednesday.
Yes, my lord.
With
Yes,
the trial court to
absolutely,
expedite the
absolutely.
application.
Absolutely,
consider
my
objection.
lords. Absolutely. But the point is, my lords, if I may take your kind attention, my lords, in the documents and citations I've produced, the first document, page number 1, not part of the writ petition, my lords, what I produced today, since it was not on the not of record in the lower court. They have misguided the lower court, stating they have a valid patent.
So those things have to be considered by the trial court.
Yes, my
There's
lords,
no consideration of the application on merit.
That's why I'm asking, my lords. The Supreme Court has said when they've made a false submission, the High Court has all the power to set aside the evidence. The
There is
patent
no
has
reference-
ceased.
There is no reference to Order 39, Rule 3.
There are various other judgments as well, my lords. My problem is that,
There are various judgments of this court which would say
Yes,
that
yes.
appeal is not maintainable.
but my lord, latest contention of this, I will approach the lower court. I sincerely request, my lords, is that one, the patent has ceased. They have not produced the same and they have not even whispered about it in the law.
Whose patent? Their patent?
The plaintiff's patent, it has ceased. Before filing itself, as on 24/3/2022, it has ceased. And the IA clearly says grant protection for the patented technology which has ceased. And based on this, he has gone and published various articles, sent messages in the WhatsApp groups of the farmers stating that police will raid their house and threatening various other farmers who are customers of me. Because of this, I've approached this honorable court. I would have waited or I would have moved other applications, but because of the subsequent acts of the plaintiff, I'm forced to knock on the doors of this honorable court.
What we can do is we can direct your appearance for the trial court on
Please,
Friday.
please.
Saturday, the court can take up the matter.
Tomorrow itself, I'm ready to move to the court, but I do want to point your kind attention, my lords, page number 50.
Let the trial court consider this.
Yes, my lords, 59. The Honorable Supreme Court in Rameshwari versus Nirmala Devi has clearly stated when somebody has done perjury, falsifying documents.
All these contents you can raise before the trial.
Yes, let there be direction for considering this as well in the Honorable Lower. And also in the meantime, my lords, the operation of the said order may be set aside till tomorrow day after. Whenever I'll appear tomorrow itself, I undertake that.
For that, again, the question is whether the appeal is maintainable.
My lords, my submission is it is
Keeping
maintainable.
open that question, keeping that question open, we can direct you to appear before the trial court because he is plaintiff is here. We'll.
One
request the trial
question
court-
you can ask,
request
my
the trial
lords.
court.
One question if you can ask the plaintiff whether they have a valid patent or not. That itself solves the.
The documents they are placed on record, my lord, it appears that there seems to have been that the patent has lapsed. I have seen this document now, I'll have to take instructions from that.
Tomorrow.
My lords, one more submission. There are two batches
Let
of
them seek
cases.
instruction.
Two batches of cases.
I agree with what my lawyer friend is saying that if this document indeed that the patent has lapsed, my suit itself may not be maintained. In the meantime, my lord, I have also found out in the trial court that particular court which has passed the interim order, my lord, is on casual. Is on training until the 27th of till this Saturday.
Somebody will be in charge.
Would the matter be posted on Monday before the district court? And we will both appear.
If you are making a statement that the patent has lapsed, then we will vacate the interim order.
It appears so,
my
I
lords.
would
Seek instruction, we will have it tomorrow.
My lords.
submit this,
Seek instruction, whether the plaintiff is.
I would only submit this. In the light of what the document is placed here at, this is what I wanted to say upfront, and I sought the court's leave. Document page number 1, what they have submitted, my lord, it appears to be that the patent has ceased. And I have also, because he has taken up such a contention in the appeal, but the document was not with me until now. I could only state, my lord, that if the patent is actually ceased, then as per section 43, the suit itself is not maintainable of the Patent Act. I will have to withdraw that suit once I go before the trial court. Therefore, I can only submit this today that this appeal may be allowed, of course, subject to, because my lord was on the point of whether the appeal itself is maintainable or not. If the interim order is set aside, and then I will go before the trial court on the next date of hearing.
To add on to that, my lords, there are two batches of cases.
Third, the learned counsel appearing for the appellant and the learned counsel appearing for the respondent. Full stop. This appeal is against an order granting ex parte injunction against the defendant in commercial OS number 920 of 2024 on the file of City Civil Judge Bengaluru. Full stop. The trial court in terms of the impugned order has granted ex parte injunction order against the defendants without assigning any reasons. Full stop. Learned counsel for the appellant would submit that the order passed by the trial court in effect is an order under Order 39, Rules 1 and 2 of Code of Civil Procedure. Thus, he would contend that the appeal is maintainable. Full stop. It is also a submission that the plaintiff respondent has suppressed the material fact, that is, patent has lapsed
Yeah, ceased.
Ceased, the patent ceased as on the date of the suit itself. As such, the suit itself is not maintainable. And in support of his submission, he has produced the document dated
Today, my lords,
document, which is the document which says that the patent has ceased.
Page number one. of
Page
today's
number one
report,
of the-
The document dated
It's printed on 11th of July 2024. It's a printout of the status from the IP website.
IP India website.
page number.
Page number one of
One.
today's memo that is filed by me.
Has produced the printout from the website, Alva. From
Yes,
the-
my lords.
From the official,
IP India
from
website.
the official website maintained by the concerned department. Full stop. Prima facie, it reveals that the patent has ceased on
24/3.
24/3/2022. Admittedly, the suit is filed in the 2024. Full stop. Under these circumstances, without getting into the question whether the appeal is maintainable or not, this go to the view that the interim ex parte order has to be set aside and accordingly set aside. The all contentions of the parties are to be considered by the trial court on merits without being influenced by any of the observations made in this order. Full stop. Appeal is allowed.
Much obliged. Gratefully.
Both parties have filed an appeal. Alva?
There are two sets of suits.
All right.
Defendants are common.
24, right?
Delay, after the report and how the two was filed. The content of the different was earlier, a notice was passed in the and within the time permitted under the law, the petition was not filed. Again, in the year 2019, and the suit was filed on the. The reply was also passed to the first notice, and the same was conceived before the order of November.
Both parties have led evidence. Probably it requires consideration.
That the entire compensation amount requires to be released in favor of the client issue with an agreement holder, which therefore that affected and
Amount is lying with whom now?
No, it's the fact of the suit, what they say is required. And once the contention that entire balance amount.
KIDB is also a party.
Second respondent, Mala.
So can we direct KIDB to deposit the amount before the court so that it can be?
Please. That should be. Otherwise, we'll make reference under 3031 of Land Action Act to the competent court.
Third, admit, call for records. Full stop. Learned confer the appellant would submit. Learned confer the appellant
Neither the defendants.
would submit that the compensation amount in respect of the subject matter of the suit is now lying with Karnataka Industrial Area Development Board.
Respondent number 2.
Full stop. Respond number 2. Respond number 2. Full stop. Since the appeal is admitted and matter requires consideration, this go to the view that respond number 2 should be directed to deposit the compensation amount before this court. Full stop. On such deposit, the amount shall be kept in nationalized bank with auto renewal mandate. Paperwork within 8 weeks. Sorry.
My lord, before this court are
Yes,
reference.
already notice ಆಗಿದೆಯಾ? Notice is served on all.
My lord, in the second matter, my lord, in the second matter, my lord, 280/2024, I will take notice for respondent number 2.
So exception, notice. Same one.
My lord, amount may be deposited before this honorable court or reference court, my lord?
Before this.
This court.
My lord, in this matter, award has not been passed,
Not yet passed.
not yet passed.
Once it
We
is
have passed the award, only 29 to agreement rate has been determined, 1 crore 10 lakhs per acre, my lord. Whether that time, if the parties are agreed, subject to execution of the documents regarding the
Now you have
agreement.
quantified, you are
has been
going to
fixed.
quantify, right?
Yes, ma'am.
Once you quantify, you deposit the amount.
If award has been passed, that may be recorded in the order. my
The
lord.
award is passed.
If the award is passed.
Or as soon as the award is passed.
Yes.
I have filed a suit for partition separate possession before the court below. That has been rejected on the ground that all 7 to 11 applications have been filed by the defendants. Against that, I have preferred an appeal. And in similar matter, the single judge has heard the matter in different cases, with similar facts. It's been reserved for orders, it will post for next week, Doctor. I produce it. And to file the compilation of the judgments of the various courts, I'll produce it tomorrow. If the short date is accommodated.
I appear
Plaintiff is rejected.
Plaintiff is rejected.
On what ground?
Ground that there is a point of limitation, and also there is no cause of action.
Suit for
Suit for partition.
petition.
Partition.
May I make one submission, my lords? My lords, two things it is admitted fact that, my lords, the plaintiffs and first defendants are brothers and sisters, admitted fact. On 7/12/1995, my lords, one of my brother who is not party to the suit, he has executed release deed in my favor, for which the plaintiffs have stood as the consenting witnesses. After lapse of 27 years, my lords, now they have filed the suit for partition. They are parties to the release deed. They are not sought for cancellation of the same. On the other hand, they have filed the suit for partition. That's one thing. It is clearly
Property belong to plaintiff's brother.
Yes. Yes.
plaintiff and as well as first defendant are brothers and sisters. I am the first defendant before the trial court. There is another brother who has executed release deed in my favor.
How that brother acquired the property?
No, all of them has acquired the property, but brother has executed the plaintiff and as well as defendants, they have altogether acquired the property, admitted fact. The brother has executed release deed in my favor on 7/12/1995, for which the plaintiff stood as consenting witness.
So time bar.
So it is time barred and also barred under section 6 of the Hindu Succession Act.
Just because there is a consenting witness, they are defrauded.
What the consent signifies?
ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. On the date of executing the release deed for some person, they have agreed to pay the consideration for me also. They did not acted on that release deed.
Even if it is
Question of limitation is a mixed question.
even that is taken into consideration, my lord, sir. According to them, the amount is not been paid. Even that is taken into consideration. For recovery of the amount is also time is barred.
It's a mixed question of law and fact has to be held by the trial court. Whether it's barred by limitation or not.
It is not a mixed question of law. Once you say that you wanted to receive some consideration or you agreed to receive some consideration.
On that point, I rely on the decision of the Supreme Court. I'll produce it tomorrow. Can you have it at tomorrow?
Next Monday.
Next month.
And moreover, similar matter is reserved for judgment before the court order number 15. A similar set of facts in different case. That they were throwing light on this. Yes.
Next.
Date maybe. Next. Aye.
Then appears call after 2 weeks. 27, we adjourned it. Before you entered the court.
Can it be taken up at some expense? Yes. Sorry. But short point is, before I read the judgment plot, I'll just explain the facts and circumstances in which this case arose. Kindly see the genealogical tree, page 187. I'll just explain. Yes, 187.
here, but
So simple it is.
it's very complicated. But I'll try to simplify it. Yes. Kindly see, Lord, Shanbog Putsamaya. Properties were that of Shanbog Munivenkappa, inherited by Shanbog Putsamaya, who was the last prepositus. Now, Lord, after this, he had 8 children. Out of these 8 children, after his death, MP Venkatesh Murthy, first son, and Gundappa were in charge of the affairs. Accepted position, Lord, in the pleading. MP Venkatesh Murthy and Gundappa, they were in charge of the affairs of the family. Now, Lord, large number of properties has come into the joint family. More than the number of items runs to about 80 to 90 items. Out of this, only 10% was partitioned in the year 2001. The reason was the other sons, Padmanabha, Raghunath, and Prabhu, the 3 sons, 3 daughters, 5 sons. The other 3 sons were completely in dark as to the affairs of the joint family. Now, when 2001 registered partition occurred, 10% of the properties were partitioned, 90% was left as it is. The ground for leaving as it is was 50 acres was acquired in Nagarbavi area for BDA acquisition. In that 50 acres, compensation was received by them, which was not shared with the landowners.
When this partition took place in respect of 10% of the property.
Yes.
All the children joined the partition?
The daughters were not there. But daughters could be excluded as on the law on that date. But all the sons were there, 5 sons were there. But the properties that were included, 10% of properties that were included, did not contain the balance 90% of the properties which had been virtually suppressed by these kartas. For example, it is there in the pleading. For example, in 1992, there were individual properties purchased by these 2 people, almost 20 to 30 items, individually, each of them. Those properties were not brought into the partition. It was agreed that it is an accepted fact that all the properties are joint family properties and arising out of joint family nucleus.
Now, where it is accepted?
That is there in the thing, in the first partition, in the first partition.
Only 10%?
10%.
Now, whether any reference is made to the remaining 90%?
No,
the partition?
it is not.
So not accepted?
Not. No, of course. They do not accept that these properties are joint family properties. It is our contention. Now, Lord, what they kindly see my plaint, Lord. I have culled out in detail. I will just read 2 or 3 paras in the plaint to show the sort of. Page 121 is the plaint. 118. In this plot, kindly see. Paragraph 13. Correct. Plaintiff submits that after searching through records, they came to know that defendant number 1 represented the joint family of late Putsamaya in the acquisition proceedings with respect to 83/1 of Nagarbavi village, which went up to the Supreme Court, where defendant number 1 herein represented the joint family and submitted before Supreme Court of India that about 50 acres of land belongs to late Shanbog Putsamaya were surrendered to the BDA for formation of Nagarbavi first and second stages. In this regard, plaintiff submits that defendant number 1 and late MP Venkatesh Murthy received the compensation award from BDA on acquisition of joint family properties. It further submits that plaintiff are entitled to the legitimate shares in the compensation by Bangalore Development Authority in respect to the acquisition of joint family properties. In this regard, Gazette notification of it. This was the plea. Now, let's kindly see the next plea. 13.1. The Bangalore Development Authorities notified survey number properties. This was the preliminary notification. Next page was the final notification. On this, kindly see my pleadings at para 13.3, page 130. Shall I read, Mla? 13.3, yes. Page 130. It is submitted that as per final notification dated 16/8/85, the possession of survey number 82/1 of Nagarbavi village measuring was taken over by the BDA and award also was passed for said property, measuring so and so, and was notified measuring so and so. Whereas the survey number 83/1 of Nagarbavi measuring 6 acres, 11 guntas was notified in the final acquisition and possession was not taken over by the BDA, passed by the wide informal note passed by the special land acquisition officer. Hence 83/1 was free from acquisition and belongs to joint family. The copies of the award passed so and so, so and so. And therefore, my lord, like this, I pointed out that there were many survey numbers which had not been acquired, which had not been kept in the 2001 partition. My suit was only for properties, the balance 90% of properties which were not made subject matter of the 2001.
And stood in whose name? The property stood in
The
whose name?
property stood in the name of Shanbhog, Munavenkatappa.
No.
Now they have got it individually transferred in there. They've got it individually transferred in the name of Gundappa and Venkatesh Murthy. But as on the date of partition, it stood in the name of Shanbhog Venkatappa, Munavenkatappa and Shanbhog Putswamai.
As of now, it stands in the name of
The individual names. As on 2000.
third-party purchasers.
No, some are third party purchasers, some are third party. Now, Lord, interestingly, what has happened? Kindly see this one. Kindly see one more para, then I'll come to the point of view. Kindly see 18.1. In view of the acquisition, sites were given to the joint family. Those sites were appropriated by themselves. I have made those sites as, these are all developments post partition. Those sites, they ought to have brought it into the joint family. They neither divulged.
No, sites have been sold now.
Some sites are sold, many sites are remaining with them. This is, yes, this is another nature of acquisition, another nature of diversion of the properties.
No, sites have not been sold yet.
Sites have not been sold,
Not yet.
not yet sold.
Stands in the name of the preserve.
Stands in the name of the. Then, Lord, another interesting factor is, kindly see 18.4. Kindly see para 22. Para 22. How they have, there is defalcation by the Karta. Para number 22. Just one instance. Para number 22, page 148. Shall I read? The plaintiff submits that out of the income of the from the joint family properties, out of the nucleus of joint family funds and sale of joint family properties, late Shanbhog Putswamai and late Venkatesh Murthy also purchased following properties, item number 1 to 16, all situated in Chundungappe village, Tavarekere Taluk 3, Bangalore South Taluk as hereunder. Now, Lord, kindly see item number. Kindly see item number 22.4. Item number 22.4. Paragraph number 22.4. That top portion.
See, there are 15, 16 registered sale deeds.
Yes.
Which have been executed somewhere in 2006 and 7.
No, kindly see the next page, man. That's why I wanted to show your lordships. Kindly
What
see
the
the,
purchasers are doing, still it is vacant or some development?
it is still vacant. There is nothing.
Purchasers are not done anything.
No. But actually, 3 sale deeds are of 2006-7. Almost 10 sale deeds are of 92. Pre-partition. That will not kindly see at page 150. Next page.
You can't do anything.
No, what has happened? They have not brought it to the notice of the Kartas.
92 sale deed.
Yes,
the
purchase deed.
Purchase deed.
Of Venkatesh Murthy and Putswamai. That will not 150, page 150, top portion. For a moment. 150, about 22.5. Kindly see. About 22.5. Sale deed dated 19/3/92. Then 22.5, item number 5. 16/8, purchased by Venkatesh Murthy. Single sale deed dated 19/3/92. Item number 6, sale deed dated 19/3/92. Item number 7, sale deed dated 94. Item number 8, sale deed dated 14/5/92. Item number 9, 1996. So therefore, my lord,
Is it your case that you are not party to any of the sale deeds?
I am not party to any of the sale deeds. And the Karta could not defalcate or divert these numbers, these properties. He had to honestly bring forth. He is aware. Karta is aware. He ought to have honestly brought forth
You
the
admit
details.
admit the fact that he was a Karta?
We admit the fact that Venkatesh Murthy and Gundappa were in charge of the affairs. Then, my lord, there are instances I have minutely narrated how these properties were acquired, date of acquisition, why they were not brought into the family partition. Unfortunately, learned
Court says, what the court says,
court dismissed it under 7 to 11.
allowed.
Allowed the 7 to 11 and dismissed the.
Reason.
Reason is, Lord, I produced the translated copy for easier. This, kindly. There is. And Lord, this is interestingly, this is artificial intelligence generated translation, which is very good. Para number 12 may be seen. Shall I read? Court does not notice any of these circumstances, Lord. All these were mixed questions of law and fact. Whether it was suppressed or not. Whether there was diversion or not. Shall I read? Para 12. Main contention of the counsel for the defendant is that ancestral property of the entire family were divided among the wife and children of the deceased Shanbo Kutsamaya on 2/3/2001. Unless the said division is cancelled, Lord, we had not asked for partition of any portion.
Claim is for undivided.
Well, undivided. And then court says, upon examining the content, it is noted that plaintiff along with others was a party to the division deed, and their respective shares were mentioned in pages 10 to 22. Since the division deed dated 2/3/2001 has not been cancelled, suit seeking a share in the remaining properties is barred by limitation. The counsel for the defendant presented the judgment of the Honorable Supreme Court in so and so. Then not para 13.
It's notice.
Yes, not let them not alienate the properties.
Are they alienating?
They are here, they are. Because.
You had the benefit of interim order before the trial court?
Really? No, not it was as soon as the notice was issued, they filed the 7 to 11 and got it dismissed immediately.
The third party purchasers can't be restrained at this juncture.
No, not at least let the defendants, the chief defendants.
Who are those?
They are respondents 1 to 9, I think. Respondents 1 to 8. Remaining are purchasers.
Or learned senior counsel appearing for the.
But one
appellant.
issue was what has happened, Lord, is some respondents have, after I have issued the notice, they have purchased. These persons have alienated to them.
Sorry?
After I issued a legal
During
notice.
pendency.
Legal notice, after I issued legal notice. Before filing of suit. They hurriedly tried to enter into.
No, we will restrain.
Yes.
The family members, not the third parties.
Yes.
Or the learned senior counsel appearing for the appellant.
Lord, that could be kept open at least.
The appeal is against an order rejecting the plaint at the threshold, full stop. The suit is one for partition and separate possession. Learned senior counsel would submit that though the partition has taken place in the year 2001, the said partition was not a complete partition inasmuch as the Karta of the family did not disclose all the assets of the family, full stop. Thus, the suit is filed claiming partition in respect of the properties which are not part of the earlier partition, full stop. With the further submission of the learned senior counsel appearing for the appellant that there is an imminent threat of alienation of the properties by the respondents. Having perused the papers, this could be the view that defendants number 1 to 9, who are the family members of the appellant, 1 to 9 or 1 to 8?
1 to 9, respondents 1 to 9, and defendants 1 to 9.
Respondent number 1 to 8.
1 to 8, Lord.
1 to 8, who are the family members of the appellant, are to be restrained from alienating the properties standing in their name till next date, full stop. The relief in respect of other respondents will be considered after the appearance of the respondents.
Alienating the scheduled properties.
Scheduled properties. No, only standing in their name.
Yes.
So scheduled property standing in there.
Yes. Obliged.
With your lordship's permission, serial number 35. Well, it's the second appeal, well, it is for office objections. Your lordship may grant 10 days time to comply with office objections. 35.1.
My apologies for the interruption, my lord. Serial number 78. Lords may kindly, we are for the respondents, my lords may kindly grant 2 weeks time, my lords. The arguing counsel is not available.
You are for the
Respondents, my lords. Serial number 78.
respondent in the appeal.
Please, my lords.
Serial number 33, my lords.
Appear for the appellants, please.
There's a connected appeal. Your Lordship may have this matter next week, my lords.
Yes.
Serial number 35, 10 days,
Much obliged.
obliged.
My lords, for the first respondent, my lords.
Yes.
My lords, on the previous occasion also, without informing, they've taken a date, my lords. At
Item
least
75, Council. Is it likely to reach today?
a definite date may be fixed.
Yes.
ಹಲೋ ನಮಸ್ಕಾರ ನಾಗೇಶ್ವರ ಮಕ್ಕಳಿತ್ತು ನಂಗೆ ನಿನ್ನೆ ಮಗ ಒಬ್ಬ ಡೇಟ್ ಮಾಡ್ಕೊಂಡಾನ ಹಂಗಾಗಿ ಅದೇ ಗದ್ದಲದಾಗ ಇದ್ದೆ ನಾನು. ಇಲ್ಲ Court proceedings are mute, my lord.
R2, R3, 5, 7, and 12, R2, 3, 5, 7, 7 are the tenants who you have vacated the scheduled property and they are no longer there. So I am filing the member.
They contested this suit before the trial court.
Now they have vacated the property. Now you have the possession of R2, 5, 7, and 12.
They can't be deleted. Notice can be dispensed with
Much.
at your risk. Memo is filed to dispense with the notice to respond number 2, 3, 5, 7, 12, and 16 and 18. Memo is taken on record. Notice to aforementioned respondents is dispensed with at the risk of the appellant. And R15 is dead.
R15 has been dead and already R15 sold LR who is R15. He has been placed on record before this honorable court.
It is further submitted that respond number 16 is the legal representative of DC's respond number 15. Memo is filed to this effect. Memo is taken on record. Appellant to carry out necessary amendment.
Respecting the lordship, as I mentioned, that steps to be taken with respect of this is R16 that has been mentioned.
R15.
R15 has been reported as dead.
Correct. R14 is the alarm. 16 is the alarm.
Yes. Your lordship, two IAs have been pending before this honorable court. IA number 1
Not listed.
and IA number 5 is also there.
List this matter along with pending applications. Next week.
Paid PF Miller to the R2 to R5 today. So far as extension is concerned, Miller, the interim order is granted till the appearance of the respondents. Therefore, interim order requires to be Miller extended.
Next week. List this matter next week. Interim order stands extended till next.
To R21 dispensation.
Notice of notice is not yet complete.
Your serial number 57, my lord, I undertake to file wakalat for respondent 1, my lord.
1, 2, 3 is 4.
4, 5 to 21.
Special and acquisition. 4 is
special and acquisition. Yes.
No dispensation.
Government advocate.
R4 who appears?
R4 is a special and acquisition officer. Then government advocate will probably appear. The Lordship will permit me to serve them and inform.
Appellant is permitted to serve the copy of petition to the learned government advocate appearing for respond number 4. Respond number 4.
Service agide sir, serve anta torisiದೆ.
All right.
R1, I undertake to file wakalat.
Give a copy, please.
Next week.
There's a dispensation of respondents 5 to 12.
21. 5 to 21. 5 to 21.
They were not.
No relief is sought against them.
They are
It is submitted that no relief is sought against respond number 5 to 21 and memo is filed to dispense with the notice to the aforementioned respondents. Notice to aforementioned respondents is dispensed with at the risk of the petitioner.
They are members of the society itself, pro forma.
Next week. None appears, week's time granted. None appears for the appellant, week's time granted to. Then that means there is no stay order.
Then there is no interim order. It is a conditional order.
Week's time granted to the needful.
Right, appear for the appellant in this matter. As a matter of fact, this matter, your lordship had indicated your lordship would hear this matter because there's a short issue.
a claim not made is awarded by the court.
Today is to be heard?
Not today. It was before this confusion of single judge and division bench. Not then your lordship is
Next week.
next week. That I'll show your lordships not the, I won't, on the main matter itself.
So this is the award amount, decree.
No, no, the decree.
How much percent?
No. 50 lakhs was supposed to be deposited. We couldn't muster the entire amount of money. 5 lakhs was paid to him. 20 lakhs was deposited. The total claim, my lord, in the court
is a conditional order.
Conditional order. But the total claim, my lord,
As there is no stay now.
now right now there's no.
So he can withdraw that amount.
He can't, my lord, whether he can withdraw or not is another issue, my lord. Whether he can, of course, through execution, he may be able to. What I'm respecting.
Can file execution and seek attachment of this order.
He can, he can, that he can. But what I'm respectfully saying is, claim is for 10 lakhs. Award, my lord, is some 1.5 crores.
What is admitted component?
Beg your pardon, my lord?
What is admitted component?
No admitted, everything was disputed. The litigation is fought, but when the judgment and decree comes, decree is for 1.5 crores.
It come next week.
We'll argue it, my lord. I'll not take more than 5 minutes in this matter. I just have to show your lordships the plaint and the order. That's all. Can I request a date, my lord, next week? Wait, I'm good.
Week's time granted to do the needful. 61. Same order.
For petitioners, appellants, kindly pass over, my lord.
Sorry?
Kindly pass over, my lord. Senior advocate.
R2 service is not yet complete on R2. Let it be listed after.
My lord, I completed.
A notice is still awaited.
Yes, my lord. 2 to 4.
Let it be served. 2 to 4.
Yes, my lord.
List this matter after service of notice to respond number 2 to 4.
Date may be given, my lord.
Serve Abakala.
Acha.
Week's time granted to do the needful.
In this case, I am for the appellate. So for a second respondent inspection, notice will be dispensed.
Dispense Marbaka. No relief is sought against them. Who is second respondent?
So he is brother of the appellate, second appellate. Sister of the second appellate.
Appellant. It is submitted that no relief is sought against the second respondent. Notice to respond number 2 is dispensed with at the risk of the appellant. So the copy.
Serve the copy. So it is come in the arts because there is a defect in the case. There is an extreme urgency as the decree.
What is the decree? Decree for injunction.
Amount directed to deposit. Amount is money suit. The agreement was under sale deed executed. The case was that so possession was not clear.
13 lakhs recovery. Execution filed. Deposit 50% of the amount. All right. So the copy. Yes. This next week.
Basic. Valuator's report in order to censor what is the value of the property I am offering for security to the degree which has been passed by the traffic.
The same property which is subject matter of one more suit or appeal.
It is not the subject matter. It is not the subject matter.
Attached.
It is the property is not the subject matter of the other appeal.
Can it be taken next week?
They on their own appropriate towards them, for the reason that they cannot dispute that. Now they appropriate the amount paid towards the common daily charges towards that and say that no, there is no from the, because there is no separate.
No, if you want to pass on an order, then it requires little bit of hearing. We'll pass over or we'll take up next week. There are so many cases pending today. Next week. No, there is a direction to deposit rupees 1.5 lakhs.
Yes, we are depositing that amount also. Court has granted 3 months for me to deposit the 50% of the amount. I will deposit it. And the remaining 50% in another 3 months, I will deposit.
Let it come next week. Let's this matter next week.
File our memo of calculation. They are filing a memo of calculation. Or they will be given, we will file our memo of calculation.
To file it in the registry. Learned senior counsel appearing for the. There is already a direction.
Already the order is being passed. To open the key. Already order is being passed by the lower.
Just a second. This is key. No, premises locked by whom? By the court? By the in terms of order dated 10/7/2024, this court has directed the executing court to hand over the keys of the premises to the respondent. Full stop. Learned senior counsel appearing for the respondent would submit that the premises was locked at the instance of as per the court order, and the bailiff be directed to open the lock. Full stop. You should not have any objection for this. Since the premises is locked in terms of the court order, the executing court shall issue necessary direction to the bailiff to open the premises. Sorry?
Mobiles will be handed over to us.
You admit? Yes.
Whatever the documents are, other files, everything are there in the premises. If those movables, whatever are present.
No, you want to attach these documents which may contain some more liability. The learned senior counsel for the respondent submits that he has no objection for the appellant to collect the movables which are not subject matter of the attachment. You file it in the registry. File it in the registry. File it in the registry.
Only difficulty the matter is coming up before the trial court.
Trial court for?
It's for filing admission and denial affidavit. In this matter, the Section 8 application has been rejected by the trial court.
When is the next date?
24th.
20?
Yeah.
On
In fact, I received it on Friday evening. I served it on Saturday morning.
so you wanted the application to be rejected on the premise that there is no arbitration. You wanted the matter to be referred to the arbitrator.
Yes,
But that is rejected
That is it.
on the ground that there is no arbitration clause.
There is no valid agreement between the parties. Is the observation of the trial court.
No, suit is at what stage now? Nothing will happen.
Admission and denial affidavit happens.
All right, the suit won't be decided.
Even then, that's, if in persons of the order.
This can, no, this can come up next week. In 1 week, the suit will not be decided.
Not be decided, again, I have to file my affidavit in denial. If I lose the opportunity.
If this court holds that the court is having jurisdiction, your affidavit will not be a waste. Next, let it come next week. This is matter next week at the request of learned for the respondent.
Let me make a request with that. Just to have an adjournment.
Don't compel him to,
And also, let them
that's
also
all.
take it.
Next week.
Directing me to deposit 5 lakhs. And covered with an interim order of stay.
You're seeking extension now?
To be able to deposit that, an application is made, filed, seeking for little intervention of the court's indulgence.
How much time you want?
I just need another 3 weeks more.
3 weeks.
So,
Now, how much time was granted earlier?
Series of tragedy has taken place in his family. Series of tragedy has taken place in his family. That is the reason why I am seeking for.
Can we extend it? Can we extend it? It's 2 weeks.
Why should not my lord can walk an extra mile and grant me 3 weeks?
We wanted to give 1 week time. We walked extra mile and gave 2 weeks.
Because series of tragedy has taken place in his family.
1 more week, sir, as a last chance. Now we'll make it clear that no more extension. Yes. This court video order dated 7/6/2024 has directed the appellant to deposit ₹5 lakhs. The amount is not deposited within 4 weeks as ordered earlier. An application is filed seeking extension of time. On considering the grounds urged in the affidavit, 3 weeks time granted to deposit the amount as a last chance. It is made clear that no further extension shall be granted.
Plus, my further submission is interim order to continue.
Interim order.
It is restricted to this day, otherwise warrant will come back to life.
Interim order stands extended till next date. Office objections to be cleared. This week's time granted. Suit for? No, suit for what? Eviction.
My lord, serial number 72, my lord.
No, last time, I think he opposed the motion for adjournment. Sorry? What are the office objections? One week as a last chance, 1 week as a last chance. Sorry? You are not pursuing an appeal against the rejection of counterclaim. Shall I record your submission that you are not pursuing the claim made in the counterclaim? Learned counsel for the appellant submits that the defendant's appellant's counterclaim is rejected by the trial court, and he is in appeal only against the decree granted in favor of the plaintiff. Submission is placed on record. Week's time is granted to comply the office objections, remaining office objections. When is the next date? It is further made clear that this court has not granted any interim order in favor of the appellant. Don't advance the case. All right. All right. All right. All right. All right. Then appears for the appellant. This matter of 2 weeks.
Serial number 72, my lord.
Yes, 72.
Yeah, I'm appearing for the appellant, my lords. May I kindly have it on Monday or Friday, this Friday, my lord. This is the execution is filed. The appeal is filed by the BESCOM authorities, my lord. The attachment
What are
more
the office objections?
I'll pay, my lord, 3,440 rupees court fee is the deficit. Tomorrow I'll pay it, my lord. My lords may kindly have it on Friday, my lord.
When is the next date in execution proceeding?
The execution proceedings already they have issued the attachment and it is posted in the month of August end, my lord. They have issued the attachment already, my lord, for the
Attachment of
reason.
movables.
Yes, my lord.
Is it executed?
Not yet executed, my lord. They, at any time they may come for the execution. For that
Comply
reason,
the
I'll
office
pay the court fee
objections, it will
tomorrow
come on
itself.
Monday.
Hmm.
To comply the office objections, it will come on Monday.
Much obliged, my lord.
Appellant to comply office objections by then.
My lords may kindly have it on Tuesday, my lord.
Tuesday.
Much obliged.
30th. Yes. Continue. Continuations, number 28, B.V. Krishnappa.
What is the office objection?
Complete the office objections.
Complied.
DPA hold copy to be.
No, it is on the KV to petition order.
Give it.
Yes.
Objections on CP.
Suit is dismissed.
So it is this filed by the plaintiff. How the appellant before the trial court was seeking cancellation of the general power of attorney executed in favor of first responding. In the course of cross-examination, one more document has been introduced by very same second respondent, was happened to be purchaser of the judicial property from the first respondent, based on the Register General Power of Attorney executed by appellant hearing in favor of the first respondent.
You admit the execution of power of attorney?
We admitted the execution of power of attorney.
Then
the point is, at the same time, a document styled as a sale agreement got executed by very same first respondent hearing clandestinely, without the notice of the appellant hearing. Wherein, in that particular sale agreement, it is categorically mentioned, the value of the property was 24 lakhs plus 90,000 something, under which it is mentioned to be paid 24 lakhs 80,000 to the appellant hearing. Remaining 10,000 was retained by the first respondent to be paid at the time of execution of absolute sale. Till that, the possession of property has to be retained by the appellant hearing. This is the agreement which has been confronted during the course of cross-examination of appellant hearing. Till that, no single plea, no single defense has been taken by the very same second defendant, who was the only contesting defendant for the trial court.
so your contention is that you are in possession.
Exactly, Manoj. A possession never handed over in favor of the first respondent hearing on by issue of the.
What is the nature of the property?
Agricultural land.
You had the benefit of interim order before the trial court?
No, Milord.
Notice served on the respondent?
No, though notice was served on the KVTR, but by the time when the appeal has been presented, the time was elapsed.
Where is the counsel for respondent?
What is happening? We have showed the copy. We have the endorsement also.
Shall we issue emergent notice to respondent?
The only thing is, my lord, based on the judgment, the second defendant on the is henchmen are trying to dispose me from the seized property. That is the difficulty what the appellant is facing now.
But there is a registered sale deed in their favor.
In favor,
These property records stand in their name
yes, but exactly, my lord.
since 2006.
2015.
15. Let there be an emergent notice.
No, if the interim order is granted, nothing is going to be lose by the
Now, how to
second
give a
respondent.
prima facie pending that you are in possession? Registered sale deed in the name of the defendant, property records in the name of the defendant since 2015.
Please, I do agree with
There
the
was no
honorable-
interim order in your favor
Only thing
before
is,
the
my
trial
lord,
court.
according to the latest introduction of the alleged sale agreement, wherein it is categorically says that until unless complete sale consideration pass on to the appellant, the possession is with the appellant by itself. That is the that is the document which is categorically speaks. That means to say, even till today, the possession of the property still within the appellant custody marriage. Not complete sale consideration. If it is believed to be, there was a transfer of the consideration as mentioned.
Where is the power of attorney?
No, I don't
agreement?
possess the document. It is a trial court.
Where is that agreement?
I will get the documents. I don't possess the document right now.
3 registered GPA. E8 registered sale deed.
Agreement is
Same day, my lord.
dated earlier to the power of attorney.
8.
Sorry?
On the same day when the GPA was executed in favor of the.
Power of attorney as well as agreement on the same day.
Exactly, my lord. That is the doubtful. Moreover, my lord, according to the plaintiff, appellant hearing, she questioned the execution of general power of attorney wherein she sought for cancellation of the alleged general power of attorney because whatever power delegated to the first respondent was not being complied with in accordance with general power of attorney. As such, she wished to get cancelled the general power of attorney. Till during the course of class examination, the execution of alleged sale agreement was kept under concealment.
Just a second. Sale agreement records. What is the consideration mentioned in the sale agreement?
24 lakhs 90,000.
24 lakhs.
24
Sale
lakhs.
deed?
Sale deed 29 lakhs, 31 lakhs.
How much you have received?
No single paisa, minutes. No single paisa has been paid to me under the alleged sale agreement. It was an.
Then you should have filed a suit for recovery of money.
No, my lordship. Even though when I did not execute the sale deed as required to be executed of the general policy sale agreement,
should have filed a suit for recovery.
Interesting agreement amount of the plaintiff after the is in possession and joining. First one shows the transaction statement.
See, if your agent has not paid the money to you,
yes,
you should proceed against the agent.
That is what, my lordship. First respondent is
against the purchaser.
The first respondent.
Not disputing the execution of power of attorney.
I'm not disputing the execution power of attorney, but I'm seriously disputing the amount said to be paid to me under the sale agreement, which is got executed.
That is dispute between you and your agent.
My agent.
Ah.
And moreover,
purchaser can't be penalized. Emergent notice. The suit itself is not maintainable. Sorry. Your remedy is to file a suit for recovery of money against the agent.
The only thing is
in the power of attorney. You're not disputing the sale deed.
We are
What you are saying is your agent has not paid the amount to you.
Moreover, my lordship, the whatever sale agreement came into executed, it's a excess of undue influence. That is my case.
Those things later. Emergent notice.
Please.
Not a case for emergency.
29, Muniraja.
Suit for partition matter. Appealed by the plaintiff. Suit is dismissed not on merits, but on an application filed by the third respondent, defendant, under Order 7 to 11A.
Yes.
Now, there are only two properties. One of the properties was purchased by the husband in the name of the wife. Whether that property becomes wife's or husband's. That is one aspect of the matter, my lord.
Secondly, other property-
Relationship.
My lord.
Tell about the relationship of the parties.
Relationship. My lord, first respondent, now of course, after filing of this appeal, she died. She is the mother of the plaintiff number one, rather appellant number one.
Come to page number 19.
ಮಧ್ಯದಲ್ಲಿ ಹೇಳಿದ್ರೆ ಹೆಂಗೆ ನೀವು? Just wait till I say. The plaintiff, my lord, or I will put it as appellant, is the daughter of the first respondent. Understand? Now she is deceased after filing of this appeal. The second respondent is a daughter of the first respondent. Similarly, third respondent is the son. Fourth respondent is the daughter.
All right, as on the date, in whose name the property stood? As on the date? As on the date of the suit, the property was standing in whose name?
The property, of course, stood in the name of the Rangamma, that is the deceased first respondent.
All right,
There is no dispute of
all right.
Question is only,
So the property belonged to Rangamma.
yes.
How she acquired?
Now, one property by inheritance
From
the father, grandfather, like
her father.
the other one, husband purchased it in her name.
As far as one property which she had inherited from her father, the suit is not maintainable during her lifetime. Right?
Now that question may not arise
Because she is no more now. Yes,
She is no more.
correct.
And with respect to that property, at least,
The
there
suit-
should be a partition.
Correct.
And
The plaint
No.
can't be rejected in its entirety.
No, as on the date of the order passed, it is legally valid.
It's too technical
Now,
now. Subsequent
situation might
development.
have changed.
Subsequent development.
Now the situation is, kindly see para 3 and para 4 of the plaint. They admit that the suit schedule property item number 1 is purchased by Rangamma. So it is under the sale date. So section 14 of Hindu Succession Act applies. It's her absolute property. Insofar as item number 2 is concerned, she got it from her mother, not the father. Her mother purchased it.
Whatever, now she is no more.
She gifted it.
Question opens now.
But as on now the suit will be decided as on the date of the suit. Now,
You're asking
there
them
is
to
no
find
further
proofs.
development. Insofar as the first item is concerned, she has already executed a gift deed in favor. That is also mentioned in the plaint itself, in favor of respondent number 4. So therefore, as against that property, suit may not survive.
No, first property means.
Item number 1.
Property inherited from,
She purchased by her.
purchased. During pendency.
No,
No,
earlier.
earlier.
After that,
Her
suit
case
is filed.
is, she was a homemaker.
She is
She had no
gifted
income. It is
that
the husband who purchased it, and therefore she cannot be said that it is her absolute property.
The donee is also made a party.
Dhoni is also made a party. Dhoni is also.
Suit has to be tried now.
My lord, there is one decision of the apex court which says that by whatever way the property is acquired by a woman will become her absolute property.
That's understood.
Yes.
In respect of another property.
In respect of other property, now situation is changed.
Yes.
So, in fact, though the order valid as on the date of that may be shown and
Correct.
he may be given an opportunity in so far as.
Correct.
Second property.
So when the suit is being tried for one property,
Yeah.
let there be a trial for one more, another property also.
No, it may not because that will displace the
All right, if
deed
you-
executed by the
Okay,
mother.
If you have stated
Yes.
that the property is purchased by Rangamma, then there ends the matter.
Husband.
You have stated so.
Yes.
Husband. So many.
So even then it becomes season of property.
Yes.
It's in the nature of a gift by the
Therefore, I
husband to the
submit
wife.
to my lord whether property purchased in the name of the wife by the husband, whether it could be said it is the absolute property of the wife or the husband. On that issue, I just pass on one judgment.
See, section 4 of Benami transactions.
Benami transaction.
Yes. Property, purchase of the property in the name of wife is permissible, spouse is permissible.
Yes.
It is not hit by the provisions of the Benami transactions.
Yes. Even then, my lord, the section 14.
Now, section 14 will apply in a situation where the property is given to a lady in recognition of her pre-existing right and limited right is given.
No,
This is not a case of limited right.
Exactly that point is considered by the Supreme Court in reported in 2009 to 15 SCC 756, which in fact relayed by before the trial court and
Purchased by the property, with the husband and wife. That property or- Hmm.
This judgment is rendered probably after considering the evidence on record. For trial, this judgment is rendered. Now, for this reason, probably it requires trial.
But ultimately they have interpreted section 14. That's why section
Based on
14 of,
evidence. No, based on evidence.
no, evidence is ultimately the property is purchased in the name of the wife, whether it is absolute property or not, is the only question that is ultimately considered by the Honorable Apex Court.
Is it only purchased in the name of the wife or is it purchased by the wife? That requires a trial.
Even if it is in the name of the wife or purchased by the wife, in both the cases, if it is purchased by the wife, there is no necessity of section 14(1). But if it is purchased in the name of the wife, then this issue may arise, whether it is an absolute property or not. That has been considered in this judgment.
Which paragraph?
The question, the facts I will show para 2, my lord, and then I will come to para 9. Para 9, they have considered 14(1). The dispute arose out of the partition filed between these Nagaratnama, wife of Srinivas, Hemalata, who was the minor at the time of filing of the suit in 1992. Plaintiff was the only child of the plaintiff number 1, who was her mother and natural guardian, and she represented the plaintiff number 2. The plaintiffs and respondent number 1 and 2 before the court. This suit was filed for partition, claiming 1/3 share in the social properties and also claiming separate possession by meets and bounds and by mean profits and other incidental reliefs. The first defendant in the suit is the mother-in-law of the plaintiff number 1 and defendant number 2, 3, 4 are the daughters of defendant number 1 and defendant number 5 is the son of defendant number 1. Defendant number 6 to 14 are the tenants in the properties. The plaint case is that Gangama, the father-in-law of the plaintiff, expired in 73, leaving behind his wife, three daughters and 2 sons. The genealogical so and so. The suit properties. Para 5, very same point is considered. The first defendant, being a housewife, had no income to purchase the property.
No, that's a matter of trial. Whether she had income or not is a matter of trial.
That exactly is a question.
If I may be permitted.
One
to-
aspect. Second aspect, probably.
Yes.
If she is in exclusive possession of the property.
Yes.
Then probably we may take shelter under section 14(1).
Yes.
If rest of the family members are also in joint possession.
Yes.
We don't know the real aspect. That will come out only in trial. Then probably section 14(1) has no application.
But my humble submission is once if it is acquired in the name of the wife, that is the point considered here. It will become her absolute property. If it is purchased by her, the question of applying 14(1) will not arises. If it is only purchased in her name by husband or by father, whoever.
As a Benami.
Benami strictly may not be applicable. Even then.
Benami Transaction Act came into force, prohibition came into force in 1988. But still, it recognizes the purchase in the name of the spouse.
Yes.
So there is a later enactment.
So that may not be applicable. Now the question is, once it is acquired, whether it will be her absolute property or it is available for partition. That is the point involved in this decision.
No. You are referring to section 14 to say that it becomes her absolute property.
Yes.
That is 1956 Act.
Yes.
This Benami, section 4 of 1988 Act recognizes the purchase of the property in the name of the spouse. So what is the implication of section 4 on section 14? That requires consideration.
Then that may be heard by your lordship, because anyway trial court will not be in a position to say anything.
No, trial court
I will
will-
assist the court in that regard. In that, because I am not fully
In
prepared
addition to
today.
all that, my lord.
On that point. Even if it is in 88, even if it is not applicable, according to me, my humble submission, even if it is not Benami transaction is not applicable, in this case, which I also agree, it is not applicable as per the provision section 4.
No.
Even then, the question remains is whether property which is in her name is available for partition or not between the family members, and which she has gifted.
My lord, apart from all this,
See, section 14(1) would apply in a situation where the property is held by a lady as a limited owner.
No, both.
You must demonstrate.
No, that is also now settled. Now it said as a limited owner as well as the purchase. That's why it's section 14, your lordship may kindly see. That's why I read paragraph 5 of the facts. In the facts, the contention taken is house has, the wife has no income of her own and property is purchased in her name. That is the contention taken in this facts of this case. And then section 14 is referred and law is laid down. Law is laid down. So therefore, this, that may, of course, if not today, it may be heard on some other day also.
while considering application order 7 rule 11, my lord is aware, only plain reading of the plain should be looked in, not the
He
defense.
says the suit is barred under law.
No, even going by the principle my learned friend has said, para 3, para 4 discloses this fact.
Only under 7A, they have put it as no cause of action. Whether while deciding that application, the learned judge could look into the defense or to go into only plain reading.
If you are saying that the property is purchased in the name of a wife or in the name of a woman,
yes,
that itself is sufficient to say whether the suit is barred or not under section 14(1). Further pleading is not required.
I think this judgment which I just cited says otherwise.
Husband is no more.
Husband is no more.
No, husband is no more, now wife is also no more.
So implication of section 4 is the property purchased in the name of the wife by way of a benami transaction. Though the property stands in the name of wife, actually it's the property of the husband. So the husband has died, so the succession has opened. That is the case.
That is his case. That's where insofar, that's why I said, insofar 2 properties are concerned, one property is, though it is also taken by her from her mother, still it is available because she has not settled that property in favor of anybody.
There is no
Insofar as item number 1 is concerned, it is settled.
Into section 14. Section 4 yields to negative matter of right. 4 yields to section 14.
So only section 14 is involved, it may be heard and disposed.
The question is whether section 4
yes
overrides section 14(1).
That's what I am
4
not
yields
I am not ready on that point today. Therefore, one date may be fixed. I will try to pursue your lordship.
It's this matter after 2 weeks.
Okay.
In the meantime, I have made a request for interim order. They should not alienate the property.
Weeks time.
ಇಲ್ಲ ಅಲ್ಲಿ ನಾನು alienation ಮಾಡ್ತಾ ಇಲ್ಲ. That may be. Assuring him. Till that date, my undertaking will be.
Learned comes for the appellant apparents that the respondents may.
ಅಲ್ಲ ರೆಕಾರ್ಡಿಂಗ್ ಬೇಡ. ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಕೋರ್ಟಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅದಕ್ಕೆ ರೆಕಾರ್ಡಿಂಗ್ ಬೇಡ. ಯಾಕಂದ್ರೆ ಅವರಿಗೂ ಅರ್ಜೆನ್ಸಿ ಇರಲ್ಲ ಆಮೇಲೆ.
ಅದಕ್ಕೋಸ್ಕರ there could be interim order when we see.
2 weeks ನಂತರ ಬರಲಿ. I am ready. It is not that ಈ ಪಾಯಿಂಟ್ ಅಲ್ಲಿ I have not seen that. So I requested for this.
Is it
2 weeks?
Not to alienate.
ಮಾಡಲ್ಲ ಅಂತಲ್ಲ.
ಅಲ್ಲ ಸುಮ್ಮನೆ ಹಂಗೆ ಹೇಳಿದ್ರೆ
ಗಿಫ್ಟೆಡ್ ಮೇಲೆ
ತಾವೇ ಹೇಳ್ಬೋದು, not to alienate. ಯಾಕೆಂದ್ರೆ ಅವರು
ನಾನೇ
ಅಕಸ್ಮಾತ್
ಅದು ರೆಕಾರ್ಡ್
ಏನಾಗುತ್ತೆ
ಬಂದ್ರೆ
ಇವತ್ತು-
ಮತ್ತೆ ಏನೇನೋ ಕಾರಣ ಕಂಟಿನ್ಯೂ ಆಗ್ತದೆ. I cannot
I have got
proceed.
full confidence.
Therefore,
in
now
my
I
client. What I respectfully submit is.
I will instruct my client not to deal with the property from this day till the
ಅಷ್ಟೇ ಹೇಳಿದ್ರು
next
ಸಾಕು.
hearing date.
Then ಹೇಳ್ತೀವಿ.
ಅಷ್ಟೇ ಹೇಳಿ.
ಅಲ್ಲ,
Not record your statement. We will record his statement. We will also record that you opposed it.
no, I have not even filed the objection, so that maybe.
Till filing of objection.
Yes.
Beg your pardon.
Till filing of objection, yes. Learned counsel, the appellant submits that there is an apprehension of alienation of the properties by the respondents. Respondent, counsel for the respondent seeks short accommodation to file statement of objection. The property shall not be alienated till objection is filed.
Great. Great.
Krishnamurti Amma.
I am for the appellant.
For the respondent, please.
Plaintiff's appeal against the dismissal of the suit for declaration and possession in respect of the B schedule property. The B schedule property is part of survey number 28/1 and 28/2 of Nagarur village. The property was sold by one Channigappa in favor of Yogananda and his sister Vijayalakshmi under exhibit P2. Subsequently, SR Yogananda sold this property in favor of BC Chinnappa. Under exhibit P4 dated 12/4/1990 sale deed, this BC Chinnappa sold this property in favor of one of the appellants, Asha Uttam Chandani. In the first sale deed at exhibit P2, the western boundary is correctly shown. Now, records are not before you.
Records ಬಂದಿದೆ. We'll call for records before admitting the case.
Record ಬಂದಿಲ್ಲ.
Suit for possession dismissed. You are in possession.
Suit for possession and injunction has been dismissed. The short point to be considered is whether the boundaries prevail over the measurements. That is a settled law. Only that point is to be considered. My client is 84 years old. Records may be called for. The matter could be
Your
admitted.
contention is boundaries prevail over the extent.
Boundaries prevail over the extent.
What is the extent?
Extent is, my lord, under the sale deed, it is undisputed that I have purchased 8 acre 11 gunta. The question is whether my property is bifurcated by a road and the western boundary is the road, or beyond western boundary, I have the property in survey number 28/2. That is the only dispute. The boundary prevails,
Malas,
there's an
on the
undisputed
eastern
principle.
side of my property, there is a road.
Proposition of law is now little bit diluted.
Please,
You cannot stretch that proposition to a large extent to
I
say
do,
that.
I do understand. Malas, on the eastern side of my property, there is a road. On the western side of his property, there is a road. The road bifurcates the property belonging to the plaintiff and the defendant. Plus, taking that particular issue, please do not. The boundary being the road, please do not. This 1 acre and 15 guntas falls within the ambit of my property. And he claims that it is his property beyond the road. That is not, please do not, is not established.
All right,
Therefore,
anyway, you are in possession now.
I am in possession since past 42 years.
Correct. Now, we'll call for the records. We will not admit the appeal as.
Please do.
Call for records.
Some date may be given, please.
5th August
Short date,
29. That's right.
please.
Bangalore.
Nelbangla.
29.
In the sale deed, the roads are mentioned on either side.
Plus, in his sale deed also road is mentioned.
It
In
is
my
correctly
sale deed-
mentioned, I have the property even beyond the road.
Question is whether the road is shifted or not.
It is not shifted. What the government does.
So please.
29. Next Monday. 31st, 31, Gangadarappa AV.
Appear for the
Good for?
food for declaration, declaring that the general power of attorney registered, executed by defendant number 1
Null and void.
in favor of defendant number 2 are null and void. And the sale deed executed by defendant number 2 in favor of defendant number 3 is null and void. Now, the suit in the present forum is not maintainable because they are not the persons who executed the document. How can they seek for holding that the documents are null and void? I can understand if they have.
Are they claiming under the executant?
Pardon me?
Are they claiming under the executant?
Yes, yes, they are claiming under the executant. Who is defendant number 1? Who is defendant number 1? They are parties to the documents executed by defendant number 1 as witnesses. And there are other documents to show that
What
they
is
are
the property?
aware.
What is the property? Nature of the property?
Nature of the property is, as on that date, agricultural land. It was a revenue site within the city of municipal, Tumkur, measuring 20 guntas under 2 registered power of attorneys executed.
Now the property stands in whose name?
In my name. In my name.
Under the sale deed?
Yes, yes.
Executed in 2013?
Yes. How can it be? Yes, it is in my name with the purchaser of the property.
Produce the records to show that it's still in your name. It's next week.
Prayer for injunction may kindly be stayed. Injunction decree has been granted. I have been prevented from making use of my property.
No, let him.
No, let him file the objection,
to
but till
produce the
such
records.
time, I request the court to kindly grant an interim order of stay of the decree of injunction.
During the
Decree of injunction.
pendency of the proceeding.
No, there was no interim order.
No interim.
There was no interim order.
Until next date, you will stay the operation.
Yes.
Learned counsel for the respondent seeks short recommendation to file a statement of objection. Full stop. The suit for injunction is decreed. A declaration injunction is decreed and the defendant is in appeal. The defendant claims that he has purchased the property under the registered sale deed executed in the 2012 based on the power of attorney of 2006 and 2007.
Yes.
Stop. This is further contention that the executant of the power of attorney has not questioned the sale transaction.
Yes.
Under the circumstances, the operation of the decree stayed till next date.
Please.
Who is R3?
R3 is my friend's father.
Totira? Issue emergent notice to R3.
Very.
32.
Yes, correct. He is the father of plaintiffs 1 and 2.
Plaintiff's appeal, suit for a declaration of title and also for a declaration that subsequent sale deeds based on a GPA is not binding on the plaintiff and for injunction.
Suit dismissed.
Suit dismissed. Lord, it is not in dispute that the land was granted to one Krishnappa in 1975. Lord, subsequently, in 2001,
Notice and call for records.
yes, I have sought for not to alienate the property against fourth respondent. Now, in view of the decree,
Property stands in whose name?
now stands in my name.
Then how can he sell the property?
Well, they have created a parallel kata, B kata anta ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ನಮ್ದು A kata ಇದೆ. So there is hectic efforts is going on.
There is a sale deed in your name?
Sale deed is in my name.
In which year?
My sale deed, my lord, is in 2006.
Learned counsel for the appellant submits, plaintiff appellant submits that he is in possession of the property in the since 2006 based on the registered sale deed of 2006.
Yes.
However, the trial court in terms of the impugned judgment and decree has disbelieved his claim and dismissed the suit. It is further submitted that the defendant, by taking undue advantage of the dismissal of the suit, has created a parallel document showing his name in the.
Well, he created it before only.
It is his further submission that the defendant has created a parallel document showing his name in the property records and is likely to alienate the property, taking advantage of the fact that the suit is dismissed.
Yes.
Under these circumstances, the respondents are restrained from alienating the property till next date.
Please.
Urgent, 34.
Suit for plaintiff's appeal. Suit is for declaration of title and for possession.
My title is admitted. There is no dispute about my title. 1993, I purchased the property.
Dismissed on what ground? Limitation?
No, my lord, it has been dismissed on the ground that the defendant took up a plea under section 53A of the Transfer of Property Act, contending that I have executed some general power of attorney. My lord, I issued a notice to the notary public who is said to have attested that general power of attorney, and I examined him before the court. He denies. He says his signature and his seal have also been forged. Court disbelieves that
What injunction you are seeking now?
not to alienate.
Stands in whose name?
My lord, in my name, admittedly, my lord, may kindly see page 89, my lord. They
All right.
don't claim title.
All right, now the finding on issue relating to title
On
is
the
in your
basis
favor.
of that GPA, my lord, they may do so.
Just a second.
Right.
Issue relating to title is in your favor.
My lord, it is neither in my favor nor in their favor. The issue related to title has been not clearly stated.
Late ಮಾಡ್ತೀರಾ ನೀವು?
What has happened is here. Place on the.
No, you want to alienate the property? You want to alienate the property? Till next date, till you file objection.
My lord, no notice has been served, they are not cavatars.
Ivetrallo ಅವರು? But he has saved the process for you. Till next. Till then, don't sell.
My lord, in the meanwhile, it's a Bangalore of the state, Mayor Hall. The records may be called for, my lord, appeal itself can be done. I will file a compilation of the entire this thing.
All for records.
It is a 10-minute.
All for records. You appear on behalf of all the respondents. One respondent. Learned counsel for the respondent undertakes to file wakalat on behalf of the respondent.
I filed the wakalat.
Wakalat ಹಾಕಿದ್ದೀರಾ?
In the show.
Registry to show the name of learned.
Till then,
All for records. Learned counsel for the respondent seeks short accommodation to file statement of objection to the application seeking temporary injunction. Let there not be any alienation till next date.
Great.
Please. Wakalat filed before the registry is accepted. Registry to show.
$35.
And
36.
then appears just after 2 weeks. Six, 35.1, 10 days time granted to remove the.
36.
Not this week, next week. Is this matter next week?
29.
Date.
37, Kavita Damodar.
Defendant's appeal suit decreed against me, suit for recovery of rent. In the cross-examination, he admits that there is nothing payable. The trial court does not even take that into account.
You vacated the premises?
I vacated the premises long back. Earlier, once he had obtained an ex parte decree against me. In the course of execution of that decree, I vacated the premises. Then I succeeded in getting the decree set aside and the matter was remanded only for rental recovery. He comes and then amends the plaint and says, I also have some license fee recovery, etc. It is my defense in the suit that the rent was never at 2 lakhs, it was only at 30,000 rupees. My lord, you only see the cross-examination which has been completely ignored by the trial court.
No,
The
what
judgment reads as if there has been no cross-examination.
What the agreement says on the rental amount?
2 lakhs. 2 lakhs. The agreement says 2 lakhs. In his evidence, he concedes that the entire premises was not given to me. And therefore, between us, there was an arrangement that it should be only 30,000. It is his evidence. At least the trial court must advert to it if nothing else.
So if it is taken as 30,000, are you in arrears?
I'm in surplus. I'm in surplus. And the only evidence as far as payments and debits and credits are concerned is a self-prepared statement produced by him as Exhibit P1. That also is not tenable evidence. There is no bank statement. There are no rent receipts, nothing.
No,
His statement.
Where is the admission that the rent is
Yes,
only
ma'am.
30,000?
My lord, at page number 6, the last paragraph at the bottom, internal page 6. It in the cross-examination, my lords.
Running page?
My lord, I produced it separately now. I just gave a copy now. Separately, I just gave, madam. What is that? That. Yes, yes. Internal page 6. Last paragraph. It is not correct to suggest that as I started using the part of the suit schedule property, I reduced the rent to be paid by the defendant. Witness volunteers that as the defendant has requested to reduce the rent as you are suffering loss in business, I had reduced the rent to rupees 30,000 per month. It is not correct to suggest that laundry service business is in the basement of the so-and-so. Witness volunteers that it is in the third floor of the suit schedule property.
And
It is
how-
his case.
And how this evidence has been dealt by the trial?
Not even referred to. At least if it were adverted to, I would have some case to answer. If the records are called for, the trial court decision has to be set aside. And where the witness says reduced to 30,000, the trial court says reduced by 30,000. There's a world of a difference between to and by.
Reduced to 30,000
Out,
for how long?
out of the total,
For how
out
long?
of the total
Well,
rent,
in the
total rent and license fee,
re-examination, that also
he has
comes to
reduced
my rescue.
30,000 only.
From 2015, in the re-examination, the plaintiff's advocate itself elicits the admission that it is from 2015.
Well, out of the total rent and license fee, he has reduced only 30,000 rupees. 30,000 rupees, not for entire amount, rent is
No,
reduced to
come
30,000.
Come to the suggestion, or sorry, re-examination. Rate of applicability of the reduced rent, which I stated in the cross-examination, was rupees 30,000 from 1/10/2015.
Yes, my lords, out of the total sale consideration, to total rent and as well as the license fee, there should be a 3 lakhs and add by the time.
For this
But-
re-examination, just a second, for this re-examination, there is no cross-examination.
No, further than that, I was more than happy with this admission. Because the suit is of 2019.
Out of the total, he is trying to confuse this honorable court, my lords. Kindly see the judgment.
One second, just one last submission.
My lords,
Suit is of,
my lords.
one last submission, 2019 suit. His claim is for arrears from 2014-15. That itself I said is barred by limitation. At best, you could have asked for from 2016 onwards. If the suit is of 2019. Even that is ignored by the trial court.
So from 1/10/2015, you are not.
I'm not even liable to pay. If the suit is of 2019, at best his claim against me could start from 2016. And if the rent is at 30,000 rupees, I have already paid excess.
When did you vacate the premises?
2020.
In the execution premises, we have taken the
First round it got.
warrant and we have got the property
First, how
by
the trial
process
court-
of law.
how the trial court has dealt this part of the cross-examination and
Only my lordship, it has been considered that out of the total rent and lease fee, out of the total 3 lakhs, the plaintiff has reduced 30,000 rupees. So still 2,70,000 rupees he has
But
the able to
in
pay.
page
That was the
14
observation of the trial court.
In page 14, para 23 of the judgment. Quantum of arrears the trial court.
how can anybody reduce the rent from 3 lakh to 30,000?
2 lakhs to 30,000 because.
Because his request we have heard,
evidence-
that to come, that
evidence
mistake we have
shows-
committed.
the
He has taken
evidence-
advantage of that words.
The evidence shows that although the entire building was promised to me, half the building he took away for his own purposes, laundry services and other things. I have produced photographs. He admits it.
Then also it should be 1 lakh, not 30,000.
There were other arrangements also, but the fact of the matter is that I had to make check payment of 30,000 rupees.
For arguing, he is taking stray sentences.
Can it be referred to mediation?
Certain.
No, lordship, 1 crore 38 lakhs he has to pay.
Sorry?
1 crore 38 lakhs he has to pay.
Mediation. Can it be referred to
No,
mediation?
let them deposit,
So what exactly-
show his bona fides to pay, depositing 50.
What exactly transpired, we just can't gather from the evidence.
Yes, no, my lordship, he has not at all adduced evidence at all.
I have
He has not opposed the evidence of the plaintiff. He has not refused the,
What he says is there is nothing to oppose, the evidence is in his favor. That's what he says. You yourself say in the cross-examination that has been reduced to 30,000.
reduced to 30,000.
Reduced by.
reduced by 30,000 out of the total, the rent and as well as the license fee. That was the observation of the Honorable Trial Court, my lords. You cannot take that one stray sentence to get out from his liability.
Well, even if the evidence is called for and exhibit P1 is seen, this court will have no faith in this, in the trial court's judgment. There is no material at all. It is his own self-prepared statement, whereas the evidence is like this.
He has also reporting that he has not produced any document to show that he has paid entire rents till the vacation of the.
Probably this examination chief and cross-examination, at least cross-examination has taken place in Kannada.
No. It's in English. This is not a translation.
No, court might have recorded in English.
Yes. No, he answered. I cross-examined him. He answered in English. There was no attempt to mislead or confuse.
Was it two or by?
Because
It was two. It is two because it is my case in my written statement also that
he
it
is
was reduced.
interpreting like that. That interpretation is not correct.
It is in my case in my written statement also that it was reduced to, not reduced by. He only supported my case in written statement. Therefore, I had no reason to lead evidence of my own.
No, my lords, the evidence is to be read as entirety to understand what was the case of the plaintiff and what was the case of the defendant.
May I put it
In
this way?
entirety, it has to be looked into.
Let the records be called for within a week or 10 days. If the evidence shows that I am due to pay, I will withdraw this appeal. The evidence on a plain reading will demonstrate that there is nothing payable.
Did the matter be sent to mediation? Just try to find out whether the matter can be settled.
No, my lords, earlier proceedings also attempts have been made.
Otherwise, it is speculation based on rules of evidence, that's all. Speculation based on rules of evidence, nothing beyond this. Mediation, try madi.
No, my lords, earlier also attempts have been made. It was failed. We don't want to pay even single pay to the plaintiff towards the
Call for
rent.
records in 2
Call for
weeks, my
records.
lord, either this way or that way we will
Call
be
for
done with it.
records. Call for records.
But he has filed execution. In the meantime, no escalation in the execution.
You have to deposit the amount.
Lord, let the matter come within 2 weeks.
Call for records, nothing beyond that. If you want the stay order, you have to deposit them,
Some portion of that, my lord, I don't know.
50%.
That's a bit too much. 1 crore 30 along with interest. When I have nothing to pay, 50 lakhs to go out of pocket at this stage and I'm not even in possession of the premises. It is not for me to bargain, but a lesser percentage. 0 is payable.
Deposit 30%.
I know that. Great.
The defendant appellant is heard the learned senior counsel for the appellant as well as the respondent. The defendant appellant is in appeal against a decree granting recovery of arrears of rent. The defendant appellant would submit that he is not in arrears and he has paid the admitted rent of rupees 30,000 per month, which is admitted in as admitted in the cross-examination. Learned counsel for the respondent would submit that amount, rental amount admitted is rupees 2 lakhs per month.
No, my lords, 3,10,000 per month.
3,10,000 per month as averred in the, as recited in the lease agreement.
Lease agreement and as well as a license agreement.
Considering the submission made before this court, this court to the view that the operation and execution of the impugned judgment and decree is to be stayed, subject to appellant depositing 30% of the decretal amount.
50%.
Within 8 weeks.
Usually 50% will be.
8 weeks.
But I may be permitted to file paper book. Date may be fixed. It's a very, very short issue. Date may be fixed sometime.
The call for records estimated, we are not yet admitted the appeal.
Great.
38, Vijay Kumar ke.
Settle agutta nodi. If possible, settle agutta nodi.
ಅಲ್ಲ ಅಮೌಂಟ್ ಕೊಟ್ಟ ಸ್ವಲ್ಪ ಕನ್ಸೆಷನ್ ಕೊಡ್ಬೋದು. ಅಮೌಂಟ್ ಒಂದು ಪೈಸಾ ನಾವು ನಾವೇ ಇನ್ನೂ ಕೊಡ್ಬೇಕಂತ ಹೇಳ್ತಿದಾರೆ ಅವರು.
Defendants appeal, my lord. Suit for specific performance before the learned trial court. Suit for specific performance, my lord.
Decreed.
Decreed.
Will let evidence?
Let evidence, my lord.
What is your defense now?
My lords, two main grounds, my lords. Main defense is, my lords, plaintiff failed to prove his readiness and willingness before the court. And my lords, another ground, my lords, he has no financial capacity to enter into this kind of huge amount as a sale consideration in the agreement.
What is the amount agreed?
65 lakhs, my lords. He claims that, my lords, 25 lakhs is paid to the bank and remaining amount nearly
35 lakhs.
35 lakhs was paid in by way
Requires
of cash.
consideration. Requires consideration.
Pardon,
Requires consideration.
but may only out of 65 lakhs, Lord, 60 lakhs was paid. What was balance was only 5 lakhs. Question of ready and willingness may not arise for the reason that it is a vague denial on the part of the defendant regarding, it is a registered agreement of sale.
Only call for records, we will not admit them.
Yes.
Call for records.
Please, my lords.
Till then, don't execute the.
We are not yet filed execution petition.
The for the respondent would submit that execution petition is not yet filed.
Please,
Such petition is filed, the appellant is at liberty to move the court seeking interim order.
please, highly object.
39. Kanchan Jain.
I appear for the respondent gave it on.
Defendant's appeal, my lord, suit for specific performance. It was decreed. My lord, this is a case, my lord, wherein your lordship, my lord, had suggested. There was novation of contract. It was my defense, stating that there was a new memorandum of understanding, exhibit D1, which was executed subsequent during the pendency of the said suit, wherein the a new sale consideration amount of 70 lakh was agreed between the parties. And accordingly, 30 lakh rupees was paid back to the plaintiffs, was received by the plaintiffs, which was admitted during the course of cross-examination. And rupees 40 lakh was remaining to be paid. Rupees 40 lakh was paid by way of, for which the checks were given, 3 checks were given, which came to be dishonored. My lord, my specific submission was, my lord, it was not, since they had not even, since a new contract was placed in, came into force, the earlier agreement could not have been given to a specific performance execution. Further, my lord, since there was no prayer for refund, the defendants were not entitled to repay any advance money also. However, my lordship had suggested that 40 lakh if you return, as because it is your only defense as per exhibit D1, you can come to a terms of agreement. I sought instruction from the client. Is ready to deposit 40 lakh and cancel.
Let them deposit that amount and the records may be called for. Then the matter may be heard.
Once he deposits the amount, probably you have no case. Probably, because.
No, but the thing is, the trial court has come to the conclusion.
It is like this. You have agreed to receive 70 lakhs, giving up your claim for specific performance.
Yes.
He paid 30 lakhs, you received it. For balance 40 lakhs, check was issued, check dishonored, you prosecuted him.
Yes.
So you had no intention to go for specific performance. Logically speaking.
Yes.
Deposit the amount.
Let him deposit
Record
and
your
I will take instructions from my client.
Record your statement that you are going to deposit balance 40 lakhs.
Till then, the execution operation of the judgment and decree may be.
You have to
No, no.
deposit the amount.
I will deposit, subject to the.
Learned
This
consequence.
amount is outstanding from 2012. Oh,
They
where
have
should we go?
instituted parallel proceedings,
You
my
cannot
lord, and
simply deposit
they have
and
barred-
get away
For
from
the
that.
appellant on instruction would submit that the appellant is ready to deposit balance amount of rupees 40 lakhs out of the amount of rupees 70 lakhs, which is agreed to be paid to the plaintiff, alva?
And as per exhibit D1,
As per exhibit D1, full stop. 3 weeks time is granted to
4
deposit.
weeks, 4 weeks.
4 weeks time is granted to deposit the amount.
Meanwhile, the operation of, I have sought for an operation.
You have filed execution?
I have filed execution.
Till then, the execution proceeding filed by the plaintiff shall not be proceeded further. Till then, 4 weeks.
For 4 weeks, yes.
Any date maybe.
4 weeks of the date. Who is R4?
R4 is a subsequent purchaser, my lord. He claims through a.
Issue
He has
emergent
already
notice.
dealt with the properties in favor of so many people.
Emergent notice to R4.
Yes.
Great.
40.
Waiting for the respondent, my lord, seeking a short accommodation of 2 weeks to file our objections. Twice they've sought time. This This is the second time that we're asking for an accommodation, my lord. It would just be granted for 2 weeks.
The third time actually, twice they've taken time. But anyway, if he undertakes that he's not going to file any execution, then time may be granted.
What is the implication of the impugned order?
The lessee's proceedings, the lessor filed the arbitration on a non-registered, unregistered, unstamped instrument. Ignoring the fact that it's unregistered, unstamped, the award is to give the lock-in period payment, which is unheard of in law. So I challenged under 34, but 34 court says being an arbitration award, we are not interfering.
He has filed execution now?
No, madam.
Not
There
yet.
is no execution that has been.
He's not filed, but last time he gave an undertaking, let him extend that undertaking.
Learned counsel for the respondent
Let me
seeks
take
short
note.
accommodation to file statement of objection. Full stop. The undertaking given by the learned counsel for the respondent that he will not precipitate the matter is taken on, is extended till next date.
Much obliged.
Date name.
2
Date.
weeks is,
5th August.
Right.
much obliged.
41. Gurracha.
Please, your lord. Lord, defendant's appeal, my lord. Suit for specific performance.
Decreed.
Decreed, man.
What is your defense?
Our defense is that, my lord, the original agreement was dated, my lord, 1/6/2007. On 5/4/2000, 1/6/2007.
Seven.
On 5/4/2010, one more agreement, my lord, supplementary agreement, my lord, alleged supplementary agreement came to be executed. We have disputed. One of the defendant has not signed.
Third, learned senior counsel appearing for the appellant. Admit, call for records. Execution file ಆಗಿದೆಯಾ?
My lord, no. 3 months, my lord, there is a.
Learned senior counsel would submit that agreement for sale is dated 1/6/2007. And it is further stated that the plaintiff claims that one more agreement was executed on 5/4/2010. Learned senior counsel would submit that one of the
And ready and willingness is
one of the
also.
defendants has not signed the agreement and the remaining defendants have disputed the alleged second agreement dated 5/4/2010. As such, would contend that the suit is barred by limitation.
And ready and willingness is
Stating
not.
the submission made, the operation and execution of the judgment and decree under appeal is stayed till next date. Emergent notice. Call for records.
42. Samir Sharma.
Appearing for the appellant, challenging an order by virtue of which my plaint was rejected on 2 principal grounds. One is on the ground of lack of cause of action. The second is limitation. I had initially entered into an agreement to sell on 18/1/2017. I'll just pass on the document. Documents relied upon in the plaint. Initially, I had entered into an agreement to sell.
Suit for
It's a
specific
suit for specific performance, alternatively for recovery of amounts.
agreement dated.
The original agreement to sell that I had entered into is dated 18/1/2017. However, admittedly, as per clause 4 and 5 of the agreement, there is no date that is fixed for its execution. Therefore, my humble submission is under
Date
Article
of refusal, date of refusal.
Date of refusal. Now, that date of refusal comes in 2022 when I issue a legal notice. They respond saying that we don't abide by this. Pursuant thereto, I file the suit. Therefore, it's a mixed question
How
of,
the trial court says it is barred by limitation.
your lordship may kindly take the operative portion at page 42 of the appeal papers. Page 42. Your lordship may see in the middle of the paragraph, on going through the entire plaintiff governments, it is not in dispute that the agreement of sale was executed on so and so in favor of the plaintiff by defendant number 1. Defendant number 1 also executed a registered sale deed dated so and so in favor of the defendant number 2. Plaintiff has signed as a consenting witness to the sale deed. On the date of registered sale deed dated so and so, the agreement of sale dated so and so stands cancelled. It is not in dispute that the defendant has executed an MOU dated so and so in favor of the plaintiff by agreeing to repay the amount of 5 crore in favor of the
This
plaintiff.
property is already sold now.
Property was sold by respondent number 2 in favor of respondent number 3 by virtue of a sale deed.
You are a consenting witness.
I was a consenting witness insofar as a sale deed between respondent number 1 and respondent number 2 is concerned. Now,
But
with
in
regard
usage
to
of the same property.
with respect to the same scheduled property, now my submission with respect to the fact that I'm a consenting witness is it was taken under coercion, although your lordship may think it is a run of the mill claim. However, immediately 3 days after that sale deed is entered into, An MOU is entered into in my favor, wherein respondent number 2 says that I will repay your 5 crore to you.
So
So
your claim has to be for recovery.
That is an alternative claim. Now, what the trial court does is, in my respectful submission, what the trial court,
You can't claim both things.
in my respectful
Being
submission,
consented for the sale and having agreed to receive 5 crore. So you
that
can't claim
5
a-
crore was never paid to me.
No, you file a suit for recovery of money. There's a difference.
In fact, if your lordship were to see, I have said either claim for specific performance insofar as my original,
Alternative prayer is in time.
please, everything is in time. And in my respectful submission is, insofar as limitation is concerned, mixed question of fact and law under Article 54, the second limb of it, and in
19 to 2018 is the agreement,
Please.
second agreement. So suit filed within 3 years.
suit was filed in 2022 because I issue a notice in
Date.
suit, filing of the suit, your lordship, on 8/5/2022.
Under the agreement dated 19 to 2018, what is the date fixed for payment?
There is no date fixed for payment. There's no
No
date,
date fixed.
no date fixed, admittedly. In my respectful submission, I've also sought for an interim relief.
The property is already sold.
Property is sold, let them at least maintain status quo as on date.
Who? Purchaser.
Respondent number 3, purchaser.
No. You are a consenting party to that sale deed.
I have disputed that
Yes.
because it was taken under my coercion.
Issue notice.
If until the next date of
If it is
hearing,
under coercion, why would you agree for payment of rupees 5 crore?
sorry, your lordship,
If it is under coercion,
please.
why would you agree after 2 days for payment of rupees 5 crore?
After 3 days, the respondent number 2 admits to the fact that this has happened.
This
And
de- No, this defense of coercion undue
I
influence.
understand.
These are the stories of 1940s and 50s.
Time
where
as
most
old
of
as
the
time.
Indians were illiterates.
I understand. Only submission is status quo may be maintained. That is my only humble submission.
Notice.
In that case, if a date may be fixed. Because,
Saru Abakal.
sorry, your lordship,
Notice has to be served.
I'll,
Issue emergent notice.
Please.
Once it is served, you move the court.
I understand, please.
Hearing on IA, number 43 adjourned, number 44, Abhinav Ramana.
Sorry, my lords, serial number 43, I was being waiting, lords. In the meantime, my lords, the last date of occasion, the notice has been dispensed for respondent number 5. In fact, my lords, the entire scenario, the suit revolves around defendant number, respondent number 5, serial number 43, your lordships.
It is adjourned.
I
Somebody-
understand, my lords. Kindly, my lords, any date may be fixed, my lords.
5/8, date quoted. 44,
R1 and 2.
This IA has been disposed of by order dated 26/3/2024. So it may not survive me. 26/3, please see the order dated
Suit
26.
for possession.
My lord, suit is for declaration possession. I claim possession based on a sale deed. The defendants say they are agreement holders of my vendor. My vendor sells the property without disclosing the agreement.
You have filed suit for specific performance.
No, they have not filed. Suit is now dismissed, saying that you have suppressed the agreement to sell. And therefore, my lord, suit for possession, declaration possession is now dismissed. That is all the point, my lord. How he can resist, my lord, as an agreement holder, my suit for declaration and possession.
Oh, agreement holder is in possession.
Yes, agreement holder is in
Pursuant to
possession.
agreement.
Yes,
You can't dispute his title because he has purchased the property from the same vendor
yes.
under whom you have entered into contract for sale.
That is all, that is the point, my lord.
Will seek instructions.
All for records.
ಅಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗಿದೆ
ಆಗಿದೆ. Records ಬರ್ಬೇಕು.
ಪೇಪರ್ ಬುಕ್ ಹಾಕಾಯ್ತು ಸಮ್ ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ my lord. That is all, that is the point. That is all, that is the point. I already filed paper book.
12th August.
Both of them are living under the same person, one has executed the same deed.
Great.
Forty-five, Raghu MP.
Happy for respond number 2 to 4, my lords. Lords, in the IA, they have stated that there is a delay of 506 days, my lords. But that's not correct, because, my lords, the decree was passed on 28/7/2018, my lords.
8/7/18.
Please. And my lords, they have applied for the copy on 16/3/21. It was delivered on 22/3/21, and they have filed it in the year 22, my lords, 11/2/2022. If my lord sees IA's para 3, my lords, it has the dates. Para 3 of the IA for condemnation of
Date
delay.
is According to you, how many days delay?
Lords, it will be around 5 years, 9 months, my lords, because it has to be taken from 18. After deducting 90 days, limitation starts, my lords. And what they have stated is COVID period, they are trying to exclude it. My lords, only if the limitation falls during that period, my lords, that can be exempted, not otherwise, my lords. And even there also, my lords, if it was expiring somewhere between that period, 90 days was.
It's very bit, after the COVID lockdown had started, probably. Could have been.
If it was falling during that period, my lords, it got extended and even 90 days extra would have been there for them to file. But here it's 2018 was the decree, my lords. So that calculation of 506 days is incorrect. If my lords is para 3 of the IA for continuation. Para 3. I state that the certified copy impugned order dated 28/7/2018 was applied on 16/3/2021 and the copy was delivered on 22/3/2021 and this appeal is filed on 11/2/2022, my lords. And appellant number 1 is an individual, appellant number 2 is a company, my lords. And there are also various cases against these appellants.
Now, registered sale deed has been declared null and void.
Please.
How?
My lords, the defendant number 1 and 2 had taken a GPA from the plaintiffs, my lords. And under the unregistered GPA, they have entered defendant number 1, husband, sales one item to the wife, defendant number 2. And later on, my lords, both sell it to the present appellants, my lords. And even the consideration, whatever the amount it was paid, even that is bounced, check bounce. This calculation of 506 days.
Appellant is not here.
Is any
None appears for the appellant. This is
any shorter date, my lords?
one.
Any date?
Suresh or Budhya?
22 days. Very nice.
For appellant, your lordship. I'm just seeing my seniors, so, your lordship, on the previous occasion.
My lord's permission, my lord. With my lord's permission, my lord, may I seek my lord's indulgence, my lord. My lords, we have not been, my lords, able to deposit, my lords, as we had undertaken. My lords, I'll not seek any indulgence of your lordships, my lord. All that I'll pray for, my lords, may kindly be pleased to give me a week's accommodation, my lords, because auction is fixed on Saturday, my lord. If at all you are able to, my lords, deposit, my lords, we'll come back before your lordships, my lord, and humbly pray for a prayer, my lords.
This matter to one.
Please.
47, Chandrana Karika.
Filed an application, my lord, for early hearing. The suit is for ejectment.
Can be granted early hearing.
Please.
Learned counsel for the
Maybe
appellant
for-
has no objection. to
After
grant-
August.
Grant early hearing sought by the respondent. Accordingly, I number 124 is allowed. This matter for final hearing on 19/8.
Interim order may be extended.
Remote.
48. Previous.
There's a delay of 156 days, my lord, in filing the appeal.
All are served.
All are served. Represented.
What is the reason?
But,
For partition.
suit for partition. Suit for partition is partly decreed. My request, my lord, for mean profits, my lord, is rejected by the learned trial judge.
Plaintiff's appeal.
Plaintiff's appeal. It is an issue, my lord, to be considered in the final decree proceedings. Lord, one third share, my lord, was originally sought by the plaintiffs. Later, my lord, it was reduced to 1/8 share. And there was admission by the defendants also to that effect. I had filed a memo, my lord, under Order 12 Rule 6 to decree the suit on the basis of the admission. My lord, without evidence, my lord, the matter was disposed of. But while writing the judgment, my lord, the learned judge says there is no evidence, so there is no evidence for mean profits. It is rejected. That is to be an issue, my lord, considered before the at the time of final decree proceedings.
Notice is already served.
Yes, my lord, they have not appeared.
There is a delay of 156 days in filing the appeal. Application is filed to condone the delay. The appeal is filed challenging the decree, refusing the mean profits. Notice is served on the respondents and there is no appearance. Noticing the cost shown in the affidavit accompanying application for condonation of delay. delay of 156 days in filing the appeal is condoned. I number 1 of 24 is allowed. Issue notice to the respondents.
Allah, the,
It's only on application for condonation of delay.
along with main my lord I had sent and FDP is also filed. But the only point, my lord, is that the matter to
May not be, technically it becomes issue notice. Admit not bad, only this point. We will not admit the appeal, notice,
emergent notice.
emergent.
And I may be permitted to serve, my lord, the counsel who is appearing before the FDP proceedings.
In addition, learned counsel
In addition to
appellant
that.
is also permitted to show the copy of the appeal memo
Appeal memo.
to the counsel appearing for the respondents of this appeal.
Obliged. One more request, madam, I'm sorry. There is a previous order by this honorable court. I had made an first respondent, my lord, had died and I had filed a memo. Lord, kindly take, my lord, the order dated 22/2/2024.
It's already recorded.
Allia, there is a small error, my lord, with great respect. I had filed a memo stating that the appellants as well as the respondents 1 to 7 are the LRs of deceased respondent number 1. Inadvertence, my lord, it appears only 2 to 7 are the LRs anta agogide ashte. And the appellants anta ಸೇರಿಸಬೇಕಷ್ಟೆ.
Learned counsel for the appellant submits that respondent number 1 is dead. And this is further submission that due to inadvertence, respondent number 2 to 7 are stated to be the legal representative of deceased respondent number 1. He further submits that even the appellants are the legal
Legal
persons of deceased respondent number 1. Submission is placed on record. Appellant to carry out necessary amendment.
Carry out
in the
amendment.
court.
Obliged.
49 urgent, 50.
But the amount I was expecting. My lord, I couldn't make the deposit as I promised because the amount that was expected from the KADB has not been released since April, my lord. I have to get about 1 crore in this. Since April, it is being delayed, my lord. Anytime it may be released in my favor. I'll make the deposits, my lord, as soon as I get the amount. This is the notice, my lord. I have to get about 1 crore, my lord. And anytime it may be released, once I get that amount, I'll deposit.
What is that?
This is the notice from KADB where I'm entitled for 1 lakh, 1 crore, my lord. Anytime it has to be released. My lord. I'll deposit. It's my father's money.
Have you seen that?
Please, I'll give, my lord. 3 crore is due, out of which I'm entitled to 1 crore.
Family property.
It has been acquired and anytime the money has to be released, my lord. 3 crore is the amount that is to be released, out of which I'm entitled for 1 crore. I'll deposit 87 lakhs in this court. In fact, day before yesterday, they promised anytime it has to come to my hand.
Increase for ejectment. It's an industrial equipment, 15 days notice.
At the admission stage, that can be looked into.
Company is not.
It is working.
The missionaries are getting deteriorated. And they are not even using the missionaries. Should I not get?
Machinery belongs to who? Appellant?
It's both, my lord. His machineries as well as my machineries are there.
Both I have given.
If you are not.
My machineries are also there, my lord. And
Which are your machineries?
many, I think about 2 to 3 crores worth machineries are there, my lord. It's running machine.
He's not
In fact,
coming
I've
in
taken.
he's not coming in the way.
In fact, I'm taking loan, my lord, for
Sorry?
running this. For purchases machineries, I've taken loan, my lord.
Understood. He's not coming in the way for you to lift the machineries.
No, but
You can take your machineries.
But my lord, there is a counterclaim of 70 lakhs which needs to be decided in this appeal. That has not been decided by the trial court.
No, that can be decided even if you vacate the premises.
My lord, I'll deposit the amount, my lord. It can be heard on merit, my
So
lord.
you are not challenging the decree for eviction, right? You're
Yes,
only,
my lord.
your claim
Even
is relating to the.
The notice itself is not valid, my lord. In fact, The notice was issued asking me to deposit 1.6 lakhs, out of which the trial court has held that it is only 21 lakhs that is due as on the date of the notice, my lord.
On quantum,
Please,
there is no
madam.
difficulty in hearing your case, hearing your appeal. For eviction, you are not questioning that decree for eviction.
When the eviction, my lord, the notice itself, the termination itself is not proper, my lord. The termination of, this court held that 15 days duration was enough for terminating the, but that is not the issue. The issue is the notice is under section 111G, my lord.
If you recollect, last time you said that you are only on the quantum or the counterclaim.
Two issues, my lord. Two issues, my lord. One is my counterclaim needs to be settled. The other is notice is under section
This
111G.
contention did not raise.
But in my appeal, I have raised, my lord.
No, no,
In my appeal, I have
Maybe
raised.
in appeal it is there. but
True,
the
my
court
lord.
posed the question, you said you are
But-
only concerned
No,
with the quantum.
in fact, I didn't make a mention about
In
this.
this context, you said that you are
But my main appeal, my appeal itself is for that, my lord.
but you made a statement.
Yes,
that
my
you-
lord.
you vacate the
I
premises.
understand, yes, my lord. But the appeal is under section 100. That is one of the ground I have taken in my appeal, my 111G is the one of the ground I have taken in my appeal, plus the counterclaim I have taken. The notice is not very clear on the amount that needs to be paid. Actually, as on the date of the notice, the trial court has held that I am only due 21 lakhs. As against that, 1.6 lakhs was demanded in the notice.
Counterclaim will hear no difficulty. But last time you made a statement that.
True,
you are
my
going
lord.
to
I
because
remember.
Defunct,
My lord, I agree with my lord, but this is one of the things which I missed on the last.
when you are expecting money,
Anytime it has to come, my lord. 6 weeks, my lord. In fact, I'd been trying on Friday, they said they'll be releasing the money, but till date, it has not been released. My lord, on the safer side, my lord, 6 lakh, 6.
and there are
weeks,
how
my lord.
many claimants for this?
Make up.
How many claimants?
No, there is no claimant. Your Honor, my lord could see on the river side. It's only me and my 2 brothers. Sangapandi and 2 brothers. There is no claimants in this. There is no other obstructor also. Only we have to collect the
How much you
money.
are required to deposit?
Make a one.
How much you are required?
Out of 3 crores, I am entitled to 1 crore, out of which 87 I need to
How
deposit.
much you are required to deposit?
87, man.
87 lakhs.
I'll deposit money. I'll deposit that money. 87 lakhs was the amount I agreed to deposit. I'll deposit 6 weeks, my lord. By then I'll get this amount. I'll deposit that.
In commercial court, they should deposit the amount and then contest. Is that the way how the commercial court manages?
No, in case, assuming that the interim order is not extended, probably you will be in a position to execute the decree and take back the possession. But what about amount? Again,
The amount.
no, again, you have to file one more application for attachment of some other properties belonging to him to recover the amount.
Please ask him to deliver the possession and take possession. For amount, not I will contest whatever.
My lord, I may be permitted 6 weeks, my lord. By then the money will come.
6
The
weeks to vacate.
appeal can be heard on merit. my
6 to vacate.
6 weeks to deposit the amount. I'll definitely get my amount. The appeal can be decided on the merit any day, my lord.
See, last time you made a different, you gave a different impression to the court.
No, in fact, I didn't make that 111G as a point to be
Yes, you
raised.
didn't raise
Yes,
that
my lord.
point.
That's my mistake. I agree, my lord. But that is one thing
Because
which
of
I
that,
missed.
we showed indulgence and granted time to
I'm
deposit
sorry,
the
my lord,
amount.
but,
Now again, you have come out with one more.
This amount
contention.
this amount will be released anytime, my lord. At 6 weeks, I'll deposit that amount. Merit, appeal can be considered on merit, my lord.
This was issued in on which date?
April, my lord. April,
Four.
2nd April.
Then
Anytime it has to be released, my lord.
what you have done thereafter?
I have been going to the office continuously, my lord. Every time I go there, the officer is not in the seat. He has gone, they say that he has gone to Vidhan Sabha. Some days they say he has gone to BMRCL to collect the money. So the officer is not in the seat continuously for a period of nearly 20 days, my lord. That is why I couldn't collect the amount. Otherwise, I would have collected the amount deposit. This time, my lord, 6 weeks time, my lord, I'll ensure that I get that money, I'll deposit here.
We'll grant you 2 weeks time.
My lord, 6 weeks, my lord.
Thereafter nothing.
The position there is very difficult, my lord.
All that, after 2 weeks, you can argue the matter on merits also. There is no need to press for interim prayer. Learn it once for the appellate.
My lord, 3 weeks, my lord.
2 weeks.
Let me just try, my lord.
Nothing has happened. This is in the month of April, they have issued the letter. Learned comes for the appellant submits that he needs another 4 weeks time to deposit the amount ordered by this court. Full stop. Learned comes for the respondent seriously opposes the motion for adjournment. Full stop. After considering the materials on record, this court is the view that 2 weeks time to be granted to the appellant to comply with the earlier order to deposit the amount. Full stop. It is further made clear that no further extension shall be granted to the appellant.
Otherwise, appeal can be heard. Yes, ma'am.
He cannot be heard until he deposits. It's a condition.
51,
Publish.
Chandranath Tariga.
Hearing for the respondents.
1 day delay.
Claims of the order.
1 day delay in filing the appeal, my lordship.
What is the reason?
Reason, my lordship, by mistake calculation of
So this is
Appeal
your fault,
period.
not the fault of the appellant. You thought there is still time to file appeal.
Delay may be condoned.
Delay is condoned.
kindly have 10 day after tomorrow for admission, my lordship.
Suit for
Suit for declaration and possession.
possession.
Permanent
Be
injunction.
dismissed and counter claim for adverse possession is allowed. Trial court denied the title of the plaintiff and adverse possession is allowed.
So you are not in possession.
I am in possession, my lordship. My contention is that I am in possession as per the compromise petition in the
Speak, next.
Supreme.
52 urgent, 53. Girish CS.
Here for respondent number 7. I require time to file the objections, my lord. I have informed the
Wait
appellant.
for the appellants only. This is a suit for partition which has been wrongly held at the trial court.
My lord,
It
sir.
is my father's property. 7 scheduled properties are there. I am the daughter and I am eligible for a share in that. Now, the
Suit
trial
is
court.
dismissed.
Suit is
Is
dismissed.
dismissed.
Father is alive.
He is no more.
Father is alive.
No, he is no more.
After the death of the father, you filed.
Yes, yes.
My lord,
When
sir.
he died,
Well, it's one request, my lords. There is subsequent developments, my lord. I'll place on record the documents. I require only 1 week time, my lords, to file the
I have a
objections.
submission, my lord. They are tampering with the schedule, shoot schedule property. They're putting up construction. There is an IA for stay. At least a status quo may be granted. No.
No, my lord, sir. I already informed them that I'll file the objections.
Status quo may be granted.
no, suit is dismissed because the court holds that there was one more compromise. There was a
But
decree.
I was not a party to the compromise.
You're not a
petition.
party.
I was not a party to it. And there is also one document which they have said,
No, when the compromise took place, father was alive.
father was not alive.
Not
Was not alive.
My lords, I request pass over at least 2 days time, my lords. I've already informed them at the morning that
Yeah,
I've
inform me
taken
that
until.
he'll be coming, that's all.
What is he doing? Putting up a structure.
Putting up a construction. He's changing nature of the land, my lord.
What is the extent of land?
Total 7 scheduled properties are there.
7?
Scheduled properties are there.
Extent, total extent. Huh? Total extent you are asking.
Total extent.
Lords, this is in a nature of partial partition and there is recordings in the.
Now, what
That's a-
construction is putting up? What construction?
He is putting up some construction.
Now being into PBAP areas. Now they are putting up pillars in the properties.
We don't know what nature.
Who is putting up?
The dependent.
Different number 1.
5 to 10 or respondent 5 to 10. I represent dependent,
Now, what kind of construction is coming up?
not they are putting up.
Pillars.
Multi-story apartments.
Apartment. Pillars have come
It's a
up.
development.
Yes, sir.
If you
It's a-
succeed, you will also get share in it.
But my submission is not as far as female is concerned, not I was the defendant number 1 to 5, I was going with the plaintiff. I considered there was absolutely no partition as far as this 1 to 7.
No, understood. If the construction should come up during the pendency of this appeal, and if the suit is decreed, you will also get share in some of the constructed.
That is not that is not the intention, my lord. That is not what we want. We want the land as it stands, not with construction.
Lords,
It
I
should be
require
left to
only
the
2 days, my
to
lords.
decide how to use. the
Construction has already commenced.
No, it is an illegal construction. We just started
When
recently.
Week back.
They just come up with it. They cannot change the nature of the land and give me what they feel.
But 2 things were not, one day the land is not converted.
And it
Since
is,
the matter comes up, the jurisdiction comes up with the BBM. That was one of the issues for us. There was a supplement proceeding before BBM and after. But Strata was not transferred. All those things.
when were you served with the copy of this application?
almost, when the appeal was filed, he was on table.
But my lords, there is subsequent developments, my lord. I'll place in all the records and we'll submit, my lords. Only 2 days, my lords. I request only 2 days.
What is subsequent development?
They
Construction.
have, they have entered into agreement, my lords, that I'll place in records. That
Who has
another,
entered into- Who has entered into the agreement?
the appellant,
Respondent.
Appellant.
Respondent.
my lords,
Who
I,
have-
I-
I'll
I
seek it.
apologize.
I will seek instructions.
I
I
apologize,
deny it
Lord.
and I seek instructions. I'll
Yes.
take instructions.
There is no complete instructions towards me
This,
also.
Monday.
Monday, yes.
much obliged,
Not on
much obliged. Status quo till then.
Monday, Burley. He
Monday.
says that you have entered into an agreement.
I seek instruction, but the status quo till then, my lord.
Not be done, my lord. The submission is one of the respondent appears to have entered. That cannot be true because I have entered. I'm giving Makara, my lord, I'm be filing it in the office. I was, my name may be also.
Your name is not shown.
Respondent.
Register.
Vasant Madhav is representing.
You are going to appear on behalf of
Yes.
rest of the respondents.
Respondent 1 to 5.
Learned Counsel, undertakes to appear on behalf of respondent number 1 to 5. You are supporting the appellant.
Yes. The trial court.
What about others?
They are entered KV.
6,
6 to 10 are in.
Give it,
the
huh?
lordships,
6 to 10.
Seven
give it.
other are family members.
Learned Counsel for the cavator undertakes to file wakalat on behalf of respondent number 7 to 10. Cavator,
Okay,
7 to 10. Let it come on Monday.
Much obliged.
please, publish.
Store matter, number 9. Rajadasi.
This case I
Appear
appear
for
for the
respondent.
appellant's counsel, my lord. For the proposition of law which was been canvassed, my lord, the trial judge may be right, but in view of the subsequent fact, my lord, admittedly, my lord, my father had a right to seek for a declaration and partition, my lord. Now, my father is no more. So the right to sue, my lord, as far as the children are concerned, my lord, it will survive.
Where is genealogy?
Genealogy, my lord, if your
Right.
lordship may kindly see, my lord, the appellant, my lord, is the appellant 1 and 2 are the sons of the first defendant.
He has not disputed. But that's mother's property.
Property belong to Saraswati.
Saraswati.
Yes.
Mother. And during the, she has executed a will and thereafter
No,
his,
no,
her
yes,
defendant
no.
number 1 have executed
Yes,
a
yes.
release deed.
Just second.
That is not
Just
disputed.
second. When
Yes.
Saraswati died?
1997.
Don't-
She has got
That-
one son and one daughter.
But she died on 1997,
Yes.
11/2/1997.
All right. One son and one daughter.
One son and one daughter.
Ah.
And my lord, the son have executed a release deed. That is also admitted
In favor of?
in favor of the second defendant. The first defendant have executed release deed in favor of second defendant.
Agbedu sir, genealogy and everybody. See, Saraswati died in 97. He is survived by Balasubramaniam.
Bal Subramaniam and
Janaki.
Lord, the
Second defendant.
second
Janaki.
defendant.
Janaki.
Yes, my lord. Janaki
So
Natarajan.
one son and one daughter.
One son and one daughter.
Son executes a release deed in favor
Yeah,
of
release deed in favor of second defendant. That is Janaki. Janaki.
Janaki. also.
Janaki.
Ah,
The
Sons of-
plaintiffs are the sons of
yes.
the first defendant.
All right. Now
The
who died? Now
dependency-
Who died? Who died?
Our father, my lord, first defendant.
Ah.
So first defendant,
When he
yes,
executed the release deed?
2007, my lord.
2007.
Yes.
He has not
No,
disputed.
that is
first-
disputed, my lord. That the children dispute, my lord.
Children are disputing during
yes.
his lifetime, he has
No,
never done.
now, see, under order 7, now, my lord, my suit, my lord, came to be dismissed on the ground, my lord, on the question of law, my lord. Order 7, Rule 11, DL. Now, what the court says this, during the lifetime of the father, my lord, I could not, children could not have filed this suit.
Correct.
Now my father died, my lord.
When?
He died during the pendence of the suit itself, my lord. That was not brought to the notice. He died during the pendence of the suit. So whatever, my lord, he had a right, my lord.
He had, just second. He
Yes.
had a right to question the.
Yes,
just
gift
second.
deed as well as the,
Just second.
Yes.
He had a right to question the relinquishment deed.
yes,
Within 3 years from the date of execution of the deed.
Yes,
It was executed in 2007.
yes,
He died during the pendency of the suit. That is, after 2016.
yes,
Within 3 years, he has not questioned it.
it is not question,
By
but,
Just a second. By the time he died, right to sue or right to question the release deed had expired. So you
But
have not
that-
inherited that right.
no, but that was not the ground, my lord, taken by them. That was not at all the ground. Under order, what they say is there is a will in their favor. So when there is a will, my lord, property belongs to the mother. On that ground, my lord, the trial judge, or the application was filed.
Let us assume
Yes,
mother's will is not proved.
yes,
Then also the
Yes.
property would devolve upon Balasubramaniam and Janaki,
yes,
even in the absence of will.
yes, yes.
And he executed a relinquishment deed.
That is that children, my lord, now we dispute.
He did not question it during his lifetime.
Yeah, he did not question.
So by the time he died,
Yes,
his right to question it had expired because of law of limitation.
maybe,
So the
but
children,
yes.
so the children did not inherit the right to sue.
But that is not the ground taken, my lord. That is, your lordship may kindly see order 7 rule 11, application filed by them, my lord. Lordship, what they say is, our mother had executed a will. There is also a gift deed. So on that ground, my lord, property belongs to us. It is an absolute property. We have no right.
Correct.
No, that is a
No,
good, that's,
With will, without will, the same would be.
no, that's a question of trial, my lord. My suit cannot be dismissed at the threshold, my lord. Kindly see my plaint. Your lordship may kindly see the plaint, my lord. That cannot
Sir,
be a ground, my
no
lord.
locus to file a suit.
At that,
that means-
at the relevant point of
That
time.
means you had no
Yes.
cause of action to file a suit.
Yes, I should have a cause of action. Without cause of action, I can never file a suit, my lord.
You
But
might have
in
shown
the-
a cause of action, but not a cause of action in the eye of law.
No, but maybe, my lord, but that was not the point which was urged
That
by
is
the.
That is the point.
No, you kindly see the application. That's why, my lord, I would like to, I request your lordships kindly to go through the applications filed by them, my lord. What they say is, they don't say that we had no right at all. What they say is, there is a will. There is a gift deed. So you have no right to claim,
Now forget about their application.
yes.
You look into your plaint. It's order 7 rule.
But that would be a new case, my lord, set up. That would be a new case.
No, order 7 rule 11.
Yes.
Is only based on your averment in the plaint.
Yes, the trial court has to decide that point, my
No,
lord.
if the plaint averment says.
Yes,
the
that,
Just a second, the property belonged to your mother, sorry, grandmother Saraswati.
yes,
There ends the matter.
yes,
Because when the suit was filed,
yes.
son was alive, daughter was alive.
Yeah, yes. Now, in view of the death of the father, my lord, now father died, my lord. Father died during the pendency of the suit. He died, my lord. So the trial judge, what the trial judge says,
Father
understand?
is not the plaintiff.
He was not the plaintiff, he was the defendant. Yes,
Father is the plaintiff.
But-
Could have,
yes, but father had a right, my lord. Father had a right.
no, father had no right.
No, he could have challenged the gift deed.
Didn't challenge.
He didn't challenge. He did. That is another aspect. He didn't challenge. But the question is, my lord, whether these facts were pleaded. The trial judge has dismissed on a different footing, my lord. This is a,
Now
this,
go by your plaint government.
no,
plaint
yes,
government
that
would-
is there, man. That I can't dispute the plaint. Everything is in black and white, my lord. I can't. But the proposition,
Once you admit that Saraswati was the owner of the property.
yes,
And once you admit that when you filed the suit, your father was alive
yes.
and your aunt was alive, there ends the matter. You have no cause of action in the eye of law. to
At
file a-
at that point of time, I had no. Yes, that I admit, my, because the trial court, my lord, has exactly rejected my plaint on that ground only. But in,
That event, there is no scope for interference for us. No.
maybe, but in view of the subsequent fact, my lord, that
Absolutely no contention.
in view of the subsequent,
His ancestor.
this is pleading on injustice.
If you have got a separate cause of action on the premise that succession is opened after death of the father, you work out your remedy by filing a fresh suit if it is permissible.
No, that can be noted, my lord.
We won't say
Allah.
that you are entitled to file a
No,
suit.
legal,
Can-
no, on the question of law, otherwise, but I may be permitted to file a suit, my lord.
What we
Otherwise,
say is if there is a fresh cause of action, it is for you to work out your remedy. That's all. Because of the death. which is
yeah,
taken.
yes, my lord.
Blood
Because-
debt. As your lordship have rightly, pointed out, my lord, the release deed was dated 7/1/2015.
15.
And my lord, his father was alive till 2024. And my lord, till 24, he has not filed the suit. Now, my lord, once he has not, he's accused of his rights also,
Second.
because he was
Second.
placed ex parte here.
In the written statement, oh, was placed ex parte.
He was placed ex parte here. It was a collusive suit between them.
Father.
He was placed ex parte.
Father,
Defendant
not
was
you.
placed ex
You-
parte.
They
So,
No, we won't say that he is entitled to file a separate suit. We can only say that
like, if that much observation is given, my lord, definitely they will file, my lord, because, my lord, the learned trail judge have not even, my lord, Article 7 Rule 11D application, hakiradukku, and this, my lord, there is the learned trail judge have observed only the averments of the plaint and have rightly rejected the plaint. So therefore, my lord, as on the date of filing of the suit, there was no cause of action, therefore the suit was rejected. If that is sufficient, my lord, rest if they have got workout, my lord, without any observation, my lord, it flows, it goes without saying, my lord. If they have a cause of action, my lord, because otherwise also, in that case, I'll not be entitled to say, take here, the same contention.
whether we observe or not, he is going to file a suit.
Definitely. Even if it is not observed, it will be filed. There, if that observation comes here, I'll not be able to file Article 7 Rule 11D again there. Because that, my lord, he will always say,
We can say, if the appellant claims, because he has raised a contention now, we have to answer that. If the appellant claims that succession is opened again, then it is for him to establish. Yes,
it's for him to establish, but let there not be any observation in this suit.
not permit him, that's all. Will not, there is no express permission to be granted by this court.
Yes.
It's for him to work out.
Because he can't shut
Not
out
the learned counsel
on
appearing
both the
for
stages, my lord.
appellant and the respondent. Full stop.
No, may I just.
The
submit one
plaintiffs are
thing?
before this
Just
court.
Para 25 of the trial court judgment, my lord. Their claim was allowed only on the ground that I had no right, my lord. Section 15 was quoted, my lord. Court says, my lord, I had no right at all. The trial judge, in fact, maybe it was a mistake on our part. We should have brought to the notice the death of our father. Probably we didn't bring it. But the fact remains, my lord, he was dead at that point of time. So succession opens. So, my lord, a liberty may be granted to file a suit.
The plaintiff's invoice number 602 of 2016 on the file of first additional senior civil judge Nelamangala are before this court. Full stop. The suit for partition and separate possession by the plaintiffs is resisted by the defendants. The defendants file application under Order 7, Rule 11 of the Code of Civil Procedure to reject the plaint on the premise that the plaintiffs have no cause of action to file the suit. The trial court has accepted the contention of the defendants and has rejected the plaint. Full stop. Next para. The brief facts necessary for adjudication of the case can be summarized under. Saraswati was the proposed. She died in 1977.
1997.
97. She is survived by the son
Defendant
and
number one and
son and the daughter.
Son and a daughter.
First dependent is the son, second dependent is the daughter of late Saraswati. Full stop. The
Third defendant
suit is filed by the grandson of Saraswati through
Grandson and daughter.
grandson and granddaughter of Saraswati through her son Balasubramaniam. Full stop. The defendants contended that the property being the self-acquired property of Saraswati, after her demise, the son and the daughter of Saraswati acquired right over the property under the will executed by Saraswati. Full stop. Thus, it is their case that the property is the self-acquired property of the son and the daughter of Saraswati, and the plaintiffs, who are the grandchildren of Saraswati, do not acquire any right over the property during the lifetime of their father Balasubramaniam. Full stop. The trial court has also referred to Section 15 of the Hindu Succession Act and has concluded that the property being the self-acquired property of Saraswati, the grandson of Saraswati and grandchildren of Saraswati are not entitled to claim partition during the lifetime of their father. Full stop. In substance, the trial court has held that there is no cause of action.
Cause of action and not on cause of action.
In substance, the trial court has, in substance,
15 ಅಲ್ಲಿ.
in substance, the trial court has said that there is no cause of action, there is no right for the plaintiff to claim share in the properties. Full stop. Next part. Learned counsel appearing for the appellant would contend that an important factor, that is the death of the first defendant, the son of Saraswati, is not brought to the notice of the trial court. Full stop. It is his submission that he died during the pendency of the suit and succession would open after his death. Thus, the suit is maintainable. Full stop. Learned counsel for the respondent would contend that the Balasubramaniam has executed a registered relinquishment deed in favor of his sister in the year 2007.
So 7/1/2015.
15 alla?
15, as on 7/1/2015.
On
A
7/1,
gift deed dated 8/1/2007. First one gift deed dated 8/1/2007, and thereafter one release deed.
had executed a gift deed on 8/1/2007 in favor of his sister and one
No,
relinquishment.
Release deed on
By
7/1/2015.
the mother, my lord. Gift deed by the mother.
Will was by mother. Will was by mother.
Gift deed by whom?
Gift deed by the D1, defendant number 1.
No, I'm sorry, my lord. Gift deed is by defendant number 2 in favor of defendant number 3. Why should I execute a gift deed, my lord? I have the gift deed, copy of the gift deed.
Defendant number 2 yaru?
Daughter, two, grandmother.
Sister.
Howದು?
Gift deed by whom?
7/1/2015.
How the defendant number 2 has executed a gift deed in favor of defendant number 3. That
Correct.
is, she gives the property in
Alright.
favor of her daughter.
To her daughter, all right.
Yes.
Learned counsel for the respondent would contend that defendant number 2 has executed a registered gift deed in favor of her daughter, defendant number 3 in the year 2007. And the defendant number 1, the son of Saraswati, has executed a release deed in favor of defendant number 2
Asha Saraswati.
in the year 2015.
Yes.
Full stop.
Janaki.
Thus, he would contend that even though the defendant number 1 has died in the year 2024, by the time he died, he had lost the right to question the registered relinquishment deed of the year 2015. Stop. Thus, he would contend that the succession would not open in favor of the appellants in respect of the properties covered by the registered relinquishment deed. Stop. This court has considered the contentions raised at the bar. The following point arises for consideration. Whether the trial court is justified in holding that the plaintiff had no right over the suit property as on the date of the suit and is justified in rejecting the plaintiff. Stop. Admittedly, it is settled position of law that when it comes to rejection of plaint, the plaint averment is to be taken into consideration. On going through the plaint averment, it is very much evident that the plaintiffs have admitted that the property belonged to Saraswati, their grandmother. Full stop. Saraswati died in the year 1997. Full stop. It is the case of the defendants that Saraswati executed a will. The plaintiffs may not be admitting the execution of the will. However, the position of law does not change whether it is a case of testamentary succession or non-testamentary succession in respect of the assets of Saraswati. Even if it is a case of non-testamentary succession, her heirs would be defendant number 1, the son, and defendant number 2, the daughter. Defendant number 1 and defendant number 2 would inherit the property of Saraswati under section 15 in the absence of any testament executed by Saraswati. Full stop. Under section 15, the daughter and son would acquire the property absolutely. This being the position, the plaintiffs cannot claim a right in the property by reason of birth in the family when the father is still alive. Full stop. This being the position, this court is the view that there is no cause of action in the eye of law for the plaintiffs to file a suit for partition. Hence, this court does not find any error in the judgment of the trial court in rejecting the plaint on an application filed by the defendants. Full stop. Next para. However, it is to be noticed that defendant number 1 died in the year 2024. Full stop. The learned counsel for the plaintiff submits that the succession has opened in favor of the plaintiffs after the death of the father. As such, the suit is maintainable. Learned counsel for the respondent would submit that the release deed was executed by defendant number 1 in the year 2015 and he died in the year 2024. At the most, he could have questioned the release deed within 3 years from the date of execution. As such, he had lost the right to challenge the relinquishment deed. As such, the plaintiffs cannot question the relinquishment deed. Full stop. Since this is the development which has taken place during the pendency of the suit, this court is not going to express any opinion on the claim of the plaintiffs relating to succession being opened after the demise of the father of the plaintiffs. If any action is brought subsequent to the action is brought by the plaintiffs on account of death of defendant number one, it is for the court to take appropriate, it is for the court to pass appropriate orders in accordance with law. Appeal is dismissed.
Yes.
Much of-
Disposed on.
We'll dismiss that. Dispose that.
Death which 24 ಅಂತಂದ್ರಲ್ಲ ನೀವು?
ಹೌದು,
Which-
24.
Not 24 because appeal is of 23.
Appeal is of the year 23. Therefore, it must be 23.
21.
21.
21 ಅಲ್ಲಿ.
21. 21.
Court ಮಾಡಿಲ್ಲ. They have not reported to the court also.
Yes, ma'am, that was a mistake. I admit, my lord. I admit that was a mistake.
You have not reported also.
Brother, ಅವರಿಗೂ brother. Grateful.
Nineteen.
Section 8. Respondent has not been appearing. My lord is referring to a judgment of the Supreme Court in the morning.
It's Paradiwala.
This is Justice Pardiwala's order. Paragraph 98, 115. 98 is the relevant portion. It's at internal page 38 of the judgment. May I read with the permission, sir? What follows from the negative facet of arbitral autonomy when applied in the context of section 16 is that national courts are prohibited from interfering in matters pertaining to the jurisdiction of the arbitral tribunal, as exclusive jurisdiction on those aspects rests with the arbitral tribunal. The legislative mandate of prima facie determination at the stage of section 8 and 11 respectively ensures that referral courts do not end up venturing into what is intended by the legislature to be the exclusive domain of the arbitral tribunal. Similarly, my lords, specific to this facts 115 and 116 of this judgment itself. In the Supreme Court, the counterparty claimed that there was a voucher of accord and satisfaction. Here, I am disputing that there is any settlement. But even if the plaintiff's case is taken at best case, it is a matter before the arbitral tribunal. That's what comes from these two paragraphs. The dispute pertaining to the accord and satisfaction of claims is not one which attacks or questions the existence of the arbitration agreement in any way. As held by us in the preceding parts of the judgment, the arbitration agreement, being separate and independent from the underlying substantive contract in which it is contained, continues to remain in existence even after the original contract stands discharged by accord and satisfaction. The question of accord and satisfaction, being a mixed question of law and fact, comes within the exclusive jurisdiction of the arbitral tribunal, if not otherwise agreed upon between the parties. Thus, the negative effect of competence would require the matter falling within the exclusive domain of the arbitral tribunal should not be looked into by the referral court even for a prima facie determination before the arbitral tribunal first had the opportunity of looking at it.
No, in this case, the contention is taken in the written statement that the matter is settled.
My lords, I have not filed a written statement. I filed a section 8 application
That objection.
saying that there's an arbitration clause. In the objections, the plaintiff says the arbitration clause reads that the party shall aim to settle the matter amicably. If there is no amicable settlement, they should resolve dispute by arbitration. So he says there was amicable agreement, and now that difference is reneged from the submission. That is something that the arbitrator has to decide.
No, did they produce any document in support of that?
Nothing, my lords.
Any email exchange, nothing?
Nothing. There's no contract, nothing that has been executed. And my lords, 122. I may just read out 122 of this judgment as well. 121 says that when there is no agreement, plaintiff has a chance to go to the civil court. 122 starts. Once an arbitration agreement exists between the parties, then the option of approaching the civil court becomes unavailable to them. In such a scenario, if the parties seek to raise a dispute, they necessarily have to do so before the arbitral tribunal. The arbitral tribunal in turn can only be constituted as per the procedure agreed between the parties. The rest deals with section 11, may not be applicable to these proceedings. But in this case, the trial court has come to a categorical finding that it is not disputed that there exists a valid arbitration clause. The matter,
No, in this case, in case the appeal is allowed,
please, my lords.
your remedy is to, or
Yes, the plaintiff has to invoke
he has to move section 11.
section 21. He'll have to issue a notice of arbitration,
Correct. Then he has to appoint.
then come under section 11, please.
Third, the learned counsel appearing for the appellant. None appeared for the respondent. This matter was heard on, which was the last date?
15th, my lord, last Monday.
15th date, 15/7/2024. Awaiting appearance of the counsel for the respondent. The matter was listed today, full stop. Again, there is no appearance, full stop. Next para. This appeal is arising from the order passed under section 8, section 8, alwa? Section
Please,
8, under section 8 of the Arbitration and Conciliation Act 1996, full stop. The plaintiff had filed a suit for recovery, na?
For recovery of dues, my lords.
Recovery of dues, full stop. The defendant contested the claim by filing an application under section 8 to refer the matter to the arbitrator, full stop. To the said application, the respondent filed objection, full stop.
Please.
The respondent took a stand that the matter between the parties is settled, and as such, there is no arbitrable dispute between them, full stop. The trial court, after considering the materials on record, has concluded that the dispute between the parties is settled and rejected the application to refer the matter to the arbitrator, full stop. Next para. This learned counsel appearing for the appellant would submit that the dispute between, there is a valid arbitration agreement between the parties where the parties had agreed to resolve the dispute through arbitration in the event of any dispute arising between them, full stop. It is further submission that dispute is not settled as contended by the defendant, full stop. He would further submit that no document is placed before the court to show that the dispute is settled, full stop. Even in the statement of objection, the respondent would say that the respondent has agreed to settle the dispute after going through the accounts. Alwan, that's what she says.
The respondent said that the appellant has agreed to settle the accounts.
No, what they are saying is there is some difference of opinion in the accounts.
The respondent's plea is that plaintiff agreed to pay the money and then reneged. But if that email is seen, I have disputed the calculation itself that was given.
Is the trial court, after going through the statement of objection and after going through the arbitration clause, has concluded that the arbitration clause also provides for an amicable settlement of the dispute between the parties. And since the respondent has made a claim that the dispute is settled, the trial court has come to the conclusion that the matter cannot be referred to arbitration as there is no dispute to be referred to the arbitrator, full stop. Learned counsel appearing for the appellant would contend that the finding of the trial court is erroneous in as much as the dispute is not settled at all, full stop. It is his further submission, assuming that the matter is settled and some amount is agreed to be paid by one of the parties, by one party to the other. If that amount is not paid, again, the matter has to be resolved through the arbitration in view of the arbitration clause, full stop. Would also submit that the arbitration clause is not cancelled in terms of the alleged settlement.
Is undisputed by the plaintiff.
Alleged settlement urged by the respondent, full stop. Learned counsel would also refer to the latest judgment of the Honorable Apex Court in the case of SBI General Insurance Company versus Krish Spinning 2024 SCC Online SC 1754, full stop. This court has perused the said judgment, full stop. Admittedly, there is a valid arbitration clause between the appellant and the respondent, full stop. The respondent, though, claims that the dispute is settled, nothing is placed on record to show that the dispute is settled between the parties, full stop. Even if the dispute is agreed to be settled, and if it is not settled, the said dispute has to be resolved as per the terms of the arbitration agreement between the parties, full stop. Admittedly, the dispute is not yet adjudicated by the arbitrator, full stop. This court has also considered the judgment of the apex court referred to above. Full stop. In the said judgment, the apex court has held that even if the defense of accord and satisfaction is raised by one of the parties, and those parties are bound by the arbitration clause, and if that accord and satisfaction is disputed by the other party, the claim relating to accord and satisfaction has to be adjudicated by the arbitral tribunal. Full stop. Since the claim of the respondent that the matter is settled is seriously disputed by the appellant, this court is the view that the dispute is not yet settled, and the same has to be resolved through the mutually binding arbitration agreement. Under these circumstances, the impugned order is liable to be set aside and accordingly set aside. The Section 8 application is allowed, and it is for the respondent to seek arbitration in the manner known to law.
Suit may be dismissed, my lords, consequently.
Suit is dismissed. Consequently, the suit is dismissed.
I'm grateful, I'm obliged.
Serial number 58, interim order was not extended. I could not make that submission. I mistook the number.
Serial number 76, short date not in this matter, not as the
Oh, that was the last matter.
Cases of fraud,